Hello, 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 hello. So I've started early because I wanted to stream the um, verdict. So I decided to stream. Shannon, if you're here, thank you for the heads up. This is just the ice cream murder results. So I'm going to stream that and hopefully go straight into the Gwyneth Paltrow one. That's the that's the hope anyway. Ba 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 ba. Oh crap! Why do I have to keep pressing stuff? Mhm. Yeah, I'm gonna do this. Um, Predicts is in. And the ice cream is uh, ultra trial to follow. Ba, ba, ba. You see, it's nice to jump on early. Let's see the run. Put that on. Let's see if everything is live on my feed. Do, 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 do. Like that, like that. So again, for those who just joined, I'm just streaming the results, and then I'll go straight on to Gwyneth Paltrow trial. Then that starts about 50 minutes. Some people are interested in this, so if you are, that's why I did it. If you're not, hopefully come back in 50 minutes. Don't know what any of this means. Whether it's good news or bad news, or right, okay. They're just going to wait for lawyers and stuff now. That's all there is. They're not all actually there physically, so they've got to go fetch them and stuff like that. That makes no sense. Okay. Okay. Hey, Shannon, thank you very much. No worries. Oh, yeah, oh, you're watching the trial. Yeah, I'm not watching that because if I watch it, then that means I have to cover it. So, thanks for the heads up on this one, Shannon. This it starts at 4, so this is just for the sorry, 4 o'clock my time, so that's like 11 Eastern your time. I was ready, um, nothing to do. I slept well, thank you, Shannon, and had a great morning. Ah, okay, yeah, it's fine, fine. There's another trial. Oh crap, why is this doing that now? There's another trial that's happening, and open statements are happening now, so or will be. And I'm like, well, not get involved because of Sarah Boone. Um, so yeah, the Gwyneth Paltrow trial starts in 45 minutes, Stacey, and good morning to you as well. It's just I was bored. Shannon, Crime Spies posted that the results were in. Thank you for that. I jumped on, recorded it. Need to keep an eye on it so I can snip it. Looks like all the lawyers are in. I'm intrigued with the result. I haven't watched this, but I'm intrigued. I watched a little bit of it. I'm intrigued by the result of it. Morning, Stacey. Welcome back. Nice to see you again. So yeah, we've got plenty of time, guys, before Gwyneth Paltrow or those that are here for Gwyneth Paltrow think, what the fuck's this? Right. Hello as well to people on Rumble. Nice to see you. I know it would be nice to have a bit of ice cream, wouldn't it? Right there. That's running. That's running. Just gonna make sure everything's live. Got a bit earlier than I was supposed to be. Okay, he didn't test end yesterday purely because the defense didn't want him to. They had so many witnesses that were only available that day. So what they're going to do now, they're going to fit him in to whatever they can, whether it's Wednesday, Thursday. But the judge also said that they they got like something like 2.5 hours on Thursday to to do closing arguments. So it looks like probably Wednesday will be. But that's the reason they just literally run out of time. Yeah, Kane, if I'm being honest with you, there's nothing that's it's literally because it's a civil trial. I think they can, but everything about this trial is odd. They all get equal time, and he was literally just because. So the defense had 7 witnesses. They were only able to put on 3. And the rest are now going to be read in depositions rather than actually having them like the daughters and the children of Gwyneth Paltrow testify. So they literally just ran out of time, and the judge allowed it. That's best part. I hope that's what I said, but yeah, that's basically it. Yeah, they're only there for the day. And I say Apple and Moses and all them, they won't testify now. Do you think? I didn't see that to be quite honest. I thought he was a great witness, but I didn't personally see that he benefited Terry. But this is the beauty of it. We all interpret and take different things from it. So yeah, if you can, write how you saw that. I'm intrigued. And so when they are doing the results, I'm not going to talk over this because I'm going to clip it. Yeah, but I do think that that's a possibility. Um, that's not what they're saying. That's the thing. Um, I think that's more plausible than what they're claiming, because they're claiming obviously she smacked into him and stuff like that. I think that's what you've just said there is more than plausible, but that's not what they're both stating. I mean, I suppose Gwyneth could say she's stating that, but that would be Terry still slammed into her, and Terry saying no, she slammed into me. So look at those YouTube Rumble. Hello, hello, and welcome. It's like Shannon. By the way, I know you on Rumble, but I'm just pretending I don't know you. All good, no problems. Oh, interesting day. Interesting. Right, okay. Everything's set up there. I just hate to wait. I mean, I wouldn't want to be him now. So what do we think? Do we think it's guilty, not guilty? What is it?
Meeting come to order, court is now in session.
Thank you very much. Good morning, everyone. Mr. Escobar, it's my understanding you did not want to wait for Mr. Grant. Is that correct?
He's on his way back from something. I've got Gwyneth handling some depositions for another client in another jurisdiction as well. It would not be fair to our client to wait any longer.
Okay. Including, all right, it's my understanding the bailiffs have informed me that the jury indicated that they have a verdict. So what we're going to do is we're going to bring them out. I will receive the verdict from them. I will review it to make sure that it is signed and dated and that anything that needs to be checked is appropriately checked. I will hand it to the clerk to be published. All right, let's get the jury. I'll also ask them the question that I always ask them to make sure that they didn't have any discussions or exposure to the case between the time they left yesterday and they returned this morning to begin deliberating.
I guess guilty, not guilty.
We are.
All
All rise, jury, and in courtroom.
He must be packing his trousers right now.
Jury is present and seated. Everyone else can be seated at this time. Ladies and gentlemen of the jury, good morning and welcome back. The first question that I have of you is my first opportunity this morning to see you is just to ensure that no one discussed this case amongst themselves or with anyone else, or did any research or was exposed to anything about this case between the time that you left the courtroom yesterday when I sent you home at approximately 5:30 and the time that you returned back this morning. It's my understanding the evidence was delivered to you at 8:35 this morning to begin deliberating. So between those times, the time you left yesterday at 5:30 and the time you returned and began deliberating again at 8:35 this morning, by show of hands, anyone discuss this case, do any research related to this case, or exposed to this case in any way? Excellent. Let the record reflect that there are no hands. Again, thank you all very much. It's my understanding the bailiffs have indicated that the jury has reached a verdict in this case. My first question is usually, were you able to select a foreperson and who that foreperson is? But because we had a communication from the jury yesterday regarding the reason, I know that the foreperson is, I almost said your name. I'm not going to say your name. It's number 6, previously number 48, but seated in number 6, initials JS. So, Mr. JS, my question then is to you. You are the foreperson, correct?
Yes, Your Honor, I am.
All right. Has this jury reached a unanimous verdict in this case?
Yes, Your Honor.
Do you have the verdict form?
Yes, I do, Your Honor.
Would you please present it to the bailiff? And thank you very much. I will review it, and then I will give it to the clerk to be published. All right, Mr. Keatley, if you will please stand for the publishing of the verdict, and counsel, you may stand with him. And Madam Clerk, if you will please publish the verdict at this time.
State of Florida versus Michael Edward Keatley, case number 10 CF 18429. We, the jury, find as follows as to count 1, victims Victor Sergio Guitron. The defendant is guilty of murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause the death of Sergio Guitron? Yes. We, the jury, find as follows as to count 2, victim Juan Guitron. A, the defendant is guilty of murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause the death of Juan Guitron? Yes. We, the jury, find as follows as to count 3, victim Gonzalo Guevara. A, the defendant is guilty of attempted murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Gonzalo Guevara? Yes. We, the jury, find as follows as to count 4. Victim Daniel Beltran. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Daniel Beltran? Yes. We, the jury, find as follows as to count 5. Victim Richard Cantu. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Richard Cantu? Yes. We, the jury, find as follows as to count 6. Victim Ramon Galan. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Ramon Galan? Yes. So say we all, dated this 28th day of March 2023, signed by the foreperson J.S.
Thank you, Madam Clerk. Would the defense like the jury polled at this time?
Yes, Your Honor.
Ladies and gentlemen of the jury, what that means is the clerk is going to ask each one of you individually whether the verdict that she published is in fact your true verdict in this case. The defense may be seated.
Juror number 1, J.P., is this your true and correct verdict?
It is.
Juror number 2, A.B., is this your true and correct verdict?
Yes, it is.
Juror number 3, J.W., is this your true and correct verdict?
It is.
Juror number 4, R.C., is this your true and correct verdict?
Yes, it is.
Juror number 5, C.M., is this your true and correct verdict?
Yes.
Juror number 6, J.S., is this your true and correct verdict?
It is.
Juror number 7, B.H., is this your true and correct verdict?
Yes, ma'am.
Juror number 8, T.J., is this your true and correct verdict?
Yes, ma'am.
Juror number 9, J.F., is this your true and correct verdict?
Yes, ma'am.
Juror number 10, E.A., is this your true and correct verdict?
Yes, ma'am.
Juror number 11, J.W., is this your true and correct verdict? I'm sorry. Juror number 11, J.D., is this your true and correct verdict?
Juror number 12.
12 is J.E.
Juror number 12,
Yes.
sorry,
It's okay, it is.
is it, okay. And juror number 13, D.S., is this your true and correct verdict?
Yes, ma'am.
Is there anything from either side before the court releases the jury? Ladies and gentlemen of the jury, this is my last opportunity to thank you. Throughout the past 4 weeks, I have thanked you for your patience with us, your very important service, and your attention to this very important case. I'm going to release you now, and I am going to instruct you that all of my previous restrictions about doing research, about looking up things, about talking to others, no longer applies. About watching any of the media reports or social media or anything like that, you're free to do all of that as you wish. Additionally, there is one protection that applies to your deliberations back in the jury room, and you can only be forced to talk about your deliberations through a court order. However, if you wish to talk about your deliberations, you may do that. That is your choice. The last thing that I want to say to you is that now you know what a hard job it is to be a juror. You've deliberated for 3 days now. Many times people tell me as a judge that I have to make hard decisions, and I say, no, that's in a trial division for the juries to make the hard decisions. So we all thank you for your very hard work in this case. So at this time, I am going to release you. All rise for the jury. Jury is exited. Everyone may be seated. We need to discuss sentencing. Counts 1 and 2 require a mandatory life in prison without the possibility of parole. Do you want to set off sentencing?
But I think that would be appropriate.
Okay. Let me check with my judicial assistant who
Judge, he would also be entitled to a PSI on the
we will,
remaining counts.
he could waive it, but do you want to waive or do you want to have a PSI?
No, I'd like to have some consultation with him before we make that decision, but if we set off sentencing.
What we'll do is I'll go ahead and order it. The clerk will notate ordered. If you change your mind, we can always cancel it. And I'm going to schedule sentencing beyond 30 days because that's what it normally takes for a PSI. So we'll order a PSI, pre-sentence investigation, and we'll set sentencing more than 38 days out, most likely on a Friday.
We can do either May 19th or May 26th, both at 9 a.m.
Mr. Escobar, are either of those 19th or 26th preferable?
I mean, just have a quick.
Take your time. And state,
Judge, either of those days would work for the state.
all right,
26 is good.
all right, so we'll do May 26th, did you say 9 or 9:30?
9.
9 a.m. right here for sentencing, and we've ordered it. I'll have to file any post-trial motions at least, let's say 10 days prior to that, and we'll hear those at 9 a.m. prior to any sentencing. Is there anything else from the state?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, again, thank you all very much. We'll be in recess.
Judge, at this time, there is one matter. He originally did have a bond.
Oh.
We'd ask that that be revoked.
I will revoke all previous bonds in this case at this time.
Thank you, Your Honor.
Okay. I only watched a few days of this and I thought it was interesting, but everyone seems to think it was slam dunk guilty. I don't know. Right. Let's get out of this bad boy. Right. The wrong one. We'll cancel that. Pull this up. Joanna, were you following it? Following it then? I've not. I always saw. I probably saw about 2 days worth, and what I saw, I did see him being guilty, but like obviously I only saw see like 2 days. I did think he was guilty based on what I saw, but that means nothing because I didn't see everything, so it doesn't matter. Um, share screen. The weird thing for me, though, Giovanna, is that the last time we had a trial, it was 10-2, not guilty. 10 not guilty, 2 guilty. So to get everyone was guilty now, jeez. So yeah, these are the trials. Wow. Okay, so for those waiting, we just started early for the ice cream murders. He was found guilty on all counts. I'm just waiting for Gwyneth, Team Gwyn, to come in. Banners, banners. Take that down now. So, um, so Gwyneth Paltrow will start in about 20 minutes, just for people to know. Do that, do that. Okay. So yeah, you got plenty of time. Just talking crap, you know. Uh, oh, jeez. Okay. Welcome. That one. Okay. Um, that's done. So hopefully everyone's okay. It's now 22-4 in the UK. So it's more like 22-11 Eastern time, I think. And what is it, Pacific? 4-4. So it's 20-8 for Erin in the Pacific. And yeah, Mountain is 20-8. 20-9, sorry. And in Central it's 20-10. It always amazes me in America, the whole time zones, the whole, geez. I can stand it because it's huge, but oh. So yeah, welcome, Stacey. You said hello. Welcome, Giovanna. Welcome. I didn't want to wait when that was on, and then Big Mike, as always. Big Mike had a good circuit this morning. A little bit of weight, but not much. 3 hours Pacific. Yeah, Giovanna, for you, but for me, it's 8 hours Pacific. If they're 8 hours behind me, Pacific, and you are 5 hours behind me. Rosie! Rosie, I wanted to compliment you about your pick. I love your profile pic now. I thought that was bad. It was the same. It was, let's take myself out of this whole. Your profile was awesome anyway, but I love the whole modernization of it now. Jesus, how to step in a hole. I hope you know I meant well. Um, yeah, Giovanni, you're used to being Rosie UK time, so we are 5 hours ahead of you. Let's check on Rumble, see if anyone's. Jesus. Shannon, you're all. Yes, he was. Mhm. No problem, Rosie. It was great before, but I just saw it on Twitter earlier on. I was going to message you. I was hoping you'd come in. Looks really cool. He was. He was, Joe. How are you, mate? Hope you well. Jets. 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 Hope you're well, my friend. Aaron Rodgers looks like he's going to sign in the next day or two. Um, so you're also. Oh, you're on California time, Stacey. Erin is as well. So good. There's two of you. Got a new app. Check you out. Check you out, Rosie. Rosie, are you going to follow me on these Sarah Boone stuff as well? Then? Not next week, the week after. You got to start from the start with us. Joe, I know where you're from, Joe. I know where you're from, my friend. With old Jets, come on, let's go. Commonwealth country. Yeah, okay. So it's nice to see people. Joe, welcome. So Rosie, Stacey, Big Mike's in here somewhere hiding. He's hiding here somewhere. He's been quiet at the minute. He's probably in a meeting, to be fair. Love it. Going to try and. I've not seen Spider Girl for ages now, so I'm going to see if I can contact her to see if she. Her and Lily, I think, great at all this. So, um, oh, also, did you know that group thingy? Are you in the group thingy? Chicken thing? I messaged, saw Liz, wherever her name is, podcaster, tweeted something. So I copied it word for word and posted on Twitter. And now I was confused. I'm confusing everyone. So I'm like, oh, jeez, well, I should not even posted it. But it's supposed to be a joke, but it's backfired on me now. So I'm going to do, for those that weren't here yesterday, next week I'm going to do a live reaction for Sarah Boone's interviews because I only know that she's involved with some suitcase, some guy in suitcase. That's all I know. So I'm going to listen to her interview next week and do a live reaction. So you don't have to be here live, but it'll be recorded live so you can see my reaction. I'll be pausing it wherever I need to do it. Apparently, there's two. One's like 45 minutes outside the house, and the one's 2 hours outside, being interrogated. So looking forward to that. Also, it's Easter holidays next week in the UK. Yeah, that's the one. Yeah, so someone posted Liz, whatever her name is, she blocks everyone. Uh, so screenshot or whatever, her saying she's done loads of research and she can't believe people think that she was banned from Alex Murdoch trial. So whatever she posted, I just posted exactly the same, but saying she was banned because she doxed the jury or something. It's it was a joke, but it's not a joke because now people don't get it's a joke. Now people are believing that she doxed the jurors. I messed it up. Missed it. But there we are. Welcome to everyone else. Thanks to people that are chatting. I understand some people don't want to chat. I find it interesting how many people are watching but don't chat because they're working. I love it. I love that. Listening. And that's perfectly fine as well. Some people leave. Right. Rumble. Let's get ready to rumble. Oh, hey, that's Rosie. You know PJ Duncan, don't you? Anton Deck. I can't play it because of copyright and stuff, but it's a popular song in the UK. Let's get ready then. Let's get ready then. Let's get ready. Rumble. I won't sing anymore. Don't worry. What was banned? What? Giovanna, what? Are we talking about PJ Duncan now? Or we say someone's been banned? Someone's been banned. It's Big Mike, probably. Big Mike's probably in a meeting, so. Boo, 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 boo. Hey, happy days. But even if you are waiting, like, you can still listen to it. Do you know what I mean? Oh, you never thought about how could anybody ban you, my friend? No one could ban you. You know, you're just an innocent guy. By the way, it was suggested I start a buy me a coffee thing, right? I do not expect anyone to buy me a coffee. I'm not doing it for that at all. But I started it because a couple of people wanted to send me some money. I was like, okay, fine. So I put it up here, but at no means whatsoever do I expect anyone to send me any money. But it's there. Um, Rumble, you get paid on Rumble, you see, to uh, so a 9.5 hour stream on Rumble paid me, right? 3 cents. Oh, in the money. I mean, Rumble's okay. I mean, but I streamed it, and there was an average of probably about 6 people watching it on there all day yesterday, and they pay you. I say you get 3 cents for a 9.5 hour stream. People can donate money and stuff, but I think he's not banned. He's not banned. No, he's not banned, Joanna. He's not. I mean, if he was on most people's channels, he'd be banned by now, but not on this channel. Not on this channel. I look after my day oneers. People that were here in the first couple of weeks. I know who you are. Do you know what I mean? I'll never forget you guys for doing that. Big Mike. Oh yeah. Like a grove. Let's go. PJ Duncan. That brings back memories. That shows. Hey, that shows my age anyway. That shows your age, Rosie. Jeez. I'm now 40, so yeah, it was back in my teenage days. Jeez. Biker Grove, Newcastle. If people watch it now, they think it's rubbish probably, but it was class back in the day. 3 cents. That's how much I made on Rumble yesterday for 9.5 hours. I just tried it out just to see what it's, if it was any good, but I think they rely more on people actually sending you money on there. 41. I'm 41 in about 3 weeks, I think. So I'm nearly in the club as well. Would we be in the same school year then, Rosie? As in, you'd, yeah, we might be in the same school year. Yeah, yeah, probably would have been. Eastern, well, I can tell you it starts in 8 minutes, Joe. So Eastern wise, that is 11 o'clock. Yes, 11 o'clock Eastern. So 8 minutes, Joe. Yeah. So we would be same school year. You, me, same school year we would have been. Imagine the trouble we could have done, Rosie. You know. he? Here we go. I only go by school years.
Good morning.
Good morning.
Are the parties ready for the jury? They're all assembled and ready to go.
We're waiting.
These judges on it.
Defendants ready?
Yes.
Okay.
I like this judge.
You can go ahead and bring the jury in.
So was I. Don't worry about it. Feet nightmare. But I think we've got on well. Hey, we probably ready to married or something, Rosie. You know what I mean? Troublemakers together. 11 a.m. Yes. 11 Eastern.
Let the record reflect that counsel are all present, defendants present. Mr. Sykes, you're still doing a cross-examination of Mr. Graff. Okay. Mr. Graff in the room?
At the hall.
Okay. Can you ask Mr. Graff to come on in?
Sorry, Giovanna, Thursday's supposed to be. So. Who's he?
Mr. Graff, could you come and be resworn? Good morning.
The chance. I'm still single as well. So,
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Go ahead and take a seat.
I like the judge as well, favorite judge.
We're just waiting for the jury.
Rosie, must be something in the water because I've never got married either. I don't know what it is. I knew you're a cat lady in the sense you have cats. Don't worry, I've explained that. I knew that. I knew that you were like a recluse that just stays in your house and just has 200 cats or something. Yeah, it must be something in the water for you because I was a troublemaker in school and never got married. What's his name? Oh yeah, that'd be class. Two. I like dogs, you see. Fair dogs to cats, but I don't mind cats. They're quite easy. Except for when they bring mice in. I have a cat as well. Good. Neither do I.
Good morning. Mr. Graff was just sworn in by the clerk, so he would be ready to go. Mr. Sykes, you may proceed.
Thank you.
Mr. Graff, we talked yesterday about, this is plaintiff's exhibit 3 and the defense has one. Can you see that in front of you?
I can.
Okay. This is the ski report, instructor's comments, filed by Eric Christensen, correct?
Yes.
Okay. And you reviewed it. You reviewed it?
Yes, I have.
Okay. Now, up top here, can I have the pointer? Let's see here. See, there's a time here, 11:55 a.m.
I see that.
Okay. Can we assume that's a fairly accurate time?
Yes,
And that Whitney Smith, when she picked up Terry Sanderson, marked it as 12:02.
that's when the dispatch came in, was 12:02.
Dispatch, okay, 12:02. Now, you notice here, name of student. This one has been whited out, but on one that we have, it has Gwyneth Paltrow's name there, correct?
I don't know which one you have.
Well, the one I have has it whited out, but the defense has her name in there.
I see this one that's whited out.
Yeah. And this was a falsehood, correct? The name of the student wasn't Gwyneth Paltrow, was it?
I'm not sure the name of the student.
Well, Eric Christensen's student was Moses Martin. So if he writes name of student Gwyneth Paltrow, that's incorrect, right?
I believe this form is commenting on Gwyneth Paltrow.
Yeah, as a student, but she wasn't his student, right?
I don't believe so.
Okay. Now, would you agree that the crash, the ski crash, was serious enough to warrant someone like Eric Christensen writing a formal report? Correct?
It was serious enough that he made comments about it at the end of the day.
Okay. Is that a yes to my question?
What was your question again?
Serious enough to write a report?
Yes.
Okay, thanks. And you recognize that he claimed here twice that he didn't see it. Right here, I didn't see it. And then a little lower. Did you witness the accident? No. Do you see that?
Yes, I see
Okay.
that.
Now, despite the fact that he didn't see it, and Gwyneth was not his student, he blamed the male skier anyway. Correct? He blamed the male skier for the crash, correct? Now, did that bother you?
Is there a question?
Yeah, it was. He blamed the male.
I think you allowed the witness to answer.
It's a very simple question. Okay. He blamed the male skier.
Can you answer the question?
Yes.
Thank you. Yes, you
Well,
can
that
answer, or
wasn't
yes,
yes
he
to the
blamed the male
question.
skier.
It was just the judge question. I can't answer your question. I'm just reading before
Okay.
I answer the question.
Just read additional comments there.
I did. Yeah, I don't know that I see blame there.
First thing male skier stated was that she appeared right in front of him, thus admitting he was the uphill skier. She
Right.
never saw him because he came in from behind. Now, you don't consider that to be a blame?
I consider that to be just what it says, that thus admitting he was the uphill skier.
Okay. Did it bother you that now at the time you were in charge of all ski instructors, weren't you?
No,
What was your title?
I was the ski patrol manager.
Ski patrol manager.
Correct.
Okay. Ski patrol manager. Did it bother you that a Deer Valley employee, an instructor, whose report you read, blamed the male skier even though he didn't see it? Did that bother you at all at the time?
I don't see blame here. I just see thus admitting that he was the uphill skier.
Now, did it bother you, Mr. Graff, that on this report, he never got the male skier's contact information?
No.
Yeah, you're sitting there a day or two later, you testified about it, and you read this report, and there's a crash that was serious enough to haul someone down off the mountain on a toboggan. And this man who's writing this report never gets the male skier's contact information. That didn't bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave Gwyneth Paltrow's contact information? That bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave his contact information to anybody?
None of these bothered me because at the time, everybody skied away with the assumption that everyone was fine.
Okay, so your understanding was that everyone skied away, even though a ski patrol person named Whitney Smith hauled Terry Sanderson off the mountain in a toboggan, and in your definition, that's everyone skiing away because they're all fine, correct?
Whitney Smith responded to Mr. Sanderson in a different location from where the collision occurred. So they all skied away.
Now, let me ask you this. This claims here that a man with 4 documented broken ribs, 2 of which were separated, broken, not just cracked, separated. 4 documented broken ribs, said he was okay to 2 other ski patrollers that allegedly came by. Did that bother you at all?
That's my understanding of what happened.
Did it bother you that allegedly, this yellow over here, but a patroller came by to check on everyone? Did it bother you that there was no log of that patroller?
No.
Didn't bother you. Okay. So nothing so far has bothered you, right? Okay.
These are just the facts.
Everyday life at Deer Valley, right?
Yes.
Okay. Now, did it bother you?
I used to do a job just like this guy. They've done nothing wrong. Not for skiing, but for general activities. There's no incident report because it's not an incident.
See this right here where my cursor is?
Yes.
That Eric Christensen, after this crash, goes to lunch with one of the most famous actresses in the world and her family. Did that bother you at all?
No, I think that's standard practice for ski instructors.
Did it bother you that 3 hours after lunch or so, that he then writes his report? That bother you? Did that concern you at all?
No, that's typical of what happens.
Did it ever occur to you that this instructor might be covering up bad conduct by himself to protect Miss Paltrow, a big spender at Deer Valley? Did that ever concern you or bother you?
No.
Did it ever concern you or bother you that he might be covering up bad conduct by Gwyneth Paltrow?
No.
Didn't you basically wink and a nod at this bad conduct? Wink and a nod at it.
Can you define that?
You know what wink and a nod means?
No.
Well, actually you do, because we had a deposition on another case, but wink and a nod, as I'm using it, means you see something wrong, but you just wink at it and go on and don't do anything about it. Isn't that what you did here today?
Absolutely not.
Okay. Why wasn't this instructor terminated for filing a false report?
This is his report. There's nothing in it that's false.
Isn't it true that you believe he wasn't fired because he did nothing wrong? He did nothing wrong.
Correct.
Okay. And there was no cover-up by Deer Valley, correct?
Absolutely not.
Thank you. No further questions. Thank you.
Thank you, Mr.
That's
Sykes.
ridiculous. That's ridiculous.
I just have one question, Your Honor. if I may.
Go ahead.
Is that it? The plaintiff's got? That's ridiculous. Shame on
See you
them.
again, Mr. Graff. Thank you for coming back.
Thank you.
Very nice of you.
Genuinely, shame on the plaintiff for this.
It's okay. It was cooperating yesterday. I think I just need to go back to the old technology again. Okay, so
You have 10 minutes, Mike.
I just want to ask you, Mr. Graff, one question.
Excuse me 1 second, I got my computer.
Oh, yeah, go ahead.
They're attacking the fact that she's.
I just want to ask you, Mr. Graff, a quick question about the patrol log published this week. Looked at it yesterday with you, Defendant's Exhibit 26A. You were asked questions, not today, but before you left the stand yesterday by plaintiff's counsel about this bad boot entry here. Do you see that?
I do see that.
And do you remember questions about how that was sort of a minor issue, and he was asking why that would be logged, but other major issues might not be?
Yes.
So can you explain what is a bad boot and what would it require of a patroller who came upon that kind of a problem?
You know, I'm not exactly sure what this bad boot issue was, but it could be that a buckle was broken. It could be that, as funny as it sounds, could be they were on the wrong feet. You know, you see things like that. So there was some issue that Jess responded to, and it was as simple as a bad boot.
And might it require a toboggan down the hill if someone had a malfunction that they couldn't get down the hill?
Yes.
Okay. So, and then this section here, 1202, again, I'll use this little laser pointer, 1202 here. It over in the nature of the injury discussion, it says skier collision and disorientation. Do you know who wrote that?
I don't know who wrote it. Whoever is manning the dispatch is the person who puts these entries in.
Okay, so would it be fair to say then that it would not be Whitney Smith that wrote that?
It would not be Whitney Smith. They're transcribing what Whitney Smith is saying over the radio. So Whitney Smith was on scene 2 minutes after the call came in. And then whoever was there wrote down what she said.
Okay.
And she said that she was on scene of a skier collision with the patient experiencing disorientation.
Right. And the jury has heard what her experience was, and you don't know anything further than you've already told us about that, correct?
That's correct.
Okay, thank you.
No further questions.
All right, you are excused. Thank you.
Thank you.
Is there a possibility the witness may be called back?
Not from us.
Yeah, very small.
Okay, so you're still under, I guess, this trial, so please don't discuss the case with any of the other witnesses.
Oh, right. I'm going to move there for a second, and we'll, once we start talking, go back to it. So this guy, Graf, literally, I do the same job. I used to do the same job before I started this, but in universities and things like that. And I can tell you now that all incident reports and stuff like that would go through me. And there's literally nothing here. Hang on, what's he saying? Shit.
Okay.
Go ahead and set up.
The easel, that's all. There's nothing here that they would put. If a staff member for me had put down an incident report for what they just done, I'd be like, what are you doing? You cannot put incident reports forms for everything. So yes, he got injured, but at the time he wasn't. Do you know what I mean? I'm just baffled by all this. Baffled.
Please state your full name and spell it all out for us. Thank you.
My name is Irving Scher, IRVING. Last name is SCHER.
Thank you for being with us here today, Dr. Scher. Let's begin by just asking you what you understand your role here to be today.
To teach the jury about biomechanical engineering related to snow sports and particular skiing.
And Do you have an understanding of what plaintiff's biomechanical expert, Dr. Boehm, has said about this case?
I have. I've read his deposition testimony and his trial testimony. So I do understand what he's saying in the case, yes.
Okay, and you have opinions about his testimony, is that right?
That is correct. I've analyzed his biomechanical engineering analysis.
So the jury will get to hear your response to his analysis.
Exactly.
Okay, great. So before we get to that, let's talk about your background and training so they understand why you and not me are on the stand.
Sure.
So where did you go to school?
I did my bachelor's of science and engineering at the University of Pennsylvania. I majored in mechanical engineering and applied mechanics. And then after undergrad, I moved west and I got my master's and my PhD at UC Berkeley in the mechanical engineering department. And I had two disciplines that I specialized in. One was called dynamic systems. That's how objects move in space when forces are applied to them. And the other is biomechanical engineering. And that is the application of physics and engineering to the human body, in particular, looking at how people get injured and how to prevent injuries.
And did you do a PhD thesis?
I did.
And can you explain what you worked on?
Sure. I was the last in a line of what we called skiologists. I studied the biomechanics of alpine skiing. I created load cells, so those are devices that measure the forces, and I put them in between the skis and the bindings. And I had different instrumentation on skiers, and it was the first time, or at least that I'm aware of, that anyone in the scientific community was able to measure the forces and the body motions of skiers from the top of the mountain all the way down to the bottom. And I did this with beginners, people who had only skied 2 or 3 days in their whole life, all the way up to professional racers. And so that's what I got my PhD in.
And this is actually measurements on the slope as people are skiing.
That's right, exactly. Yeah, I'm measuring the forces applied to the person and their body motions as they're skiing. Well, and falling. We did have falls as well.
Right, and so this is not just calculations in some ivory tower, but you're actually out in the field looking at
hands-on work, which is quite difficult when you have electronics and snow and water. It was challenging for sure.
And do you also do any teaching?
I did teach. After I graduated with my PhD, I did a small postdoc in the biology department at Berkeley. And then after that, on the medical campus, and I taught intro to biomechanics, and I also did research there at USC. And then I moved, I now live in Seattle, and I'm at the University of Washington. I have an affiliate professorship there. I'm an associate professor at the University of Washington, and I occasionally lecture, but mostly advise grad students.
What about professional licenses? Do you have any of those?
I'm a registered professional mechanical engineer in California, Washington, and Alaska.
And then in terms of professional societies, these groups of people that get together to research and work on a certain field, are you connected to any such organizations?
I am.
And what are those?
I am chair of a group called ASTM F27. If you've ever gone to a ski shop and purchased ski equipment or rented ski equipment and they set your bindings, what some people call DIN settings, that's based on the standards from ASTM, and I'm the chairman of that group. We also do other snow sports equipment. I represent the US for snow sports equipment safety at the International Standards Organization, so the ISO. So if you go over to Europe, you'll have the same release and retention settings for your skis. Your bindings won't pull off your skis. They use the same standards that we've developed here in the US. I'm also president of a group called the International Society for Snow Sports Safety. And that's more academic than the other two organizations I was mentioning. We call it ISSS. ISSS is the premier organization worldwide to present and publish your snow sport safety research. And we have members from all over the world: Switzerland, Korea, Norway, obviously the US, Canada, Australia, New Zealand. It's quite a great group, and it's really the group that helped develop ski binding standards.
So you do some research on the safety of snow sports like skiing, correct?
That is my main focus of my research ever since grad school, and I've continued to do that now.
And then you also evaluate cases in a litigation context, is that right?
I do. About 15%, 20% of my work is forensic work. The rest is research and development.
So most of the time, are you doing research to try and improve the safety of skiers on the hill?
Yes, and I should say it's not just snow sports. I work in other recreational sports areas, water sports, mountain biking, other areas too, but snow sports is my favorite, my passion.
So let's explain to the jury what biomechanical engineering is, just because we could use a refresher.
Sure. Biomechanical engineering is the application of physics and mechanical engineering to the human body. But in a forensic sense, it's what links the event to the injury. So if you have some type of event and there's forces and motions in the event, in the accident, the forces are applied to a person, there's internal forces on their, like in their body at the joints or something like that. The amount of force and the amount of motion it takes to create damage to the body, that is biomechanical engineering.
And how's that different than medicine? They're both dealing with the human body, but what's the difference?
Sure. The medical field tends to take the injured person, figure out what's wrong with them, so diagnosis, and then try to get them better, so treatment with an eventual outcome. So most medical training is after the injury, as opposed to what forces and motions create the injury. We like to think of ourselves on different sides of the injury.
Thank you. Can biomechanical engineers determine the forces required to produce fractures of bones in the body?
Yes, there's a lot of research on that, and that's one of the main areas for biomechanical engineering.
So is there scientific literature that describes the forces needed for, say, rib fractures?
There is, yes.
And you're familiar with that literature?
I am, yes.
And let's maybe ask a specific question about that literature. Given your knowledge of it, does a 70-year-old man need to fall on his side with his elbow between him and the ground to cause rib fractures?
No. So there have been a number of scientific studies, mostly done by biomechanical engineers, but there's other scientists who have looked at this as well. And what they do is they take cadavers or portions of cadavers and they apply forces to them. Sometimes they'll swing a pendulum into the side of a cadaver or to the front, or they'll have a plate, a very heavy weighted plate, contact the person arm down, arm up at 45 degrees, or they'll drop the cadaver in different configurations, and then they'll see what injuries are produced. And so when they've done this, in particular for chest impacts, what we find is you can get lateral rib fractures, according to the biomechanical engineering literature. You can get lateral rib fractures with an impact to the side with your arm down or with your arm up. But you can also get lateral rib fractures from compression, so front to back compression of the chest. So if I press my chest in like this, what happens is the ribs actually bend out on the side, and that can create fractures on the side, and that's quite common as well. So rib fractures are not just from side contact, it can be from front to back compression as well.
So let's get to what you did in this case. So what did I ask you to do in this case?
Basically, you asked me to evaluate Dr. Bain's biomechanical engineering analysis to see if it was accurate and correct.
And what material did you review? I think you already mentioned you read his transcript and you watched his trial testimony. Is that right?
I did, yes.
and maybe for the jury, in case they need a reminder, he had that green screen in the back of him.
Right, just the talking head.
Exactly. Speaking from Florida, I think.
That's right.
Right. And so let's just start with his analysis. Do you agree with it?
I do not. I do not agree with his analysis.
And maybe before we explain why, just give us a sense of what you understand his method and analysis to be.
Sure. As I've gone through what he testified to in his deposition and the trial, looking at his calculations and what he's done, to me, there's two parts to his analysis. The first is calculations to show that Miss Paltrow had to land on Mr. Sanderson in order to get the rib fractures that he got. And then there was a second part that basically said, because Miss Paltrow had to land on Mr. Sanderson, that could only happen with Miss Paltrow hitting him from behind. It couldn't happen any other way. It was impossible. So that's my understanding of the kind of the two parts, the main parts.
Thank you. We'll go over those in more detail. As you looked at his analysis, you read everything that he read, correct?
I did.
And did you read even more than that?
I had additional depositions, that's correct.
Of the various people that were at the scene of the accident?
That's right.
So let's get one thing out of the way. Do you agree with Dr. Bain that Mr. Sanderson's rib fractures did not occur during the initial skier-to-skier contact?
Yes, I think that's correct. There's no disagreement at this point, at least from the testimony I've heard. The skier-skier portion where they first contact, no matter which version we have, did not create the rib fractures. I don't think anyone thinks that at this point. So that's good. We agree.
And in terms of just a quick overview before we go into his calculations, which you can explain to the jury, do you believe that Ms. Paltrow's account, and I should say, are you familiar with her account?
I am.
And you heard her trial testimony?
I did.
And read her deposition. And
Yes.
do you believe her account of the collision is consistent with what you know about biomechanical engineering?
Object. Goes beyond the scope of this expert witness.
It calls for the evaluation.
What goes your testimony?
Would you please approach the bench?
How is it now with the? I tried to refresh it, but it works okay for me at the minute. The stream seems fine for everyone, doesn't it?
Objections overruled.
Okay, so let's go back to that question. I was asking you, in your opinion, is Ms. Paltrow's account consistent with what you know about biomechanical engineering?
Yes, it is.
And maybe another way to put that is it consistent with the laws of physics?
It's the same question. Yes.
Yeah, and
exactly.
Dr. Bain, the jury heard, talked a lot about Newton's laws and the laws of physics, applying those to the evidence in this case. And again, in your analysis, as you apply them, Ms. Paltrow's account is consistent with those.
Objection, last foundation.
Overruled?
That's correct. Ms. Paltrow's version, her scenario is consistent with the laws of physics and what we know about biomechanics.
And then the account that Dr. Bain gave, and that is based on Mr. Ramon's account, is that consistent with the laws of physics?
I do not believe it is, and I can explain as we get into it.
Yes. Okay. Great. We'll explain that. Let's go to Dr. Bain's calculations so you can explain to the jury your analysis of those. We have an easel, and as I understand it, you would like to kind of draw so that you can show them what the equations mean. Is that correct?
That's exactly right.
Okay, so I'll grab the easel and then that board.
Mark's coming to fight today. Stacey's a big softie. Don't listen to him. It's fine. Big Mike's a softie, Stacey. He just wants to fight this morning.
We can't want the judge. Judge, where do you want this easel? On the screen?
He's going to also need to see the screen. So is it
Mine's
okay
good,
if you put it
You guys get on
right
fine.
here? Are you going to be able to see that?
You just
I
slightly
can't see it,
different
but
beliefs.
it's really more important that the jury see it, so I'm fine with that.
And I think if it's okay with the judge, you can get off the stand and,
Yes, sure.
and there's your marker.
We don't always all have to agree, but we can all get all along. And get
Okay, so I'm going to pull up something that Dr. Bain pulled up in his deposition. Do you remember seeing these documents? And for the record and for counsel, these are the notes in Exhibit 3 of Dr. Bain's deposition. Oh, thank you.
Sorry, I missed the question there.
Yeah, no, you're fine. So I'm just pointing you to.
Before you, these are not admitted exhibits, though.
Yeah, I'm not asking them to be admitted. They were just shown in Dr. Bain's deposition, so we're showing them here as well.
Okay, but not in his trial testimony.
He's responding to these.
You said deposition.
He also showed it in his trial testimony.
So
Oh,
direct-
trial deposition.
I was going to say direct things to the judge, but
I recall this being flashed
Withdrawn.
during his deposition or during his trial testimony.
Okay, thank you, Dr. Scher. So you recognize this page?
I do.
And I was just describing it. This was shown in Dr. Bain's trial testimony, correct?
That's correct.
And he explained that these are his calculations.
That's right.
Okay, and there's another page as well. I think it's the one just before it, correct?
That's correct. This is where he starts the calculations for the ribs. We're concentrating on the ribs here because that's what he says determines how the accident happened. He said the head injury doesn't matter for that. It's only the ribs.
Okay, great. So since I have very little idea what's going on there and you do, maybe explain to the jury what's going on.
Sure. Can we go to the page before this?
Sure. And maybe if you, it's just a little bit hard to hear.
Sorry, is that better?
Yeah, that's
Okay.
a little better. Yeah, thanks.
So he's using some basic equations for what we call the center of mass to figure out what happens when someone falls to the ground. Center of mass is if you were to balance someone on your finger, the point that you'd hold them at so that they stay balanced. It's usually a little bit below your belly button, kind of midline front to back, midline left to right. And so if you took all the person's weight, all their person's mass and put it into one point, that would be the point that you're interested in. So that's what Dr. Bain is doing in these calculations, is he's using that point for Mr. Sanderson. And this first part here, where he has this, that's an equation, X is position. So he's saying there's a certain distance that center of mass falls. And you can see that over here. That's 3.5 feet, or he does it in meters, 1.0668 meters. So center of mass falls to the ground. He's saying that there's no initial falling position, that's fine. No initial falling velocity, V is velocity. And then he has 1/2 acceleration times time squared. And that equation is correct. Acceleration here is the acceleration from gravity. So what he's saying is Mr. Sanderson's fall to the ground for the center of mass from 3.5 feet, which is probably about right, hits the ground within, and he calculates the time, he solves for time, 0.466 seconds. So that's the first part of that, which is great. The problem comes in that he then says the velocity at contact is 1/2 acceleration times time. And that is absolutely wrong. That is not the velocity at contact. The velocity at contact is just the acceleration times time. So he has this extra half. And it was unclear to me why that would be there to start. And I'm not sure why he put that in. But it creates problems for his calculations and his opinions moving forward. If we can go to the next page, I can explain that. So these are his equations. If you remember in his testimony, he said 4,000 newtons. And that's an engineering unit in metric for force. 4,000 newtons is roughly 950 pounds, I think in English, but newtons is fine. Over 4,000 newtons, you get the rib fractures. So what is this equation here? I'll show you that and then explain why that 1/2 makes a big difference. So that equation there comes from, at first, kinetic energy. We label that as KE, which is equal to 1/2 mass times velocity squared for that center of mass. And then he's saying, okay, Mr. Sanderson, as he hits the ground, has a certain kinetic energy. That energy has to go somewhere. So what happens is a force is applied from the ground to the center of mass, and he decelerates over some distance. So you can see here he has 3 inches written here. That's important. So this kinetic energy has to be taken up by some force over a distance. That's some amount of work. And that will equal the kinetic energy. And then he divides both sides to get the force. The distances cancel on this side. So the force on Mr. Sanderson is 1/2 mass times velocity squared divided by distance. And that's exactly what we have here. We have 1/2 mass, velocity squared, and distance. Now, remember, he's doing this in metric. So that 136, that is in kilograms. That's equal to about 300 pounds. So here he has Miss Paltrow and Mr. Sanderson's mass put together. So in this fall, he's saying, okay, the kinetic energy of both of them is needed here during contact. But can we go back to page 5? He uses the velocity here, the 2.29, that has the 1/2 in this. So if we go to the next page, yeah. So you can see he's using the wrong velocity. What happens is if you use the wrong velocity in here, let's do Bames as, call this wrong. So what you get is 1/2 mass times 1/2 acceleration times time. Oops, that's weird. There we go. Divided by distance, and squared there. Correct is 1/2 mass acceleration times time squared. So that 1/2 goes into this equation. What does that mean? That means that this half gets squared. It becomes 1/4. So the force that Dr. Bame calculated for this landing was actually 1/4 of the force he should have calculated. He was off by a factor of 4. So it shouldn't be 4,680 newtons. It should be 18,600 and some newtons. Actually, I have it here. 18,678 newtons. So he's off by quite a bit.
And if I may, Dr. Scher, what this is obviously all at least new to me and maybe new to some jurors. What in the end is the takeaway there if there's that much of a mistake?
So there's two things. One is if there were 18,000 newtons applied to Mr. Sanderson's chest, we would expect much worse injuries. The biomechanical engineering literature for much less than that has many more rib fractures, internal injuries, all sorts of things. We don't see any of that for Mr. Sanderson. But the real takeaway and the importance in this case is the mass here. So because he does the 1/4, he needs the mass. He needs the mass to be 136 kilograms. Now, if you redo the calculations correctly with just Mr. Sanderson's mass, so Mr. Sanderson is about 80.5 kilograms, or roughly 177 pounds, at least according to the medical records. If you do the calculations with the correct equations and only his mass, you get over 4,000 newtons when he lands. Actually, you get 11,056 newtons. So if you were to fall to the snow using Dr. Boehm's calculation method the correct way, then just Mr. Sanderson falling, not Ms. Paltrow involved at all, he could get rib fractures. This is not quite correct overall. Normally we use what's called effective mass. So all of Mr. Sanderson's mass wouldn't go through his chest. Maybe there'd be some force on his legs. If he hit his head, some force on his head. We typically would say maybe 50% of his mass would be appropriate for effective mass. So instead of the 80 kilograms, we would do, and actually I should put over here, this winds up being 11,000 newtons. And if we do the 40 kilograms instead for Mr. Sanderson, so, and that's, and we use the correct equation, we get sorry, I don't do the math in my head. 5,500 newtons, approximately. What this means is Mr. Sanderson can fall to the ground without Ms. Paltrow landing on him and sustain the rib fractures according to Dr. Boehm's calculation method. So if done correctly, he cannot say his opinion that Ms. Paltrow had to land on Mr. Sanderson to get the rib fractures, which means that this goes through the rest of his analysis. So the rest of his analysis is wrong. So this is really critical, that 1/2 that he did for the velocity, the wrong velocity, really threw the rest of his analysis into question.
So Dr. Scher, there's a lot more we could say about the calculations, I'm sure, and you would approach it differently than he did, correct?
That's correct.
But given the way he did it, if he did it correctly, you're saying that the conclusions that he came to are inconsistent with his opinion.
That's correct. Yes, okay. Exactly.
Okay, so, yeah. Okay, doctor, let's talk about skier collisions. You've, as you explained earlier, done research to understand what forces are like on the ski slope. In this case, how would you apply what you know about physics to understand the claims about the ski collision?
Sure. I would apply Newton's laws to the contacts, the different versions of the events, and see what makes sense, how it would unfold. Do the physics of the contact that's being testified to make sense? Is it self-consistent?
And this may be another opportunity to draw some pictures if you need to, so feel free to if it will help you. But you were talking about the center of mass earlier. How does that concept factor into how you would evaluate the evidence in this case?
Sure. Yeah, if it's okay to draw again.
You may.
Thank you.
And I can see what you're drawing through the monitor here, so.
Oh, nice. Perfect.
Great. And if you need more board or pages, we have them now. Is that correct?
I think we're okay with this, right?
Okay, yeah, great. Go ahead.
So the thing to know with Newton's laws, force equals mass times acceleration, if you have some, and I'm going to draw two versions of a skier, and I'm not the best Pictionary player. I'm going to draw a top-down version, and I'll draw a side version. So let's start with the top-down. So if we have a skier, and here's the skier's head, and here's the skier's nose, and then we have two skis. The center of mass would be, as we mentioned, looking down somewhere around here. Now, if you have a force that goes through the center of mass, so let's say the force goes through, then the person will accelerate in this direction. They'll accelerate along the line of the force. But what happens when you have a force that doesn't go through the center of mass, it'll create an acceleration going in that same direction, but it'll also, there's a distance here, it'll also create a torque, which is equal to the force times the distance, that will cause the person to rotate. And that's really important because if the force does not go through the center of mass, there's always a rotation. So if you're hit on this looking down, this would be the right side, then the person's going to rotate counterclockwise in this image. The same thing is true if we look at a skier from the side. So if here we have our skier, and here's their pelvis and center of mass. It's our ski boot. And if the person, for example, has a force applied below their center of mass, then there's, again, some distance. That's going to create a torque and a backward rotation so that the person moves backward and falls back. There's two things to note with this for skiing in particular that's different than most other events. Skis have releasable bindings. So if I'm looking at this side view, the boot is held in by a heel piece and a toe piece. And so if you have someone pitching forward, if the ski slows and the person's center of mass moves forward, it'll create a torque on the boot and it'll release the heel of the boot. And for someone of Miss Paltrow's size, that could be anywhere from, well, it's approximately 143 foot-pounds. So 143 pounds acting over a foot. Same thing is true for the top-down view. If we look at the toe piece for the binding, if there's a torque on the ski, a twisting torque, the ski will also release from the boot. And for someone of Miss Paltrow's size, it's about 37 foot-pounds. So in front of the boot, if there's 37 pounds, 1 foot ahead, it'll release. If it's 2 feet ahead, it's half that value. So roughly 17. So these are the principles that we need to understand the mechanics of an impact in a fall.
So when we apply those principles to this case, what conclusions do you draw?
Sure. The first is that Miss Paltrow's version of events is consistent with the laws of physics and how people move and rotate.
And what about Mr. Ramon's version?
For Mr. Ramon's version, I couldn't get it to work. It doesn't match with the laws of physics. The complete part of his testimony just doesn't fit.
And so can you explain why it doesn't fit?
Sure. So Mr. Ramon's version, maybe I should sit down.
Oh, sure. Yeah, go ahead.
And no, this, I have no idea what he's on about. I trust him.
So in Mr. Ramon's version, he says that he sees Ms. Paltrow contact Mr. Sanderson squarely in the back. And he says that it's in the middle. It couldn't be any more in the middle than if he tried or if she tried. And then also that she rode him down. I think the quote was something like, in his deposition, he says, like she couldn't have been on his back any more than if he had strapped her to his back, something like that. So as they're going down in Mr. Ramon's version, Mr. Sanderson goes spread eagle, arms out, legs out. And the key for me is that Mr. Ramon says that the inside edges of those skis that are going into this V catch, and Mr. Sanderson stops on a dime. And if that were the case, then Miss Paltrow would keep moving, and well, maybe I should draw.
Sure, go ahead if it will help.
Yeah, I think so.
You can draw it, no one will understand it, but sure. My mind is fried.
Okay, so I'm going to try to draw a top-down version of this. So if we have Mr. Sanderson, and here are his skis. And then I'm going to use a different color for Miss Paltrow. How about blue?
No one, I'm surprised
Miss
anyone
Paltrow
understands this.
contacts him from the back. And
Yeah,
now
definitely.
this is the same whether one ski is between his or both skis. If the skis are apart, it's a little bit different, so we can get to that in a minute. But if her skis are between his, let's just say, then when he falls, and here is his, so they're moving in this direction. That was probably obvious, but I wanted to make sure that was clear. So now we're still looking down. Here's Mr. Sanderson's back. Here's his head. Here's one arm. Here's another arm. Here's one leg, the other leg. Now, remember, Mr. Ramon says that his skis are in a V, spread eagle. So now,
Jared.
if that were to happen, then he stops very quickly, and Miss Paltrow is going to remain in contact somewhere around here, and her skis are going to stay underneath Mr. Sanderson. When that happens, it's like the center of mass continuing to move forward while the skis slow rapidly, which creates an upward force at that heel. It's going to create a heel release. But as you heard in the testimony, all the skis were on. It doesn't work. It takes actually very little force for this to release, the heel piece to release in a scenario like this. So it doesn't match with physics. And it's the same way whether one ski or both skis are in between.
Okay, so how do you know this, especially about the bindings releasing? How are you confident about that?
My experience, I mean, I've seen tons of binding releases. I know how bindings work. It's just physics.
Right. And you've specifically done research on binding releasing.
Oh, yes. Yes.
And you said earlier that there were other scenarios, the skis maybe between Mr. Sanderson's skis, maybe they're diagonal. Did you do evaluation of all those sort of scenarios, and did any of those work?
No, I couldn't get any of them to work. So the key is either she would come out of the bindings or she would be stuck on Mr. Sanderson. She wouldn't be able to move past it. If her skis stayed on in various versions of this, I don't know how she continues to move downhill the 10 feet that Mr. Ramon said she wound up if her skis are trapped underneath him.
And would you expect her to get an injury in any of these scenarios?
Well, certainly there's that potential, yes, a lower extremity injury for sure.
If, for example, her legs get stuck in one of the scenarios you mentioned.
Right. So, for example, if her ski is rotated out to the side going in that V with one of his skis, the other, whether it's on the outside or in the inside, can't wind up. So if her ski is on the outside, his ski is going to push her ski out. If this is her ski, as he's falling and moving into that V configuration, it's going to go from this position to here, and it's going to push her ski outward, which I would expect would create a toe release, a twisting release of the bindings, because it actually takes about 18 pounds of force, between 15 and 20, depending on how her bindings would be set. So very little force to release that toe piece. But even if it didn't release, then her ski winds up getting trapped by his, and she can't move forward. So, and in many of these scenarios, her leg would get twisted in a really odd way that would likely create injuries.
Okay, great. I think you can sit down again. And now what I'd like to do is ask you about whether you were involved in creating any animations that would help the jury understand your opinions in this case.
Yes.
And Your Honor, if I may ask for permission to show the witness these animations so that I can lay some foundation, he can use them to teach the jury.
Yeah, we reserve our same objections on these animations, Your Honor.
Understood.
I think he's a good witness, fantastic witness. Just I don't understand half of it. So the jury. If I was a juror, I'd find him credible. I'd be like, yeah, I'll listen to this guy.
Restarting.
It's been plugged in, but it's now.
So yeah. So hi, Erin. You've not missed much. I do not ask me to explain what this guy says. I couldn't tell him.
We're going a little over an hour. Why don't we take a recess while they straighten out the technology, and then we'll be back.
All right for the jury. So I can mute that now. Oh, unless they're going to discuss something. If they do, I'll unmute it.
Whatever you need to do. Thank you.
It's fine. So, Erin, first guy this morning was the same guy as yesterday that we ended with. Graph or whatever his name was. So, all the defense did was try to bash him and say, are you happy with how your employees did this, did this, did this? Did you know that your employee went for lunch with him? Blah, blah, blah. But that's all. It was actually embarrassing for the plaintiff. Actually, lawyers get paid for this shit. Like, you know, I would be surprised if Gwyneth paid this witness this. I mean, look, Gwyneth doesn't pay anybody. She doesn't need to pay anybody because, essentially, Joanna, she could just settle this outside. It makes her 100% look worse if she pays anyone. So, coming into this, I was like, why did you settle with it? But now that trial's moving forward, I can understand fully why she didn't settle. I wouldn't settle. I'd be like, give him one of them. Because this is 100%, I'm telling you, a cash grab. And I hate saying that. I hate saying it. But it is. What are we to do? Oh, is it Utah? Okay, I didn't realise we were in the state of Utah for this one. So yeah. Oh. I think Big Mike's left us. Big Mike, are you still here? Hopefully we didn't upset you earlier on. That chat's been quite good today. If anyone else is here to say hi, I give 3 waves. Hi. Agree. Well, absolutely. I think we had a thing on her Erin first day. Why did she settle? Blah blah. It's obvious now. Absolutely obvious. Oh, my arse on fire, my tailbone. Went to do circuit training this morning. Whoa, had about 5 hours sleep and then straight on to circuits. Loved it though. No idea, Joe. I don't think it's gonna be long. I think it's gonna be like 5-10 minutes as normal. So I reckon we'll be back at 5 past, 10 past. But even if you, oh Jesus, this guy's making me sleep. Even if you are not back in 5 minutes, 10 minutes, wherever, it doesn't matter. Because this guy's gonna be on stand for a couple of hours, I think. So uh, yeah, I think what Giovanni was on about is paying him off to give testimony, like because that's what the defense are accusing. Sorry, not defense. That's what the plaintiff lawyers are accusing Gwyneth of doing is paying everyone off. Like involved in ski resort and stuff. So that she means she does not believe that this guy has been paid off by Gwyneth, but he would definitely get an hourly rate. Yes. Um, no, I have to look twice as well. Don't worry. So, and I mean, literally, if Giovanna had said that, like in 6 hours' time, I would have been, what? I don't get it. So yeah, I think this guy is very credible. It's just I don't. It's not that I don't stand it. He's obviously excited. He's excited. He's been looking forward to it today to tell 12 jurors what's going on. But I just don't 100% get it. I believe him, but I think he's going to be on for a long time because the plaintiffs need to cross and everything. Oh, also, excuse me, the plaintiff wants to stretch all this because the defense were going mad yesterday about not a lot of time, and now that the lawyer has said that Erin, they're not testifying. They're not test. This fits into what I'm saying. So because everything has dragged on so much now that I believe it's Moses and Apple and someone else, their testimonies could be read in from their deposition, and they're so behind the witnesses. So yesterday they're supposed to have 7, but they only went through 3. And today they got the doctors and everything. So essentially, what's happened is the judge announced yesterday that on Thursday they only have 2.5 hours currently. That means an hour each for closing. So they've only got today and tomorrow to get through all the witnesses. I don't think that's right, and I like this judge, but we need to chat rules. What rules do you want to see, Joe? Let me know. Let me know. I'll run them by Big Mike and then we'll run through it. I mean, I hope Big Mike's still here. I hope you're just working, Big Mike. Come back. I love you, Big Mike. What? Yeah. So exactly. So if they run, that's what the defense said as well. What? So the plaintiff side know this. So I wouldn't be surprised if they start to drag questioning these defense witnesses. And also, they're still got to go and interview Terry again. They've not got much time. They've only got tomorrow. The Charles will to Big Mike. Yeah, I know, but I love Big Mike. I think it brings a lot of entertainment. It's just sometimes you know when you go that extra step, you just need that collar to go. Oh, no, not quite that far, Big Mike. Well, in my chat rules, the only thing I've always said is we're all adults. As long as we don't talk politics. Like that happened yesterday. I just like I don't want people to argue over politics. If he's not, it doesn't come back in. I'll message him later on YouTube. But here he is, KFC. Yeah, because I do. I know Stacey, you and him got different beliefs, but he's a genuine nice guy, and he used to be like a lovely woman as well. So it's just different views. And we'll get a caller. I will message him. I will message him if he doesn't come back on YouTube somehow, some way. Chrissy as well as missing. I'm not sure with Chrissy. She's not here yet today. I've not heard from her. Melissa normally pops in later on. Yeah. We've not picked up a new talker yet today. We normally do, but we haven't yet today. Oh, and also, also say, see the link at the bottom, buy me coffee. I do not expect anyone to buy me a coffee. It's more of I'm trying to set some stuff up about membership and things like that, because I might do some membership stuff on that for YouTube. But on the chance that someone does buy me coffee, it's like, I'll just put it up there. Yeah, I mean, look. Big Mike has got a hard goal. He just takes it right to the edge. And as I say, as long as you know he does not mean it, he's a really nice guy. It's fine. It's just we get into stuff, political stuff. You guys go crazy, all of you. Yeah, no one's chats on Rumble though. No one does. Yeah. Whoops. Right. Sorry.
Left it in before, so I'm got left, so it's not a bad.
I got you spot on. Oh shit! Hang on.
Okay.
Dr. Sure is using the restroom.
Okay. All right. Why don't you go ahead and have the jury come in?
I've got 6 on Rumble watching, but they don't interact at all. I'm going to try and find Big Mike. If I can message him on YouTube somehow. I don't know how you do it. Stacey, literally, Carol Spy's got Starfire on her own. Just her. She entertains herself. Looks in the mirror, talks to herself. She thinks she's talking to 2 people. She's got twins. She's actually got triplets, though. Right.
Dr. Sher, you can take the stand. We're just waiting for the jury. Are you loud enough? Yes. Yeah, she's monitoring the audio.
Yes, you sound, yes, your audio's coming through.
Okay.
Rando's another one. We've not seen Rando for a couple of days either. Yeah. training in Wales as well.
Thank you, Mr. Egan. You may proceed.
Yes, thank you, Your Honor. May I approach to show the witness the animation?
You may.
So this animation is number 5, correct?
It is.
It's called Close Up. And I'm going to play it for you. Is this one of the animations that you helped prepare?
Oh, sorry, Counselor. I just see it again.
Sure.
Which number is it?
Number 5. It's called Close Up. And it's 22 seconds. So again, Mr. Schur, Dr. Schur, you're maybe explain to the jury your involvement in creating this animation.
Sure. I worked with Brian Brill at Mountain Graphics on the impact and fall portion of this animation. It's not meant to represent exactly what happened, but generally the idea of one of the family of ways this could happen in Miss Paltrow's version. We don't know some of the exact details of how they contacted, how long they interacted, but it gives an illustration of what I'm thinking, my understanding of her version, where she's contacted from behind and then fall to the right.
And does the animation make certain assumptions about various facts and testimony in the record in this case?
Yes, it does.
Okay, and you can explain those to the jury as we go through it.
Sure, yeah.
And the animation will help you explain what you said earlier about biomechanics, applying biomechanics to this case.
Right, exactly.
Okay, so permission to publish this to the jury, Your Honor?
Just, we assert our ongoing objection to the animations or cartoons. They lack foundation, distort the reality, and are incomplete.
So animation number 5 is received for demonstrative purposes only to help this witness explain his testimony.
Thank you, Your Honor. So, Dr. Schur, I'm going to let you take the reins here and use it as you need to explain, okay?
Thank you.
Is that all right?
Your Honor, we also object to the extent that this witness hasn't testified to any of the placement of any of the other skiers or bodies in this animation.
Mr. Egan, is that relevant to this witness's testimony of the other skiers?
No, he's going to talk about the collision itself.
So you should ignore any of the other skiers that are shown in the animation.
Okay, so you can reverse it, Dr. Schur, to just before the collision, so we can focus on that and explain what you mean to show by this animation.
Maybe I can't. How do you?
You could press play again, and it will get to it.
Oh, here we go.
Okay, there you go.
Yeah.
Okay, great. So take us through, if you would, Dr. Schur, what this animation shows from your point of view as a biomechanics expert.
Sure. The first thing that you should be aware of is that this is Miss Paltrow's version of the events. So,
Dr. Schur, sorry to interrupt you.
Oh.
Just maybe pull your mic.
Sorry,
Yeah,
sorry about that. The first thing to be aware of is this is Miss Paltrow's version of the events. So that's what we're showing here. And as we move forward, I'll talk about the physics, kind of like what I drew earlier with the center of mass and the rotation. And that's the idea. That's what went into this. But again, this is not exactly what happened. This is just one of the possible ways it could have happened. So we have Miss Paltrow in black, Mr. Sanderson in the blue as they move forward in time. It's her testimony that his skis slid between hers. There we go. She felt a contact directly in the back, along her back. It sounded like her buttocks as well. The person was grunting, pressing against her, but they were on their skis for a period of time. If in this situation, he's also moving to skier's right, which is in the left in this image, that will create, remember I had the force that was offset from the center of mass. That's going to create a rightward motion for her, but also create some initial rotation. Now, in this portion, there's a number of possibilities. She could be adding weight to her right ski because of the contact from Mr. Sanderson. When you ski, if you're in, let's just take a snowplow or what my kids call pizza position. If you weight the right ski, you turn left. So if she weights the right ski here more because of the contact, she's going to turn counterclockwise. The contact from Mr. Sanderson, if it's more to the right, will turn counterclockwise. So as they're moving to the right here, there would be some counterclockwise rotation. And here, her ski can catch, or she could pitch to the side, or they could both pitch to the side. They could both lose balance. We're not sure what happens. But as they're rotating, they're continuing to fall. And Miss Paltrow's version has them spooning essentially as they're coming down together, which would make sense if their legs got caught up. If he was contacting her below her center of mass, where his right leg was contacting her right leg, her thigh in that area. Also consistent with Miss Paltrow saying that her right knee was splayed open at the end and she felt right knee discomfort. That all could happen there. So as she's rotating and he's rotating counterclockwise, they fall to the side. Now, at this point here in the animation, I guess maybe the next frame, if I can do it. Mr. Sanderson lands on his right side, maybe the right back. It's hard to say. If he lands on his right side, kind of like Dr. Bayham said, he needs to land on the elbow, that can happen. That can create lateral rib fractures. But that's not the only way. His arm could be out. He could land on the side and create lateral rib fractures. He could land on his side and a little bit towards the back, and Miss Paltrow could land on him. She could be fully on him, maybe with her buttocks or her back or some portion of her mass compresses his chest front to back, and that can create his rib fractures. There's a lot of different ways this could happen. I can't tell which one of those is right, but all of those are consistent with her version of the events. As they hit the snow, they would continue to move forward until friction slows them down. And it's also important to note, we haven't talked about the head injury, but hitting the back of the head or the side of the head, he could have his head turned. All of those are possibilities for him to contact his head on the snow. So that's not inconsistent as well.
Would it be helpful to show it in real time? You've been doing it kind of slow motion, which has also been very helpful. Maybe start from this beginning and just play it.
Objection lacks foundation for trajectory, speed, and direction.
Overruled. It's demonstrative of this witness's testimony only.
All right, thank you.
Okay,
Sorry, yeah, go ahead, Dr. Sherman.
This is from the beginning.
And if there's anything you want to comment on as it happens, feel free.
I think that accurately reflects the version that Miss Paltrow testified to that matches the laws of physics and biomechanics as I understand them.
And would it be helpful to show, there's one other animation that has a little zoom in from the other angle. Would that also be helpful?
I think, yeah, it can't hurt.
Let's show that then. Permission to approach, Your Honor, for that.
Okay. What's the number of this animation?
This will be number 4. It's called Zoomed Inside.
What was the last one, James?
Number 5. Oh, sorry. Yeah, thanks. Okay.
Wait just a second.
Yeah, really, it was more of a. Yesterday was talking about Trump. Today.
Okay, Dr. Scher. So I'm playing you number 4, the zoomed in from the side version.
Oh, and stuff like that.
Were you a part of creating this version as well?
Yes, this is the same animation, but from a different camera view.
Got it. And will this animation also help you explain the same things you've been going over with the jury?
It's the same thing, sure. Yeah, I think it also visualizes, it illustrates my opinion.
Okay. Your Honor, permission to show this animation.
Subject to the same objections by the plaintiffs, the animation 4 zoomed inside is received for demonstrative purposes only.
If Mike Aaron thinks that California's a shit though.
Okay, thank you.
Oh, if the states will go back and forth.
Dr. Scher, maybe since we've already gone through this slow motion, let's just play this one from the start, and then you can add anything that you can provide to the jury from this angle.
Sure. Here, let's play first, and then there we go. I'll wait until the contact point. So it's coming up. Here we go. There's contact, fall to the right. This one doesn't show the rotation quite as much, and we don't know the amount of counterclockwise rotation as well. There could be a little, there could be more or less.
Right.
We're not sure.
But if you go backwards a little bit into the moment of the collision, this one maybe shows, does this one show the skis coming between the skis?
Yes, it does. And I think it's better visualized in this one.
Yeah, and again, what's the significance of that in terms of how the mechanism of the fall occurs?
Well, that's Ms. Paltrow's testimony, and it works for the physics of them falling and rotating slightly counterclockwise. Frankly, if it wasn't both skis, if it was one ski between hers, the kinematics would be the same. For example, if his right ski were on the outside of her right ski, it wouldn't change the general kinematics. This is generally, and I keep saying generally because we don't know the exact details of it, this would work.
So if we flipped the positions of the parties and Mr. Sanderson was in front, Ms. Paltrow came from behind, using this as a good visual for the jury, will you explain your opinions about what we would expect to happen on Mr. Ramon's account, I should say?
Well, Mr. Ramon's account is very different because in Mr. Ramon's account, Mr. Sanderson goes spread eagle and his skis go out into that V and the inside edges catch. And that changes the kinematics, the motion. It's a very different version of what happens with the contact.
And in terms, I guess we've covered that. So maybe we'll wrap up here. You've covered a lot of things, a lot of new things perhaps for members of the jury and those of us in the room. Will you summarize for us what are the main points that you want to get across for the jury here?
Sure. The first is that Dr. Boehm cannot say with any accuracy that Miss Paltrow landed on Mr. Sanderson. His calculations are wrong. And when you look at the equations done properly, Mr. Sanderson can land on the snow and sustain his injuries without Miss Paltrow falling on him.
And if I may, Dr. Scher, was it your understanding that Dr. Boehm's opinion was that his account was the only possible way the injuries could occur?
Yes, Mr. Ramon's version was the only possible way. He said Miss Paltrow's was impossible, which I believe is false. I think Miss Paltrow's version is possible.
Right. And would you say that Ms. Paltrow's is the more likely of the two accounts?
Well, considering it's the only one that matches with the physics of what would happen in contact, yes, I think so.
Okay, and I interrupted you. You were going through your main points. What was the next one?
Well, I think we've covered it. The second thing is that Dr. Boehm cannot say that Ms. Paltrow's version is impossible. That's absolutely wrong.
It sounds like you're saying, in contrast to Dr. Boehm, that there are various ways this accident could have happened. The injuries could have occurred for Mr. Sanderson. Is that right?
That's correct.
And you've evaluated the various testimony, correct?
I have.
And you've done a careful analysis from a biomechanical engineer's perspective on what different scenarios might be likely or how they would happen, correct?
Correct.
And is it your opinion that Ms. Paltrow's version is the more likely of the two versions that you looked at, Mr. Ramones and Ms. Paltrow?
Yes, once again, it's the only version out of the two that matches with the laws of physics, the biomechanics of it.
Okay. Anything else you'd like to tell the jury that maybe I interrupted you on and you missed out on?
No, I think we're good.
Okay, thank you. And that's all for now, Your Honor.
Can you keep the screen there?
Sure.
You can turn it off. Well, actually, leave it on for right now.
On or off?
On.
Okay.
Morning, Mr. Or do you prefer Dr. Sure?
Sure, that works.
Sure, Dr. Sure. This version right here. Can you back it up about to here on the scroll?
To here?
Yeah, and then go forward it out halfway between the last one. Okay, a little farther. Just before when Mr. Sanderson, who's also
Maybe it's easier if you do it.
well, could you just go a little bit farther forward? Just go slowly. I just want to get Mr. Sanderson, who's sometimes called Dr. Sanderson.
Mr. Chair, would you mind putting on a remote that allows you to be picked up?
Okay, how about let me use this?
Sure.
Is this working? Oh, wait, now it is. Okay, go a little farther forward, please. Okay, and then when we get, okay. Now, this is Terry Sanderson.
That's Mr. Sanderson, that's right.
Okay. So his right eye is, okay, go a little farther. Now, just another fraction, just a little bit farther. Okay. So you have his head turned. That's based on your testimony that he is looking down the hill, I guess. Is that what you're saying?
I believe his testimony is that he's looking at a woman who's a little downhill to the left. He notices her, looks at her. I don't remember what the exact words are.
Okay, go a little farther. So his head, his left eye would be looking directly at Miss Paltrow. He would see her, right?
I believe so.
And it's inconsistent with his testimony. He didn't see her at all.
That's correct.
Because, but he would see her there, wouldn't he?
I would think so.
Okay, go a little farther, just another fraction. Okay. Now, in this picture, you don't have Dr. Craig Ramon in there. How far above would this point be? Where I just pointed, how many yards would that be above this image right here?
I don't know without doing a measurement, but I'm concentrating on the collision between Mr. Sanderson and Miss Paltrow.
Well, Craig Ramon testifies he was about 30 to 40 feet above. So these objects are about bent over, maybe 5 feet high. So if we just flop over, 6 bodies, we'd get to 30 feet. That would be about right here.
I'm not sure.
Well, you're an engineer, highly trained PhD. You can't even guesstimate that that would be about 30 feet.
I can't tell.
Would up here be 30 feet? Don't you think it'd be a lot more than 30 feet?
Probably, but I don't know.
Well, you helped create this animation. You don't know the distances in your own animation?
No, I've concentrated on the collision portion. That's the biomechanics portion.
Okay, who did the estimates or guesstimates of the distances of the bodies of the other people?
So that's going to be Mr. Boggart, who's going to be on soon, I assume.
Okay, so this animation doesn't have Craig Ramon in the scene at all?
Not at this point.
Okay. Is it because the defense doesn't want him in the scene, so to discredit his witness account?
Oh, I don't think that's the case at all. You'll have to ask Mr. Boggart.
Okay, we will. Okay, let's see. Just go another little section.
Fucking arsehole this guy is. Hate him, this lawyer. 100% Rosie. Exactly, 100%.
You just tell me when. I'll keep going until you say
Just
stop.
go slow. I just want to go slow motion. Okay, now stop right there. Now, do you know the time, how much time from the initial, let's say, impact of their bodies to this point would be? You did this calculation. This is your bailiwick. What you're talking about.
Do you mean in the animation or do you mean in real life?
Right now. Yeah, from the impact to this point, approximately. So like a fourth of a second, a half a second, a tenth of a second.
Ms. Paltrow says that they're in contact for a little while, a few seconds before they fall over. So I don't know what it is in particular in this animation, if that's what you're asking.
So you helped design this part of the animation, so you don't know how far it is. You just guessed it.
Again, we don't know exact timing and distance. This represents an illustration of the version. So, yeah, it is what it is.
It's an illustration of the version, but there could be wide variability in that version, right?
There is variability, but we have constraints on it.
The constraints are, it could have happened the opposite way, right?
The opposite way.
Ms. Paltrow hit Terry Sanderson.
No, I don't think so. Not with the testimony that's given. We have two versions. We have Mr. Ramon's version, and we have Ms. Paltrow's version. This is Ms. Paltrow's version. Mr. Ramon's version is very different.
Okay. Let's talk about that for a second.
I hate this guy with a passion. Vanilla, I much prefer vanilla over hazelnut. I would take hazelnut, but
just
vanilla.
You're being paid, excuse me, you're being paid, what is it, $4.25 an hour for this?
No.
Is it more than $4.25 an hour?
It is.
$4.50 an hour?
Nope.
500?
It's 500 an hour.
500 an hour.
What a dickhead.
And you billed something over $10,000 so far for your work?
That sounds about right.
More than 15,000?
No, I don't think so.
So between 10 and 15,000. Okay. You can turn that off for right now.
I think it's probably better.
Yeah, it's all about the money for the defense, for plaintiff.
What's the best way to do I just disconnect it? Is that? Yeah, maybe just disconnect. That? Okay.
This is the only argument they got is, oh, they spent so much money. Just
No, you're here to teach the jury, right? The defendant's version, correct?
Teach the jury the physics that would be helpful in understanding how to assess the accident.
So that's a no. You're not teaching the defendant's version.
I'm not teaching any version. I'm teaching the physics and mechanical engineering, biomechanical engineering that would help the jury.
I know it's hard for expert witnesses to say yes or no, but are you teaching the defendant's version?
I guess I don't understand the question.
Okay. Seemed like a simple question. Next, I'd like to talk about, did you review Dr. Gibby's testimony at trial?
No, but I did see some of his trial testimony.
All of it or some of it?
Some of it.
Was it more than 10 minutes?
Probably, yeah.
More than 20 minutes?
Yep.
More than an hour?
I don't think more than an hour.
Okay. You didn't disclose anything about hearing Dr. Gibby's testimony.
I'm not sure what you mean, but I did see it.
Okay. You've never disclosed to the plaintiff your reports or your testimony ahead of this trial, correct?
Your Honor, may we approach?
Yes.
So here we go. So literally all they're trying to do is discredit A, the money, and B, now, or he watched some testimony. He wasn't supposed to do that. Literally, it winds me up. They haven't got an argument back, so they're just trying to play dirty. Very disappointed. I've had my rant about this is a cash grab. Nancy, it's your first time here. How are you? Hope you're well. Don't worry, Stacey. We'll keep you updated. You're not missing anything. It's fine. You're right. Nancy, this is your first time here, I believe. So, hello. Whoop. Everyone gets a wave. Hello. Sometimes a kiss as well. Cheeky one. So, yeah, thanks for joining. Please subscribe and like the video, Nancy. Appreciate you. Dreadful. Yeah, I mean, it's going to be constant. But it's starting to piss me off, though, because not that going up this, but it's like the lawyers have nothing. Their only questions are, what's your rate and how can I discredit you? They generally think that the jury is thick. Maybe they are. I don't know. But I'm annoyed with it. And I hate getting annoyed. I like to be happy. Hopefully everyone gives Nancy a welcome if she's still here. Big welcome, Nancy. Rosie, got a bone to pick with you. You prefer Italians over Welsh people. I'm gobsmacked. Here we go.
Are you an expert on broken ribs?
I am comfortable talking about the biomechanics related to rib fractures.
Have you done any papers or studies or research on ribs and rib fractures?
Me personally, no, but I've read the biomechanical and engineering literature relevant to them.
Okay. You haven't mentioned that biomechanical literature in specifics, correct?
I'm not sure about in specifics, but I think we mentioned it on direct.
Okay.
He's testified a lot, probably.
So you said that Dr. Sanderson, or I'm just going to call him Terry. Terry was 70 years old at the time of this crash?
It's 69, but effectively 70 for biomechanics purposes.
Effectively because 70 is older?
No, because there's actually good information in the biomechanical engineering literature about the amount of chest compression required to create rib fractures for 70-year-olds.
And not 69-year-olds.
Well, it's actually the full distribution, but the paper that I'm thinking of from Agnew specifically talks about 70-year-olds.
You didn't mention that paper today.
No, but would you like it?
Not right now, thanks.
Fuck you.
I've not seen it. Let's see.
Answer, Rosie.
Well, I'm going to go right to another point. You have this theory of rotation, correct? That the version you're calling Miss Paltrow's version is a kind of a rotation version?
There is some rotation. It may be a little. It might be more than a little. We don't know.
Okay, so we don't know how much rotation there is, correct?
Sure.
Okay. I'd like to, let me see what this thing works. It didn't work last time. Guess it's working now. May we take a picture of this?
I think you've already done it.
Okay.
Or someone on your team has.
Okay, good. May I borrow a pen?
Your Honor, we would object to him writing on the witness's board.
It's not an exhibit. It's certainly fair game.
Okay.
So, Dr.
Can we mark it as an exhibit, Your Honor?
Why don't you take a picture of it and you can use that and then he can
Go ahead,
add,
take a
he can
picture.
add to it.
Okay.
It is our board.
Right, and in academic
We don't
fields,
have any questions right now, so.
in academic fields, it's common that people write on each other's drawings, correct?
I don't know that I've seen that, but I don't have a problem with you drawing.
Okay. So, you testified that Craig Ramon says Terry was hit directly in the back and they went down, and Craig Ramon was somewhere above 30 to 40 feet. And it happened in a fraction of a second, correct?
Yes, the fall, I would agree with that.
Okay, less than a second.
Sure.
Okay. So there was a scream. So and the scream occurred, and there was within a fraction of a second. And I don't believe Craig Ramon never testified where Miss Paltrow's skis were.
Correct.
So her skis could have been going underneath Terry like this. The pink ones would be Miss Paltrow's skis. Is that a version that is possible?
It is not.
It's you're saying it's not possible.
That is not possible with the version that Mr. Ramon states.
His version didn't talk about her skis. Now here, I'll draw what her body. The pink would be her body, still square in the back.
Pissed.
Isn't that possible?
So no, with Mr. Ramon's version, if I may, that is not possible. So in this situation here, when Mr. Sanderson's skis go into a V, and I guess you're saying her skis are under his skis, which I'm not sure how that happens because the tips curve up, but we'll go with it. Somehow she winds up in this situation getting caught with her left ski around Mr. Sanderson, and she would not continue past 5 to 10 feet, and I would expect a twisting release of her left ski.
Well, that's her version. I'm talking about Mr. Ramon's version.
No. I'm talking about what you just drew for Mr. Ramon's version.
Mr. Ramon's version, well, isn't it possible her skis could be pointing straight like this? And let me get it right here. So, yeah, so she could be going straight and she could be turning left and up and hit square in the back, but her skis are pointed this way. Isn't that another version?
So for her skis to miss. Oh, no, it's not. Do you want me to explain?
In a second. I'm asking the questions here. So so are you saying that her body could not be turned while her skis are going in one direction or she's turning up to the left? Is that possible?
Not for Mr. Ramon's version. Is it possible in general? Sure. But in her version, I'm sorry, in his version, no.
This happened in a fraction of a second. I don't think Mr. Ramon testified that he has a videographic or photographic memory. Do you?
Well, he's pretty particular in his testimony about how she was on Mr. Sanderson's back.
Right, and he could, you see the circle I have? Let's see, well, actually, maybe I could do it I've got it wrong. Let's do it the other way. Her body could be like this, and her skis could be like this too. And people turn all the time while they're skiing, and their skis are going one direction, but their body is pointing a different. Right here. Can you see me? You see that?
I see you turning, sure.
That's possible, right?
What you're doing in general is possible. Are you asking, does that match with Mr. Ramon's testimony? No, and I'm happy to explain why.
I think Mr. Ramon's testimony is, it happens in a fraction of a second. Mr. Ramon, a professional wannabe freestyle skier, likes to talk about ski angles, but the main part is the body. He saw the body, and then the bodies go down together. She lands on top of him. You're saying that your versions, which are not based on anything except your recreation of the biomechanics, are superior to an eyewitness. Isn't that what you're saying?
No, we have two versions of the accident. We have Mr. Ramon's version and we have Ms. Paltrow's version. I've assessed both using physics and biomechanics, and I'm sorry to say Mr. Ramon's version does not meet with the laws of physics. It's not consistent, internally consistent, and Ms. Paltrow's is.
Well, I don't think Mr. Ramon's version was designed to be consistent with the version of events. It happened in less than a second. And we don't know the direction of the skis. In his version, he never testified to the direction of Ms. Paltrow's skis in any of his testimony. Isn't that true?
He did not testify to the direction of her skis. That's true.
Thank you. So if Ms. Paltrow was seen down, turning up to the left, she hits Terry Sanderson square in the back, and they can fall down to the right, especially if her momentum is going, well, you know, I'm not a biomechanical engineer. I'll try to do it right here.
You're a fucking lawyer, mate.
It'd be her shoulder that hits him square in the back, couldn't it? He didn't say what part of Miss Paltrow's body hit Mr. Sanderson, did he?
He did not say. He said, well, here, I can tell you exactly what he said. He said,
Take your time.
You're just making this witness look great.
he said squarely in the back. She couldn't have hit him in the back any better right in the middle than if she tried. And she couldn't have been back on his back any more than if he would have strapped her on the back, like a backpack.
Okay, but that doesn't mean her body was straight.
Might not be exactly straight.
Yeah, it could be off center because she was skiing down. She's like this, and she hits him right in the back. Or maybe it was a little off center because Mr. Ramon only had the view for a few seconds. And her arms wrap around, her arms could have wrapped around Terry Sanderson, right?
I don't think there's any testimony about that. Is it possible? Maybe, but
Well,
I don't
where
think
would
there's
they have gone? Down to the side? She went in like this?
In front of her,
I mean, the most likely, don't skiers ski like this usually?
often.
Often? What are the other positions?
They can have her arms in more,
Okay,
can
so
have them out more,
she could be like
have her arms
this
down
and
to her
turn like
side,
this.
and the poles heading back.
Okay.
There's all sorts of options.
So in that fraction of a second, Mr. Ramon saw the collision. The screen was up here. He turns his head, and she could hit him square in the back. She could have her, at that point, her body could have turned and possibly hit her. But the point is, the skis could have been going at a different angle, one or the other, and still cause this crash. And your versions assume those are not possible because you assume that there's only one way that their skis were going parallel to each other. This is your only assumption, right?
Wrong.
You made assumptions that these are possible,
I looked at other angles. That's right.
and the testimony though, you said there's no testimony about the angle of her skis from Mr. Ramon, correct?
That's true.
Louis got a job to do, Buff. Mate, just sit down. You lost this one. You're just making this doctor look great.
You've made a lot of assumptions to make these.
Yes and no.
I thought that would be a more than one assumption.
There are
That's
some
yes or no.
assumptions. One assumption.
Okay. Less than 100?
Sure.
Less than 10?
I don't know.
Correct?
That's right. Sure.
Okay.
This is just laughing, going, yeah, sure, mate. Whatever you want. Whatever fits your narrative, we'll go with it.
Now,
Oh, absolutely. He's done this for years.
no counsel, Mr. Owens likes to do this a lot, like it's a touchdown. But on redirect, Mr. Ramon, did you see all of his testimony for this trial?
I don't know if I saw all of it, but certainly I saw a lot of it.
Okay. You saw the testimony last week, correct?
Is there any more than that?
There was a little bit yesterday.
Okay, I didn't see anything
Had nothing
yesterday.
to
I
do
was
with this.
traveling.
Had to do with that Mr. Ramon reported what he saw the same day and the same week 7 years ago. And you're recreating this, what, about 5 months ago, correct?
I don't remember when it was.
Less than a year ago.
I don't recall.
You don't recall when you consulted with Mr. Brill and made the animation?
This has been ongoing for a while. This case has been dragging on, so I don't know when it was.
Nasty pants. I think.
So you've been working on this for, let's say, more than a month?
Sure.
You don't know?
With counsel for longer than 8 months.
And for the record, Your Honor, I'd like to move this trial with testimony because it's disclosed improperly. I anticipate the rule, but I just wanted for the record to make the rule.
It's overruled. It was disclosed properly, counsel.
Okay.
What a friend.
What I'd like to do is understand that you've made a lot of assumptions, and the jury would like to know how reliable your opinions are. So how can that be reliable when you totally discount some major events like what the direction of Miss Paltrow's body was compared to her skis? And there is testimony about Ms. Paltrow's body movement. Do you know that?
I guess I don't
Prior to the
understand.
crash, just prior to the crash?
What version are you talking about? I don't know what you're talking about. Sorry.
Do you know about the version of Carrie Oakes?
I don't think she saw the accident.
Have you read her deposition?
I have.
Okay. You realize she testified that one of the kids said, "Mommy, watch us ski." And the kids were up there on the left. Ms. Paltrow was down on the right, which would tend to show that Ms. Paltrow was looking up to her left at the point of collision.
I don't recall that.
Okay. So you're
didn't see that.
you're excluding Carrie Oakes' testimony, correct?
That's wrong.
You're including her testimony?
I considered it, sure.
And are there any assumptions you've made based on her testimony?
Not in particular that I can think of, but there may be.
So could you speak up?
Not in particular that I can think of.
Okay. Not that you can think of Carrie Oakes' testimony, okay?
Oh, he's stumbling because he doesn't know what to
Are you an
ask.
expert on head injuries?
I'm comfortable talking about head injuries from the biomechanics standpoint.
Have you ever studied or held yourself out as an expert on concussion?
If it's diagnosing or treating concussion, no. If it's the biomechanics related to the formation of concussion, yes, I've done helmet research and head injury research, in particular for snow sports.
Did you apply any of your knowledge about concussion to this case?
I certainly looked at it, but Dr. Boehm was very particular in his testimony that it was only the rib fractures that allowed him to say that Ms. Paltrow contacted Mr. Sanderson from behind. So that's what I concentrated on for the jury.
And you ignored his discussion about the head injury?
Oh no, I certainly considered it.
And it's not relevant in this case?
Well, in disproving Dr. Boehm, it's not relevant, but I'm happy to talk about it.
Well, it's not clear you disproved Dr. Boehm when you don't even know the direction of Ms. Paltrow's skis at the beginning of this. It's also, I think, a big assumption to say what the body position of Ms. Paltrow was when she hit Terry Sanderson in the back.
Sustained, and was there a question in there, counsel?
Just if that was accurate, I'll withdraw it.
He's trying to get his testimony thrown out because this is bad for him. This witness is really good. He's trying to discredit him. That's why he wants all his testimony out. Because also he's listened to some previous testimony from Craig. And he's saying, no, that's not fair. Because he did disclose that he...
So you've never studied rib injuries. Have you ever testified about rib injuries before?
Could you clarify what the question is?
Have you ever testified about them in the past?
That sounds like two questions.
Have you ever testified about rib injuries in the past?
I don't recall, but it's likely.
Most likely you have?
I think so.
How many,
They're
have you
common.
testified more than 100 times?
In trial, probably 35 times, something in that ballpark.
In total, under oath, have you testified more than 100 times?
Including depositions, yes.
More than, less than 200 times?
I would agree with that.
Okay.
He's just so confident, this guy. So his shit. When you're not lying, it's so easy.
Just check.
I mean, what was the point of that? What's the point of this cross? Oh my days.
That's all I have.
Thank you, Mr. Bueller. Mr. Egan?
Thank you, Your Honor. Dr. Scher, we'll just be real quick here. Did anything Mr. Bueller asked you change your opinion that Ms. Paltrow's account is consistent with the laws of physics to your understanding and Mr. Ramon's is not?
That remains the same.
Thanks.
Mr. Bueller?
I think you said this before, that you're an expert in the laws of physics, but you're not an expert in medical medicine or orthopedics or neurology, correct?
I am a biomechanical engineer. I am not a medical doctor. I do not diagnose and treat, but I do look at what forces and what motions create damage to the body.
You may step down.
Thank you.
Thank you. May I call your next witness?
We call Paul Bogger, Your Honor.
Thank you.
Your Honor, before Mr. Bogger comes up to testify, we may want to take a 5 or 10 minute break. I want to address something with the court outside the presence of the jury.
We'll have to take one shortly anyway, so let's go ahead and do it now.
Oh, jeez. So hopefully everyone, look, literally, as I said, they're clutching the straws. It's like, what? Can't do it. Muppets. So, yeah, just to clarify, trophy totally due out, Your Honor.
Ms. Van Orman?
Hang on, we'll listen to this first.
Your Honor, pursuant to our motion in limine, Mr. Bogger's testimony is going to be significantly limited in this case. The problem that I am foreseeing is that I could be wrong, but it appears to me that counsel is going to try and use Mr. Bogger to then describe some further animations and place individuals on that animation. And I have significant concerns with that for a number of reasons. Number one, Mr. Bogger's not qualified to do that. He didn't take any kind of measurements, calculations, determinations of speed, force, physics in this case. But in addition, in his report, he doesn't make any mention of where people were, where they were placed. This would any kind of discussion of him talking about the animation, and if he was responsible for putting the people somehow on that animation, he does not describe that in his report. He doesn't talk that in his report regarding participating in an animation. He provides no diagrams in his report, no discussions of where people were or weren't. So I don't think that it would be appropriate for him to even deal with the animation, or that his testimony that he's the one that was responsible for putting, say, Apple here and Moses here and that type of thing. That would go significantly beyond anything he did in his report. So that's my concern, and I wanted to address that now rather than a sidebar.
Thank you.
John, may I take a photo of this?
Sure. Mr. Egan?
Yes, Your Honor. So I think our response would be that Mr. Bogger has poured over the records in this case, and he has, in producing these animations, made certain assumptions about what testimony might be consistent with the illustration that the animations provide. He can be very clear with the jury that he's assuming certain facts. He's not finding these facts. He's assuming that they're true. They come from the record. He can explain that they're rough illustrations. He's not made measurements and decided that, yes, this is exactly 30 feet. He can be subject to cross-examination on any point that might be inconsistent with testimony. He can explain that he chose to assume these facts and not other facts, and that if you assumed other facts, you might get different illustration. And then he'll explain that the assumption of various facts that are shown in the animations are consistent with his understanding of ski collisions and skiing generally, which he has decades of experience, not just with skiing himself, but with investigating accidents, collisions, hundreds and hundreds of them for various purposes, mostly not litigation, mostly to figure out risk management concerns, deciding whether certain skiers have to be banned from a certain resort or a ski area. he has ample experience to be able to discuss how to consider various factors in evaluating a ski collision like this that has complex testimony that's not all consistent. And the jury, in our view, needs to hear from a ski expert that knows how to do that and can explain to them the principles that he uses. He will not tell the jury this is likely what happened, or that I have found that this must be the case. He will say, I've assumed these facts. He can be very clear about what he's assumed, and then use that animation to explain to the jury how to think through the case, given his ample experience with evaluating ski collisions.
So, Mr. Egan, I guess I'm still not hearing an expert opinion from Mr. Bogger, is it?
Mm-hmm.
That would have helped the jury. I mean, everything that I'm hearing has him weighing evidence, has him making decisions about what may have happened on that day. And that's invading the providence of the jury. It's not really going to help them.
Your Honor, I see it as like, say, a medical malpractice case, which I'm more familiar with. If a certain set of facts might be in the record about what happened in a surgery, for example, then a surgeon, expert surgeon who has lots of experience reviewing records, but also doing the surgery himself, knowing what the training is, looks at the records, look at the various claims, and you, as you said in your order ruling, I believe yesterday, can say, if we assume these facts, given my expertise, I can say this makes sense, or this is consistent with my understanding of surgery. And so my proposal is that we use Mr. Bogger in that sort of way, where he can help the jury understand, given what he knows about skiing, and given what he's seen in the record, that there are certain principles you can use if you assume certain facts. Evaluate a certain collision such that you're applying some rational principles rather than just generally going with a certain gestalt feeling about what someone said. You're actually trying to rationally go through how to evaluate a ski collision, which again, he has decades and decades of experience doing. And he won't say, he'll say to the jury, you're the ones that have to decide what happened. This is a very difficult case to decide.
Isn't your medical malpractice expert example, isn't that an expert that's to evaluate whether the standard of care was breached?
Yeah, well, so yes, usually we would offer an expert in that way, but given your ruling, I'm just trying to use that as an analogy where we could still use expertise that would help the jury without rendering that final opinion, telling them, as an expert, you should do this, and I'm really the one that knows because I have tons of experience. Instead, he can say, here's how I evaluate these accidents, and let me show you how to do it. And then they have rational principles that come from his field of skiing and ski accident evaluation that help them, that they have not heard. They haven't heard from any ski expert that has provided to them that kind of a rational layout for analyzing the various complex claims in this case. And I think that would help them.
Sure. And I think in my preliminary ruling on this witness yesterday, I'm losing track of the days here.
Me too.
I think I stated that he is qualified, certainly has qualifications, and can testify as to what a reasonable skier would do or not do in a certain hypothetical set of facts. But in terms of applying and weighing the evidence in this case, I think that goes too far.
Okay, so but if we showed the animation and we made it clear to the jury that we're assuming certain facts, we're not weighing them. We're just saying, look, let's take these facts. We're assuming them. We're not saying that they're proven. We're just showing you how to analyze the facts, assuming these various parts of the testimony are true. That would be too far, you're saying?
That sounds like closing argument. It doesn't sound like what a witness can offer under Rule 702. He can talk about, I mean, he's an expert in skiing. He can talk about skiing dynamics. He can explain what a snowplow is, what parallel skiing is, what the rules of skiing are generally understood to be. But in terms of taking that next leap, I don't think he can say, I've looked at the deposition testimony and I can tell you who's at fault here, or I can tell you who did something wrong here. I just don't see, I think that's the jury's responsibility. And I don't want a witness telling the jury how to make its decisions or how to make a decision that's either an ultimate issue or one of the issues leading up to that ultimate issue.
So even him explaining his process for how to evaluate ski collisions would be too far?
To what end? Why does the jury need to know how he evaluates a ski collision?
Because evaluating ski collisions is a complex matter and he has expertise as to how to do that.
Yeah. You know, right now I'm just talking or I'm responding to your question sort of in a vacuum. I don't know what it is he's offering.
If it would help, I could give you kind of an example. Like,
sure.
If I could say, Mr. Bogger, when you evaluate ski collisions and you've evaluated, have established that he's evaluated hundreds of ski collisions. Have you ever evaluated collisions where there's conflicting testimony? Yes. When you approach that testimony, what are principles you use to evaluate that? And he can explain those principles. He doesn't have to talk about the facts of this case. He can explain, here are these principles. I don't think the jury's heard that. I think it would be helpful to them. I think it would be rational and it wouldn't be overbearing.
You're asking him how he evaluates credibility.
I guess that's true.
How does he reconcile different accounts?
Right, but we wouldn't, if given your ruling, we wouldn't go into applying it to this case. We would just give them the rational principles that would help them weigh the evidence. It wouldn't tell them how to do it. It would just give them a framework for doing it, which only he can provide. They have not heard from somebody that does this for a living, has done it again.
And how does that vary from what the jury does? If you look at the credibility jury instruction that I've already read, for example, how does that differ? I mean, where it talks about conflicting testimony, how does what he's offering provide any specialized knowledge? I consider that generalized.
Yeah, so I don't think he would just talk about, general principles of evaluating witnesses. He would talk about particular aspects of a ski slope or witnesses on us. If he were here right now, he could help me.
He is right.
Yeah, right. He is right here.
So when ski accidents happen, and people go to the ground, their skis get released. I could see that as specialized knowledge, just like this witness offered something along those lines.
Yeah, no, that is an important thing. He can explain.
But in terms of this skier said such and such, and this skier, but this is how I evaluate that aspect of it. I think that's invading the providence of the jury.
Okay.
On deciding how to weigh testimony.
Okay. I mean, for the record, if I may, Your Honor, I think we put this on before, but in case we didn't, we believe the motion to exclude Dr. Bogger or limit his testimony is untimely, and that Greg Skordas, their expert, whose report does much the same thing that Mr. Bogger's report does, should be limited in the same way. Again, just renew our request that he be able to speak to the jury about his evaluation of the ski accident.
So just again, my sort of ultimate conclusion on what I'm hearing on this motion to reconsider and on the response from the defense is that it's up to the jury to decide ultimately what the parties did, where the parties were positioned, and who ran into whom. So it's up for the jury to make those decisions. So as long as this witness steers clear of those areas, that's the main emphasis of my preliminary ruling, and I'll have to hear what's being offered.
Okay. Do you mind? I know I'm not an old man, but my memory has failed me. Those three again. Who hit whom? Going backwards.
It's up to the jury to decide ultimately what the parties did.
Right.
In other words, leading up to, during, and after the accident. It's up for the jury to decide that. and various experts have given them some helpful information, like the biomedical expert gave testimony as to what the biomedical evidence reflected that would help the jury make that decision. Just like this past witness gave the jury some biomechanical information that will help the jury make their decision about what happened in that accident, what the parties did, where the parties were positioned, and who ran into whom.
And the reason that you see Mr. Bogger as doing something different than, like, say, Dr. Schur just did, who took the jury through assuming these various facts. I'm not telling you that this account is true. I'm just taking as an assumption what Ms. Paltrow said was true. Let's analyze it. You're seeing Mr. Bogger as different, and I'm not totally sure how. Do you mind explaining that?
The plaintiff's witness applied biomedical principles in a methodical way to the different versions and then handed the jury that information. The biomechanical expert that just testified applied biomechanical principles to the different versions and gave that information to the jury to help them make a decision.
Okay. So,
and what I see this witness doing is reading different accounts and reconciling them and wanting to give his reconciliation to the jury, which I think is too close to what the jury actually does. It doesn't help the jury from an expert standpoint.
okay. So it sounds like you're not persuaded that of our position, which is that he has skiing expertise similar to like a biomechanical engineer has, and can apply that to the facts in a way that would provide the jury with some, again, rational scheme to assess the accident that they wouldn't have otherwise.
Under Rule 702.
Right. Okay.
And the same is likely going to hold true to Mr. Scortis' testimony.
Okay. And you say likely.
I've heard you make kind of a motion. I haven't heard from the other side whether they're opposing that in some way.
I see. You're just waiting until you have more specific.
If he's the same type of an expert, and I realize that he may not be a risk manager and he may not be a ski accident investigator for an employer, but it sounds like his testimony is along the same lines.
Right. Okay. So just in terms of guidance on this ruling, you mentioned the bindings, and I apologize for going long. I just want to make sure that we
specialized knowledge,
right?
So that can help the jury in making their decision.
So in your mind, would something like recognizing that the positioning of the skiers, if one skier is uphill, applying a certain knowledge of skiing, that would suggest certain things about the accident. Would that be out of bounds?
I guess I have to hear the question, but it sounds like you're getting back into making conclusions based on an investigation. If you lay out some hypothetical facts to say if this skier was here and this skier was here, from a skiing standpoint, and then ask questions based on that, I could see that. But
okay,
it's feeling a little too hypothetical right now.
Sure. Okay. Thank you, Your Honor. Thanks for your patience with my questions.
Sure. Ms. Van Orman?
Just really quickly, circling back to why I raised this in the first place, is the concern with the animation. And so what I don't want, because Mr. Bogger apparently had some involvement in creating the animation, which was not designated in his report, nor was any mention on what his involvement was, what he did for it, how he placed anybody anywhere. There's no discussion of any of that. I don't think that it's appropriate for him to comment on the animation and to say, well, yes, I saw that, this helps me because I'm the one who helped to place these people there. It would have been, again, by reading the depositions and applying, which is what the jury needs to do. So I would say he can't even talk about the animations because that just goes beyond the scope of his report, anything that he's done in the case.
I would agree.
Unless the foundation can be set.
I haven't heard anything that would establish a foundation. I've
We
heard
have been
no profit.
broadsided, Your Honor. We had a 37-page report produced a long, long time ago. There was a motion deadline that we respected months ago. These issues were argued 45 days ago, and then immediately before our witness is going to take the stand with this 37-page report, we get essentially a midnight filing and that guts half of his opinions. I don't think it's fair, Your Honor. I can't even read the darn thing. I'm focused on getting my witnesses ready. The untimeliness is very prejudicial to us, Your Honor, because we can't properly brief this in days.
Okay. I've already ruled that the initial motion was timely, and I made a ruling on the initial motion. The subsequent motion was not untimely. The court has agreed to reconsider the motion, and that's what I've done. And I don't feel that it's unfair or unduly prejudicial. You were aware of the issues with his report long ago.
But you ruled in our favor before.
What I ruled was that the initial motion didn't give the court enough to grant it.
Because
and so then there was a motion
briefed it.
Then there was a motion to reconsider that gave the court more information, and I can see that it would be. I mean,
you can't poorly brief
you don't want
a
to,
motion.
I mean, this would create an appealable issue. Do you want to do that for your client? Is my question.
No, but I don't want to. They poorly brief something, the judge denies it. Then right before the testimony, they better brief it, and now we lose. I mean,
that's what trial is. This is trial. Things happen. The points that were raised in the motion are valid points. They're sound. They're based soundly in the law, and I want to make sure that what the jury hears is sound and not subject to any more risk of appeal than possible. So we'll take 5 before the jury comes back.
Well, the judge did really well there to explain. He took so much time to explain to Clark Kent. He actually taught Clark Kent some stuff there. I thought that was very, very good. We won't get that of many other judges. So I like that. I learned some stuff there. Okay, so Erin, statically, so what's it called? Law and crime. They're behind, so it's not me, it's them. So yesterday I did another stream. So I'll re-click on it and see. I'll try as well on the break to find another stream, just as a backup, because they're out of sync. But lunch will be probably in the next hour. So if there's a problem, I'll redo it. Right. Is Rumble bad as well? Oh yeah, well it would be because it's the same thing. So it's law and crime. It is. It's not me. So well, I don't believe it's me anyway. So. Let's have a look. Account. Okay. You can vacuum. That's my worst job, vacuum. I hate vacuuming. I think you know by now, Joe, what it is. This Judge Rosie is my favourite out of every. I'll be honest with you. Like I could only base it on like 4 judges, but this one by far is my favourite. The absolute the absolute patience. And can you see any other judge explaining to that lawyer Clark Kent, like giving him examples of helping when he was struggling to answer the question? The judge helped him out. I've got a lot of respect for that, you know, because lawyers, some of these young lawyers, got a tough job. So I don't even know who DeSantis is. I presume he's a politician. You see, Do you know what it is, Joe? She just pushes my buttons. Shannon pushes it. No, it's fine to name them. It's just more of a, like, let's talk an arguments about it. Well, I mean, yeah, I agree with you, because and I think even the plaintiff knows that the defense is ahead, so well, she pushes her luck, you see. That's what Shannon does, pushes her luck. Mini Appalus. Mini Appalus. See? Got it down. Mini Appalus. Mini Appalus. MMP, what's that? I don't know what that is. Oh, is this something for some podcast? Is it how's it down? What's that mean? Is it down? That's great news though. Yeah, because I'm MMP. That must be a podcast. The Mandy thing podcast, isn't it? Beep boop, beep boop, beep boop. Good. I'm there. You can have chats with me there. Don't care. Oh, is that so that's the Mandy woman thing, Liz and all them, is it? Down. Why is it down? I gotta look at Twitter. Whoosh. Love you, Shad. I love you. Thanks for chatting. I didn't even notice you were on there. Yeah, I didn't even notice. Free speech allowed here. Speech allowed. Yeah, probably. There's something to be gained here. I'm going to look now, though. If there's any links, let me know, because I need to. Or tag me on Twitter if you find anything. Try and have a look.
Ready for the jury? Yes.
If this out of sync again, I'll find the stream of lunch, all right? So don't worry. Oh.
Judge, you can say yes.
Keep blocking me.
Okay.
I'll take this. I don't know if anybody said yes.
I didn't hear anything, so they went to get the jury.
Everybody's kind of busy over here.
I see that.
I'm blocked by people. Block, 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 block. Right, search Lily. Lily's the best. Lily, if you're here, show your face. If you're not here, why the fuck are you not here? The real Whiting Housewives of South Carolina. That's amazing.
Thank you. Mr. Owens, you may proceed.
It's James again.
Okay, Mr. Egan?
We call Paul Bogger our ski expert.
Thank you. Mr. Bogger? If you could walk right over here to the clerk, and she will swear you in as a witness.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth? So help you God? Thank you.
Good morning. Would you start by sitting down and then giving the jury your full name and spelling it once you get situated.
Thank you very much. Yes, my name is Paul Bogger, Paulbaughger.
Your Honor, I note that my computer is still there. Do you mind if I grab it?
Sure.
Do you hear the sound? I can hear it.
Mr. Bogger, thank you for being with us.
Thank you.
Will you tell the jury what you understand to be your role here today?
Yes, I was retained to do an investigation to consider all the circumstances involved in the accident that you've been sitting through here. And I've also been asked to, if asked to assume certain facts, I could give opinions as to how that might work. Would that be plausible? Do I see this? I think maybe a lot of what I would hope to add today would be to sort of give the operational side, the skiing side, the things that we observe in accidents, and when we evaluate them, what we learn and what I pass on. I do a lot of teaching and training, which we can get into, but those are, I think, the sort of the key areas.
So do you have expertise to help educate the jury about the skier responsibility code?
Yes.
Or just reasonable principles about how to ski?
Yes.
What about how, like, for example, bindings and ski equipment might factor into how they might work in a certain collision?
Yes.
And why do you have confidence that you can explain that and with authority to the jury?
Well, I've been involved in working professionally in the ski industry for 37 years, and I've primarily focused on the outdoor, on snow, skiing, more specifically ski safety. That involves ski accidents. I do a lot of ski accident investigation. I mean, literally thousands and thousands. And I've done a lot of collisions. I've worked on a lot of collisions, and I haven't just done it at one ski area, my home ski area, but I actually had 4 ski areas that I did risk management oversight for. And I'm primarily a patrol director at my base, but then I moved into more supervisory roles that started to involve other ski areas as well, including one in Canada, one here in Utah that you're probably familiar with, Brighton. And those experiences of looking at these accidents in a variety of locations has given me quite a bit of information I can use to do the day-to-day use of that. Do we need to address certain issues on the hill? Do we need to remove a skier, for example, if somebody's unsafe? In bad collisions and bad accidents, we really do need to learn as much as we can. We get medical feedback. We just consider a lot of information. And then the last piece of that is I pass a lot of that on. I've been training and teaching people in the ski industry about accident investigation, skier collisions, skier safety for the last 20 years. And so I've been all over on that.
Do you have any higher education?
Yes, I have a degree in economics.
And what about certifications that are related to ski sports or skiing?
Yes, I would have a number of certifications. I'm not sure how many of them would bear directly on the ski accident part, but I'm an EMT, an instructor of outdoor emergency care, a licensed blaster, an aerial blaster, which means we can use explosives from helicopters and mostly for avalanche control. Well, I guess only for avalanche control. If there's anything else, probably be a big problem for me. I'm sure my license doesn't say that. But and then I have a number of schools that I've attended, avalanche schools and various ski risk management type things. And then, as I said, really the last 20, 25 years of my career, I've been mostly teaching and training others, whether it's the National Avalanche School, which we actually just held here in Utah in the fall, or consulting for ski areas, working with the National Ski Areas Association on national safety campaigns. The National Ski Patrol System was on the National Safety Board. And so there's a lot of related things. But I think that's the gist. I've been involved in, I like to even say, as I've been referred to as an expert in this for a long time, and I've done a lot of trials and testimony on ski cases. But I always think of myself too as a student. I'm continually learning about it. I always want to know the next thing. And you think they're all the same, and a lot are fairly similar, but there's always something new and something different. So,
have you ever, in your capacity you mentioned of reviewing cases for litigation or giving testimony in court cases, have you ever done that in Utah before?
Yes, I had a.
When was that?
Well, I've had a number of skier collisions that I've investigated here now with Brighton. That's more my oversight, and I'm reviewing the accident records. And then when we have a bigger collision that has more issues and so forth, or a ski accident for that matter, I'll get involved and I'll start going through a review much like we've been doing here. And I had a trial, I think 3 or 4 years ago in Salt Lake. Solitude, the ski area, was involved. And Park City, I've had a couple of collisions at Park City that I've done expert reports and so forth. But those cases settled. But anyway, so yeah, and that's, again, I think what's different about what I do than, say, maybe what Mr. Graff would have been doing when he was the patrol manager, is that I do travel and I do go to all the different parts of the country, including the East Coast, for accidents and the investigations. And skier collisions happen basically everywhere. And that's been I'd say I've probably had 20 cases that have gone to trial that I've been involved in. Maybe they haven't all gone to trial, but at least that have been in litigation.
And are you aware of any studies, or have you done any measurements of how common ski accidents might be?
Well, I'm certainly, I work with people who actually are involved in the, what we call the 10-year interval studies. And there's been 4 10-year interval studies about ski accidents and the mechanisms of ski accidents. I look at that data. I also, excuse me, I think you heard Dr. Scheer earlier describing the ISSS, the Snow Sports and Trauma, so the International Congress for Ski Safety on that. And I've presented there. I've presented I can't probably keep track of all the different meetings and groups that I've presented to, but these are bigger groups, the ISSS. And then I also present papers and do peer-reviewed work. The International Snow Science Conference, ISSW workshop, that was dreamed up in the 80s. They haven't lost that part of it, but it's a conference. It's an international conference, 1,000 people there. I do reports on things that happen, ski area problems, in fact, one ski problem with the snow immersion suffocation. I don't know if you've heard of that. You might have heard of tree well fatalities. Did you remember? We just had one here in Utah. And so that would be something I would gather data on. I talked to the general manager of the ski area that it happened adjacent to, and talked to the folks from the Avalanche Center here, Forecast Center. And they have some educational outreach that they do. And I basically was at the front of the snow immersion piece. I helped coin that term, and we did it. I keep a database. I keep doing ongoing research. I see you have another question coming.
No, it's fine. Well, I just, if you don't
idea.
mind me interrupting, so when it comes to measuring how common ski collisions might be in a given region or in a given place at a given time, do you have any particular data you can offer?
Yeah, well, certainly. If you looked at, I mentioned those interval studies, the rate in skiing accidents, the total skiing accidents of collisions is about 6 to 7% of all of the reported accidents. Now, I'm sure there's a lot of collisions where people just bump into each other and go on their way, probably a lot more of those. But ones that result.
Your Honor, I'm just going to object. I'm fine if this is just background foundation on Mr. Bogger's experience, but this goes beyond anything contained in his report.
I see it as background, so overruled.
Yeah, that's fine, as long as it's background.
Thank you, Your Honor.
Yes, so that rate at 6 to 7% is sort of uncanny from interval to interval. So 40 years of data now, and it's still the same. And now I use that metric myself because I'm looking at the 4 ski areas that I'm supervising. And then the other ski areas that I go to when I do investigations, I look at their data because the first thing I want to know is what is that rate here? And it can vary throughout the season based on weather conditions and snow surfaces and so forth. But, you know, that's a metric is, are we doing okay? Do we have a problem? Is there something that needs to be addressed? And so I look at it in all accidents. There's all kinds of data you can get from accidents, not just skier collisions in that way. And then we try to pass that information on. Sometimes we target it towards safety outreach. What you can look at a lot of safety stuff on the National Ski Areas Association website that anybody can log on to and look at the safety pages, and a lot of stuff on collisions that's in there and skiing safely and so forth. I had a lot to offer in the production of all that.
Thank you. Do you have any knowledge of what the rate of ski collisions might be in Utah? How common they are?
Yes, and it would be almost identical. Yeah, there might be, again, minor variations from ski area to ski area. But if you looked at Deer Valley, for example, which I did, and I asked this question during my site inspection, and their rate is just right in there. It's probably 6%, 7%.
How many collisions, and I'm talking not ski accidents, but collisions where 2 skiers are hitting against each other, how many collisions like that have you investigated, evaluated in your career?
Yeah, I looked through sort of back through the accident review data that I keep, and to just look at what you saw the other day, the incident report form, and maybe it's got something like an additional patroller comment or a ski instructor's incident report. I looked through that and I figured there had been about 4,000 of those that I reviewed out of about 44,000 accidents with just the incident report form that I've looked at. That's all accidents, but collisions, about 4,000. And then things that really got more investigated where there was things like we're doing here, 550 is, so that's it's a lot of accidents and a lot of collisions.
In those collisions?
Over a long period of time.
Sorry,
I just wanted to make,
yes.
And nobody will think skiing is safe anymore. I
Yeah.
want to finish that.
So when you've done those evaluations, what is your role? What are you trying to accomplish as you evaluate those accidents?
Well, sometimes we need to find the cause. Mostly we want to know the cause, and certainly that's how you can target prevention. But we also want to learn circumstances. Sometimes we have really bad injuries in these collisions, and it's important for us to make sure we know, is there somebody at fault? Are people meeting the responsibilities? And so we're looking at that all the time. And part of that is we want to make sure, since we're all responsible as skiers, that includes the ski areas, me, you, if you're skiers, that we share safety and we all do it together and we all have responsibilities. And if one of us is not doing our job, people get hurt. And so we need to evaluate fault at times, and we maybe address some people that we actually remove from the mountain. We've had people go in cop cars off of the mountain, but we're serious about it. We want our skiers to know that we're serious about it. They feel okay bringing their kids there, that we're not just turning a blind eye.
So in your evaluation of these various collisions, what have you learned about what the inherent risks of skiing are?
Well, certainly skiers face a variety of inherent risks, and those are often codified into, especially in states that have a lot of skiing in them, like Utah or Washington State or California. there's what they call like a ski safety statute in the regs. And so it will mention many times, it'll enumerate what some of those inherent risks are. Another place you can find those inherent risks are on trail signs are mandatory here in Utah, and that they're publicly displayed. But also the ticket back, sometimes that varies from place to place. But do you want me to list any of the inherent risks?
Sure, yeah, just to educate the jury, given your experience investigating these various collisions and just your experience as a long-time advanced skier, what are those inherent risks?
Objection, Your Honor, relevance.
Overruled.
Thank you. Yes, so things that you encounter as a skier, things that you could likely have a problem with if you weren't paying attention and weren't following your role, your duties of things that we would identify under things like the Ski Responsibility Code, which we can talk about, but terrain changes, forest growth, bare spots, things that you might run into, objects, lift towers, grooming machines, snowmobiles. We try to keep those off the hill when people are around. That's part of the sport. People need to get, lift maintenance people need to get around the mountain. So snowmobiles would be in there.
Oh, sorry.
Yes, go ahead.
I was just going to say, what about inherent risks relating to ski collisions?
Yeah, and that's where I was coming to. So I wanted to give you the broad brush and then say, and things like inbounds avalanches, you can actually get, even if they do the mitigation, you can actually get into an avalanche inbounds. And that's a risk you hadn't seen identified for a while, but about 5 or 6 years ago, we started adding that one. And collisions, skier collisions, or even collisions with lift towers and objects. But skier collisions, as we know, 6 to 7% of the accidents, we can eliminate some things, but an inherent risk you cannot. And the definition there is the risk is inherent in the sport. You cannot remove it without fundamentally altering the sport as it exists today. So that means following our good responsibilities and being prudent skiers, we can reduce the risk, but we can't eliminate it.
So does that mean that sometimes collisions occur despite people reasonably skiing on both sides of an accident?
Yes, that happens all the time.
And when you investigate collisions, do you sometimes, after a thorough review, conclude that you can't determine who was at fault?
Yes, that's common.
So just to put that in another way, in your evaluations, will you come to the conclusion that a certain accident is, and the evidence that you received in gathering information about it is not clear enough for you to identify who is responsible for it?
Yes.
Let's talk about the skier responsibility code. You mentioned that.
Yes.
And it's been brought up before, but since you're the ski expert, let's have you teach us about it for a second. I believe it is defense. Give me just a second. Sorry. Thought I had it right here. Yep. It's defense 91. Any objection to that being published? Or I guess I should talk to the judge.
No objection.
91 is received.
Okay, so let's put this up on the screen. It's also on your screen right there, Mr. Bogger.
Yeah, thank you. I see it.
And I'll turn it here so it's a little easier to see. Okay, so is this the skier responsibility code you were referencing earlier?
It is, and it's actually changed in the last few years, but that's the one that was in existence at the time of this accident.
Okay, got it. 2016.
2016.
February.
2016 February, that's correct.
Okay, and how do you know about this skier responsibility code?
Well, it's key, excuse me, it's key to all of the duties that we were just talking about in order for people, the skiers, for us to do our part. And it's a national code, started back in the 60s with the National Ski Patrol system before they had professional ski patrols at ski areas. And it's used all over North America Canada has something called the Alpine Responsibility Code. It's very similar. It has a few more details on it. I've testified in trials in Australia talking about a code that they have, again, very similar to this. But these are basic rules of the road. You have to give people, so you can put some order into the chaos that is skiing. You know, skiing is very dynamic, as you know if you're a skier. And so you're trying to put some basic rules in that people can follow. Their common sense. And go ahead.
Do you know, are there ways that skiers can become familiar with this responsibility code?
Yes, this is published at all ski areas. It's on trail maps typically, and you'd find them on big trail signboards too at the ski area. Websites will have it. There's all sorts of places you can go to find this, but it's everywhere.
Okay, and let's talk about the particular points here. I'll pull them out. Maybe should we just go through them one by one? Is that okay?
Sure, however you want to do it.
Okay, so the first one, always stay in control and be able to stop or avoid other people or objects. That seems fairly common sense.
Yes, that's if that one doesn't work, the rest of them aren't going to work.
And then the second one maybe is more important. People ahead of you have the right of way. It is your responsibility to avoid them. Can you explain what that means for skiers?
Yes, and the presumption is when people are skiing down a run, the people in front of you aren't going to have that rear view like you would. You'd be in a better position as an overtaking skier to see the people in front of you.
Got it. 3 is you must not stop where you obstruct a trail or are not visible from above. What does that mean?
Well, again, it's just about being visible. And so if there's a breakover in the terrain and you were on the bottom side of it, the skier that's coming from above isn't going to see you. And so it's to prevent surprises. And again, if you're skiing in control, if you're following the first rule, when you're coming up to terrain changes, that's one of the things that skiers have to manage is their skiing, their speed, their rate, their course, and most importantly, their lookout. That's what allows them, even if they come to a terrain change and there's let's say a small child taking his skis off on the downside of that hill, you're not going to run into him, even though that person might not be following the code. You're not following it either if you just go tearing over the hill. You have to be able to be in a position to maneuver so you don't hit anything.
Okay, so if a skier were taking, are you familiar with the term GS turns?
Yes, giant slalom.
If a skier were taking GS turns, what principles here should that skier follow?
Well, with a GS turn, and again, just backing up for a moment, skiing is very dynamic. It's people that are changing positions relative to each other all the time. And people are going at different speeds. People are using different styles. And you're mentioning one of them, you know, short radius turn or a slalom versus a larger radius turn, more rounded turn, a giant slalom. And these are different styles. And there's no prescription for how you have to do it or even what your ability is, any of that. There's no speed limit. I mean, there's slow skiing areas, but there's no number. So the idea is skiers have to be able to be in control, and it's the lookout. In a GS turn, you're taking wider swaths of terrain. You're moving across more, you're using more of the available hill space. So again, if there was trail density that was suggesting maybe you should be skiing shorter radius turns, that would be a reason. But typically when people are skiing giant slalom turns, their speed is usually faster. And people that are skiing short radius turns, I mean, if they try, they can ski quickly, but most of the time the turn is what controls your speed. So if you're making more of them, you're probably going slower.
What about, let's assume a skier is overtaking another group. They're skiing through a group that's skiing slower. What responsibility does that skier have?
Well, again, as the overtaking skier, you're looking at the rule number 2, people ahead of you have the right of way. And when you're coming into a group, you now have less space to maneuver. And your lookout has to be sharper because you have more things to focus on. Again, remember, everybody's not moving in unison. They're moving dynamically, and people can turn suddenly. And so again, if you're a prudent skier, and this isn't necessarily covered in the code, but if I'm going to make an abrupt turn on a crowded run, that's a problem for me. If I didn't look, I need to look up. It doesn't say you have to look uphill, but so the code gets you just so far. And I think, if I may, one of the things about the code is if you try to look at any one rule and say, for example, in a collision, because I have to look at this all the time in these investigations, or when I'm training people, I would have to tell them, never focus on just one. That's just one part of the puzzle. There's usually something else. And if I had a penny for everything that was involved, the failure of the lookout, for example, if I might have two skiers in a collision, and both are trying to be not the uphill skier. And I look at them and I'm going, but you were changing your positions. You had different speeds. You were merging and converging on each other. You both have the responsibility for your lookout. It can't just be straight ahead. You have to be looking. And that's part of why you have to go to number one, and that's the king. And then you go through the rest of them, but you can't hang your head on just one. Now, in some accidents, it may be really prominent, and you can weight it that way. But I'm just saying, you need to consider all of this, and the lookout you can't forget.
Right. So, is there anything about what can you tell us about the rules of skiing reasonably that relates to skiing within your ability? Is that one of the rules?
Well, it's not a rule per se, but it is right here that you have to be in control. So that means for whatever slope you're on, whatever the snow surface might be, it might be a hard, icy day, and you're going faster. It might be a little harder to control your speed. You need to then, it's not that different, I guess, from driving there, because, if the weather's bad and your braking distance is bad, then you have to give more room. And I think creating space is a key, but you have to ski within your ability, and you want to assume that maybe not everybody's doing the same thing, and leave a margin.
Okay, so what about if take an example of a skier that may have certain physical disabilities? Does that skier have the responsibility to take account of those disability or those limitations and ski appropriately?
Yes, of course.
Let's move away from this for a second and ask you about a hypothetical that connects to Dr. Scher's testimony. You were here when Dr. Scher testified earlier, correct? And he talked about bindings releasing. Do you remember that?
Yes.
And do you have knowledge about how bindings release in ski collisions?
Yes, I do.
So if you were to assume a certain skier came and hit another skier directly in the back at a high rate of speed, would you expect bindings to come loose, the skis to come off the skier?
Objection, Your Honor. Lack of foundation also not contained in his report in the lease. There is nothing mentioning any binding release anywhere in the report.
Sustained.
Let's take another hypothetical. Give me a second to think it through. Let's forget about bindings and use that same hypothetical of someone skiing directly into someone else's back. Would you expect that person to launch over the person they hit in a couple feet down the mountain?
Same objection, Your Honor. Lack of foundation.
Sustained.
Is there a space on the hill where skiers, let me think about it differently. If a skier were trying to avoid collisions and ski in a kind of safe and cautious place on the hill, where should that skier go?
Well, you could look for certainly terrain within your ability, and if you want to be cautious, you'd probably want to be on easier runs. And if you were wanting to be away from more people, specifically if you're concerned about skier collisions, and runs are getting crowded these days, you pick the right time, or you wait for opportunities. You can wait for traffic to go by and then you can go. Staying on the margins of the run is usually good, because you only have one side to defend, if you will.
So if a skier were taking short radius turns on the right side of a run, would that be within the parameters you've just described?
Yes.
So the onus is on me, because I need to get more subscribers to come to chat. So I'll have to get thinking how I get more
did
people
cut you
here.
off a little earlier when you were talking about the inherent risks of skier collisions, the things you learned about what the inherent risks are in skiing, investigating collisions. I want to make sure you got out what you wanted to on that point. Was there anything else?
Well, I mean, that's a big question.
Objection vague.
Sustained.
Okay, Your Honor, may I take a second to consult with my counsel? Thanks. Sure.
This I've had in the other one. There's a lot more chatty, I think, but we're starting to build it. It's just you've got to think right this second, as Erin says. The trial's not the best. We're missing Shannon. We're missing Chrissy. Missing Big Mike at the minute. They're also quite vocal people. There's also probably 4 or 5 other people that are normally here aren't here today. So yeah, I understand there's probably other streams with more chat and stuff, but it's just, yeah, if everyone was here all at the same time, we'd have probably 40, 50 people here. But with work and everything, it's hard. I appreciate that. I appreciate everyone being here. I wish I could do more for you guys. I really do. We'll get there one day.
Okay, thanks for your patience, Mr. Bogger.
Sure.
You personally went to the site of this collision, correct?
I did.
And were you there when Mr. Brill, maybe I should ask first, do you know Mr. Brian Brill?
I do.
And who is he?
He does animations, the ones that you've been seeing here, and he does them all over. For ski accidents, I think he does other things too, but he's very, very precise in laying out the terrain and the features in the terrain. That the trees are all the right height and the shadows are correct and all of that.
And you were here and you'd seen the animations before, correct?
I have.
Objection, Your Honor. This goes beyond the scope of his report. There's no mention of animations in the report.
Overruled at this point. And need to see how it's tied in.
Sure. I was just going to ask that given that you've been to the site of the collision, does the animation to you accurately portray the location?
Objection, Your Honor.
Sustained as to relevance. It doesn't matter. It was a demonstrative of the other witness's testimony.
Okay. In this case,
Actual Sarah Boone murder. So
what did you review?
I looked at all the deposition testimony, the documents, and various forms. We did the site inspection. I did work with Mr. Brill on the animations. I talked to Mr.
Objection, Your Honor.
Graf.
Strike. Relevance.
Sustained as to relevance. Why don't we take our lunch break at this time? It's just a little afternoon, and we'll take a recess and return at 1:30. Thank you.
Your Honor.
So yeah, next one's not next week, the week after Sarah Boone. Stacey, I'm chilled about it. Look, I understand that some YouTube channels take off, and this one hasn't yet. But look what we're building. There's people I could speak to people here that if it was too big, you can't speak to people. I'm happy. It's only tomorrow, Thursday. It's been 3 weeks. I think we're doing great, guys. Yeah.
Questions in light of the court's earlier rulings? Okay. We'll see you back at 1:30. Thank you.
100%, Eric. I think once people find out about it, I know Joe said it doesn't come up and stuff, but that's where it's hard. It is hard to get it to traction going on it. But every day we seem to meet someone new. So hopefully some people that I know that don't even look at streams, they'll start joining us. There's a lot of people I know that's not here now that hopefully will join us when there's a proper murder trial. No, she's just out there. She hates this. Doesn't want to be here. Yeah, yeah. I thought you were here, Joe. Felt guilty of all counts, but people are amazed by it. Like, I didn't watch the trial. We watched a couple of days, but on Twitter, people are shocked. They got found guilty. So I don't know. Do you not know what's going on? Right, over lunch, I'm also going to try and find Big Mike. I need to search for him. I can't find him anywhere on YouTube. If you put his name in it, I just can't. There's so many Big Mikes around. I can't find his bloody name. And he hasn't commented on any of my videos, I don't think. So, nightmare. Nightmare. It's all good though. Right, I'll put a thing up as well now. And say when we're back. One, so that means 2, 3, 4, 7. That's 3:30 Eastern for you, Joe. We'll be back. Be back. It's the lunch break. Right. 1:30 MST. 3:30 EST. 8:30 UK time. I've got to put in Fiery and Stacey. 12:30 EST. I think I've covered everyone. That's someone else from another country. I'm also going to look for a stream because this one's shit. YouTube. Let's see. Oh, Jesus, what's wrong with me? I need some dinner, I know that much. Okay, not that one. Right, so another one, see if this one's better. So that means I need to stop sharing. Mike. Yeah, no worries, Aaron. See you later. 3:30, Joe. 3:30. I'll be back about 3. So see you in a bit, guys. Right, I'm just gonna change streams. screen. I need to put my lights on. Look how dark it is. We'll probably be back on about an hour if people don't want to be around chat. All right, I'll put this back up. Presents. Share screen. Not that one. Six up there. Right, guys, if you're still there, see you in about an hour. Ta-da! Hello, hello, hello. Mic check, 1, 2, 3. I think we're back. No, not back. I mean, no. It connected to my iPod. I panicked there. I was like, no, I want to be connected to this stream. Not my iPod, because I don't know where my bloody iPod is. Oh, I'm full after lunch as well. Might take a nap. Under the witnesses today. I love that doctor. He did not care one bit about anybody or anybody. Laughing. Brilliant. Alright, let's get this out. Ba, 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 ba. Ba, 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 ba. Ba, 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 ba. Well, you can drop off. Just mute it if you don't like my voice. Ba, ba, ba. I'm singing. Ba, ba, ba. I'm not going to cover my left ear. Is anyone around in chat? No? Okay. Let's see if there's anyone on Twitter. I mean, we're early, but I thought I'd come back early because that's the kind of guy I am. Generous. Generous with my time. Okay. No one left there. Ba, 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 ba. Ba, ba, ba. Ba, ba, ba. Ba, 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 ba. Mhm. Ready? Hopefully everyone's okay after lunch. It's always a lull point after lunch, isn't it? Because you're just tired, can't be asked to do anything. So I'm sat down, do the stream. Doesn't take much energy. Wow, I've got 18 viewers on Rumble. What the f is going on? I've got 5 on YouTube, 18 on Rumble. What the fuck is going on? Rumble might be the place to be. Who trouble with Rumble is I've only made 20 now. Bloody hell, guys. Hello to the Rumble lot. Right, how much money have I made on Rumble? 5 cents. I made 2 cents today in Rumble. I'm gonna be a millionaire. Everyone goes it's so hard on YouTube because it pays like when you get monetized, it pays good. Rumble, you can just make money straight away. The other problem is it's like you make 2 cents a day. No one tells you that though. I don't mind. As long as I'm streaming, I don't mind streaming to Rumble as well. 21 watching, welcome. Right, Rumble, right. If you're not going to donate money, right, do me a favour, just follow the alternate corner, please. I've got 4 followers. There's 21 of you here, so please follow. I'd really appreciate that. I'm new to Rumble, I've no clue about it, so I'm still learning. Way up to 6 on YouTube, look at this. I mean, Rumble smashing it. 24 watching now, what the fuck's going on? I'm going to be, what's that? I don't know what that means. 1, Eve 1. I'm going to be at 100. Appreciate the message 1 for Eve 1, but I don't know what that means. I might be behind on the times. I'm a bit old. I appreciate you, man, for messaging. Please follow me as well. I could do with more than 4 followers, that's for sure. Don't know why that song's in my mind. I don't know. Don't even know what song it is. Must have watched it on a film somewhere. When you've won, you are to not worry one bit, my friend. Fighting cat to spell it. I love it. Look, I can't spell for shit either, mate, so don't worry about it. Or I say mate. Well, mate could be male or female, so that's fine. Appreciate you watching. Are you into all this like live stream stuff or trials? Have you checked my channel out? Have you seen some of the other videos going on there? I've also got like I've done it on all in YouTube, but somebody who is not here right now told me to go and try Rumble, so I did. Rumble's not as PC apparently, so that's why I'm here. The only problem is, unless I get 5 followers, I have to pay £11 a month here. So I want to get. I got 4 followers. I just need 1 more follower. I don't have to have pay $11 or whatever it is a month. I do not care if that's the one. Well, I'm shocked with Rumble's response. We will be back at 3. Oh crap! Hang on. We are back now in. Oh, follow. It doesn't show that you followed. Oh, it might. It might. Did you follow the alternate corner one? Because for whatever reason, my channel is the one that I need followers on. I don't understand how. I genuinely don't understand how Rumble works yet. I do not understand it. I'm sure it's simple. I'm still trying to get used to YouTube, so I don't know if you've liked my actual page or whether you like the alternate corner, but it doesn't update yet. But it's all good anyway. I'm not gonna hold you to it. At least you're chatting. I love the fact that you're chatting. I got 2 chats on the go now. I got the YouTube one on the Rumble one, which is good. But multitasking is not my strongest suit, though. Okay, I'm gonna go up Facebook. I forgot Facebook today. Don't matter. Can't be asked with it. Wow. Adnan Syed's murder conviction has been restated. Wow. Wow. Oof, okay. Cool. Yeah. The owners and those. That's fine then. That's fine. That's good because generally, I think it's quite good. It's just the fact that I don't know. I would do anything. I know you got to pay $11 or whatever it is to stream. That was self-explanatory enough. But everything else, I just can't seem to understand it. And also, I know I need 5 followers to be with the stream for free, so that's the aim to get 5 followers. And like, you can't get chat on the screen. And it's unfortunate that this doesn't link into YouTube, that the chats don't join together or something. Oh, I suppose you can't because this was more freedom of speech, where YouTube is a bit more restricted. That's fair. That's fair. So I've got to try and multitask now. If people talk to me on streams, I do it. It's not good. I mean, look, I'm sure you've tried this. Hang on, let me just see if I can. Oh, hang on. I followed you now. You should have. But did I follow you? I don't know if that helps out. But I just followed you. I don't know what that does though. I've refreshed my end. It doesn't do it. It shows her at the bottom of the video 4 followers still. But it's all good. I'm not like, if you pressed it, it doesn't work. That's all good. I mean, I've just done yours. It says it has updated. He's got 2 followers. I did press it, so I followed him. It says, oh, I got 5. Let's go. It only says 4. This is what I mean. I don't understand it because it says 4 of mine. Hi, this is Shannon, by the way. One Eve One. This is Shannon. She's got a channel as well. You can subscribe, follow hers as well. No, I haven't found Big Mike yet on YouTube. No, I subscribed to his channel, but I've not found him. Can you see the messages from One Eve One, Shannon? We made a friend. Let's go see. Look at that. Thank you for giving a like. I knew you'd give a like. You were missed. You were missed. I did notice that you weren't here. But it's all good. I understand people got busy lives and stuff like that. So don't worry. Don't ever worry about it. But nice to see you back today. I've got Rumble set up as well. So I've got 2 streams set up here now. And so I'm multitasking. I am now. I've got 5 subscribers today, by the way, which is good. Don't know where from. Oh, hang on. Let's have a look here. I had 24 followers on Rumble at one point. Now I've got 15. Still more than YouTube though. Whoop, whoop. What are you doing this now? What's happening? How's life treating you? Joe's back. Joe is back in the house. Rosie, the cat lover, the cat lady. I won't call you that. That's harsh. I know what you meant. I hope you're well. Yeah, I'm very busy, but that's the way I want it to be. Do you know what I mean? Hey, for the last 3 weeks, I've worked 7 days a week, working all hours from about 7 a.m. till about 1, 2 o'clock in the next morning with everything. I'm not scared of hard work. Let's throw it at me. You might be on twice. How are you on twice? 2 accounts, you mean? Mm-hmm. Very clever, Rosie, but I'm not sure you're that clever. I still love that picture of yours. It's so cool. The blueness of it and stuff. My friends stop talking. Shannon comes in and they stop talking. Mm. It's all good. It only comes up as one, though, I think. Oh, I don't know, maybe not. Because I can't tell. You can never tell who's here, who's not. Yeah, I think so. It's based in the US, Joe. It's talking new to me. I have no clue about it. I'm just learning. Um, Let's talk to Shannon who taught me about it. It looks like we're back anyway, so which is a positive. Is it? Oh my God, what's the witness called now? Is it this guy? I don't remember. It's an hour and a half. How do you have an hour and a half lunch break? I don't get it. It's unheard of. Normal people, you're not lucky to get like half an hour. You want to be on the jury just to get a bloody hour and a half lunch break? Joe, you're the man. If they're tidy people, happy days. Trying to get the chat going. But to be fair, I've got a lot of people that said that they will join properly once the Sarah Booth stuff happens because everyone finds this one too boring, which is fair. I mean, I do as well. So I think that's a big reason why we have got. There's a lot of regulars who are not here. Nafta, for instance, wasn't here yesterday. She pops in today. Um, there's loads of people that I've not seen yet today that normally here. Chrissy, for example. Big Mike's missing. I actually subscribed to Big Mike's channel to try and entice him back, but I couldn't message him. So I hope he sees the subscription as a sign of we want you back. We want you back. We want you back for good. Wherever you are. What's that, Rosie? Is that Westlife? I want you back. I want you back. I want you back for good. Whatever I say, whatever I do, I didn't mean it. I just want you back for good. Want you back. I want you back. Want you back for good. Oh my God! See, it's amazing. Take that. Gali Barlow. Michael, I don't remember that. I don't remember the names. I know Guy Barlow. Hey, thank you so much for this. Now I've got to figure out how the hell I put this on. Yeah, got it. Amazing. I got it. Thank you. I need to understand how I put it in my YouTube thingy, but I need to figure out how to do it. I'm not the most tech savvy, shall we say. But thank you for that. That's amazing. Oh, you kept my double chin in. You kept my double chin in. Ah, you. Oh, only joking. Only joking. I look quite cool. I look quite hot, to be quite honest with you. I'm happy with that. Twins. Yes. Yeah, right. I'm going to try that. If I, oh, no, I need to put this in now. Send it to myself, don't I? Oh, no. I got a YouTube on my phone, haven't I? What am I doing? Da, da, um, what I'll do now. And no, I subscribed to his channel to see if I could message him, but you can't, unfortunately. I hope he does come back. I don't think he gets offended easily, so I think he'll be back, but I don't know why he's not back, if that makes sense. Not that one. That's all good. I had to mind that. Yeah, she just sent me the blue pic, yeah. How did you know that? Here we go.
Thank you.
Don't worry.
The bailiffs are bringing in the jury and getting them ready.
I thought you sent me news. I got
No,
excited.
I will bring them in the room until they're ready.
Yes, yeah, it's a blue picture. As you can see from Rosie's face, that's what it is. And she said it for my face. I'm going to change it over Twitter. Oh, that's nice to you. Yeah, it was lovely of her. Rosie's always nice. I mean, so are you, doesn't it? And that's the thing, right? I got so many nice people involved in these chats. Karen, she's lovely. Depends what day it is, but you know, Shannon's lovely. Chris, you know, we're lucky, I think. Right. I think I messed that one up. We'll get the Twitter one done now.
Mr. Bogger, you can come back up to the witness stand.
I think this stream will be better. I've got a new streaming site.
Okay, we're ready for the jury. All right. Thank you. Mr. Egan, you may continue.
Thank you, Your Honor. All right, Mr. Bogger, we just have a few more questions and then we'll get you off the stand here. First, is it your opinion that both Mr. Sanderson and Ms. Paltrow had the responsibility to exercise reasonable care to avoid a collision with each other on the day of their accident?
Yes, that's correct.
And you're familiar with Ms. Paltrow's account of that collision, correct?
Yes, I am.
Have you heard her testimony, in the trial testimony that she gave to this jury?
I have.
And you also reviewed her deposition?
Yes.
And if you assume that her account is correct, is it your opinion that she did comply with the standard of care or the reasonable standard that you just said that was her duty?
Yes.
And if you assume her account was correct, did Mr. Sanderson comply with that duty?
No.
And why is that?
Well, if you assume the facts that we're looking at Ms. Paltrow's version, then you'd have to conclude that at the moment of the collision, she was a skier below and was hit from behind. In that collision, I know I said there were a lot of other factors, but in this case, that seems to be the key factor. And that's where the failure of someone's lookout at the last minute, even if they can be in control the entire time, making great slalom turns, whatever it might be, but you can be a very good skier and you can be skiing in control. But if you have a momentary failure and there is someone below you of your lookout, then you have a collision. And by definition, if you have that collision, that's not in control because you can't stop and avoid anything below. So by definition, that's skiing out of control, even if it's momentary.
Did you review the evidence relating to Deer Valley's paperwork and obtaining of information about this accident?
I did.
And do you have knowledge of the standards for ski resorts in terms of that kind of a investigation of an accident?
Yes.
And did Deer Valley comply with that standard?
Yes, based on the facts that they had in front of them, yes.
And did you see any evidence of inappropriate documentation?
No, what I reviewed looked like it would meet the industry standard of care. It would be very similar to all the ski areas that I visited and know I'm familiar with their record keeping and so forth. These are typical business records kept in the course of business.
In your experience, thoroughly investigating over, I think you said 500 ski collisions, do you sometimes conclude that the evidence does not allow you to determine who is at fault?
All the time, yeah. Sometimes you just don't have enough information. Sometimes you have conflicting information and you just, there's plausible versions and you can't know which one's right. And you just have to realize that you're not going to be able to determine fault. So that's common enough.
Okay, that's all my questions. Thanks.
Thanks.
Ms. Van Orman?
Good afternoon.
No, but
Good afternoon.
I'm
presume
going to be
so.
really, really quick with you. In fact, we're just going to do the opposite of what you just testified to. So you were just asked if Miss Paltrow's version of the accident, assuming that was true, would Mr. Sanderson have violated the skier's responsibility code? We're going to flip that. You've heard Mr. Sanderson and Mr. Ramon's version of the accident. Assuming those were true, they would have complied with the skier's responsibility code, correct?
Correct.
And Ms. Paltrow would have violated the skier's responsibility code.
That's correct.
All right. And in fact, the skier's responsibility code, it applies to all skiers. They all have to follow it, right?
That's correct.
No matter if somebody has a disability in their eye or if they're turning to look at their children to watch them ski.
All skiers have that responsibility at all times.
That's all I have. Thank you.
Thank you.
Oh, thank you.
Thank you, Mr. Bogger. You may step down.
So, Apple and Moses, apparently they were only there for
Mr. Egan,
yesterday.
you may call your next witness, or Mr. Owens this time.
So,
Stephen Edgley, MD.
Stephen Hedgley. So, yeah, it's disappointing not to hear them, but it's because the whole trial's running behind.
There's a lot of stuff
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can have a seat.
Again, I'm really good. I do. I do.
Would you begin by stating your full name and spelling it for the jury?
Stephen R. Edgley. That's a Stevenedgley. Yep.
Come on, Steve. Right. We've got 27 people on Rumble and only 5 on YouTube. What's going on?
Okay, Dr. Edgley, are you employed?
Yes,
Where are you employed?
at the University of Utah.
And are you over the acquired brain injury division?
Yes, physical medicine and rehab is my specialty, and I'm over that section.
How old are you, sir?
49.
Okay, and just background, undergraduate degree, where was that?
I studied psychology with a pre-med emphasis at BYU. My med school training was in Chicago at Loyola University in Chicago. And I did a 4-year residency in physical medicine and rehab at the University of Utah.
And then did you go there? Did you stay at the university?
Yes.
And have been for how many years?
Overall, 20, yes.
Okay, and do you
Others would have been
hold
off
an endowed
because of
chair
kids.
at the university?
I do.
Do you teach? Are you a professor there?
I do.
And you personally had an acquired brain injury. Is that true?
Yes. So I had a stroke in 2001, 21 years ago.
And did that event play a role in your area of study?
It did. I was initially matched for a residency training in ophthalmology, actually. I took 1 year off to deal with the recovery aspects of my stroke, and then began physical medicine and rehab residency training.
Are you board certified in your specialty?
I am.
You are a physician, MD, correct?
Yes.
And do you deal with people other than stroke people, other acquired brain injuries?
So in my practice, it's a very busy practice. 95% of my practice deals with acquired brain injury.
And what is that? As opposed to brain injury, like if a baby is born with a brain injury, that's not acquired, right?
Acquired. So acquired brain injury encompasses strokes, traumatic brain injury, concussions, and a myriad of other brain injuries related to, surgery, anoxia, near drownings.
Anoxia is like oxygen deprivation.
Yes.
Okay, and maybe a child who's found at the bottom of a swimming pool, rehabilitated, brought in, and they come and see you.
Yes.
About how many patients have you seen in your career?
So I have, let's see, I see about 15 separate encounters per day over 20 years. That equals over 65,000 patient encounters of acquired brain injury.
Thank you. And do you consider yourself an expert in brain injuries?
Yes.
And the fact that you have personally had an acquired brain injury, does that also give you additional insight?
It makes me kind of unique in that I have experienced.
Have you reviewed voluminous records in this case?
I have.
So the court complaint, records and reports from the VA hospital, is that fair?
Yes.
About 1,000 pages or so?
Yes.
And deposition transcripts, Gwyneth Paltrow, Terry Sanderson, the daughters, Sam Goldstein, Dr. Fong, all of those?
Yes, that's correct. Yes.
And medical records also of the Park City Instacare, Cognitive FX, Sam Goldstein. Have you reviewed those?
Yes.
Do you believe that you have the foundation to render expert opinions in this case?
I do.
Sure.
The jurors have already heard that the patient, or I should say Mr. Sanderson, has a mild traumatic brain injury. Do you agree or disagree?
I think I have poured over the records. I think it's possible.
Okay.
But the testimonies are inconclusive.
The truth.
The most important things you look at are how long they're unconscious and how long they've lost their memory, amnesia.
That's correct. So that's going by the Cantu concussion grading system, which is preferable because it's the most objective and not relying on subjective symptoms from any patient.
Okay, so a concussion, if you hear someone has a concussion, are those your two lead questions? How long were you out? And how long is your memory out?
Exactly.
All right, and apply that to Mr. Sanderson, would you?
So it is unclear whether he lost consciousness. Now, let me be clear. So let's define consciousness. So when you are unconscious, you are totally lifeless and limp. Not speaking, not moving. That's unconsciousness. I based on the records, there is a very inconsistent evidence that he did in fact lose consciousness. So I am not able to state that conclusively.
Okay, what do we know about, for instance, Christensen was the ski instructor. He testified to no loss of consciousness. You with me?
Yep.
And Brad Falchuk has not gone yet. Ms. Paltrow has stated no loss of consciousness. Craig Ramon did say loss of consciousness. Have I sort of summarized some of the people who talked about that?
Yeah, and the plaintiffs himself has said, loss of consciousness, 5 minutes, and then again a later 10 minutes.
Okay,
Yes.
so Mr. Sanderson kept changing what he
Yes.
was telling people, right?
Um,
I don't know, a few seconds, 5
Yes.
minutes, then 10 minutes. True?
Yes, and I think that is why it's important to clarify loss of consciousness with the post-traumatic amnesia. So, the plaintiff will not remember how long he was unconscious, if at all. He will remember the first memory he had of that event.
Okay.
And
So consciousness, I heard you say 5 minutes, and I just want to be clear. One of the ways we rate sort of the severity of the concussion is very short to no concussion, up to 5 minutes, and then over 5 minutes.
So
is that true?
So to clarify, no loss of consciousness, but post-traumatic amnesia is a grade 1 concussion.
Thank you. Whitney Smith, I guess, was another provider who said no loss of consciousness. Are you aware of that testimony?
I don't recall.
Okay,
Yes.
Whitney was the toboggan person.
Yeah,
and
okay.
She asked, she quizzed them, I guess, but let me move on. Okay, so even if Ramon's testimony is believed, that would put him only in the second category, less than 5 minutes.
Yes.
Okay, and first category is essentially no loss of consciousness.
Yes.
Okay, now let's go to amnesia. Applying what you've learned about Mr. Sanderson, how long was his amnesia after the collision?
That is also very ambiguous and multiple reports. I hear and read that he had a conversation with Eric Christiansen, which he does remember, which was, traumatic in his opinion.
So Sanderson remembers Christensen yelling at him. True?
So,
is that what you're referring to?
Yes, that is the allegation, yes.
Okay. And he remembers his friend, Craig Ramon, talking to him. Are you okay? Are you okay? True?
Yes.
Okay. So what does that tell you about like length of amnesia?
It was brief, if at all.
Okay. So you said that two big things we look at for severity of concussion is how long they're out and how long they could forget things.
Yes. And I will add, so people experiencing brain trauma have a period of fogginess, and as the plaintiff himself said, quote, I rung my bell.
I rung. Okay. At one point he said, I rung my bell. I hear you. Go ahead.
So I am not able to say, so it is probably, it is likely that he did have some confusion, but if he had no loss of consciousness and no post-traumatic amnesia, it can't really be called a concussion.
All right, fair enough. And confusion, let's just talk about that issue. He has memories at the actual incident site, correct?
I suppose. I don't think.
An objection, Doctor. That's when you do not answer.
Length of period of confusion. Do you remember what he told the toboggan person, Whitney, about whether he, do you know if what Whitney observed in terms of his confusion level?
No.
Okay. She wrote alert and oriented ×4 or something. That's in evidence. I'm asking now to comment on it.
Overruled?
No foundation.
Overruled?
If Whitney, the toboggan person, observed no alert and oriented ×4, are you familiar with that term?
Yes.
And is it 4 out of 4?
Yes.
Like 4 is the best score?
Yeah.
I want to know what that scale means. Please tell me.
So let's see. Oriented to person, place, situation, and location.
Place, time.
Time. Yes.
I don't know. Okay.
Person, place, time, situation.
Did you say president or present?
No, person.
Person. Gotcha.
So.
All right. And the jury's heard on those issues, so that's okay. I asked Terry, would it surprise you if at the Instacare they found no confusion? He said no. Is that consistent with your knowledge of the events?
Yes.
Have you seen texts he was sending out even at the bottom of the hill about Whitney?
I
Go ahead.
I have heard about the text. Yes.
All right. Is it your opinion that if Mr. Sanderson suffered a concussion and it was mild, it was mild?
Bleeding.
That's
Overruled.
Go ahead.
What's the question
Yes.
again?
Is it your opinion that if Mr. Sanderson suffered a concussion, it was mild?
Yeah, yes, it is. Yeah.
And is that based on the things we've been discussing, or are there any other issues? Loss of consciousness, amnesia, confusion. I'm just wondering, are there other issues we ought to hit before we move on to your next opinion? To go to that issue.
A helmeted low velocity impact. Also,
low velocity impact. What does that mean?
So he was not going fast.
Okay, what do you know?
Like in a car accident. He was not going car speeds.
Okay. And you read, for instance, the depositions where they discuss it was actually kind of a slow fall.
Yes.
And that's important when determining how hard the hit was or something for the concussion severity.
Yes.
Thank you. Any other factors we've missed?
I don't think so.
All right, let's go to your second opinion here.
Everyone's listening to him now as well.
None of the medical records support plaintiff's claim that perceived symptoms of cognitive decline are related to the ski collision. Is that your opinion?
Yes.
Maybe I'll flip it around. Comment on his symptoms. What percentage of his symptoms that he now complains of are related to the ski collision?
I can't really do that. I think would be better to analyze what he had going on in his brain before and after the collision.
Please do that.
So the plaintiff, and I'm in no way trying to pick on the plaintiff, but he had a number of brain conditions. He had a stroke, which he lost his eyesight in his right eye.
Stroke.
Yes. He had evidence of a microvascular disease
in his brain.
And probably most importantly, he had evidence of a hydrocephalus clear back in 2009, and let me talk about the hydrocephalus and.
Okay, let me make sure we get the whole list, though. These are preceding brain problems from his pre-collision. True?
Yeah.
Are we showing this, whatever this exhibit is, to the witness and having him read off of that?
No.
He's not reading off of it, but please turn it around. It's a different topic.
So
That was not a prop. That was getting ready to show it, but we'll go on.
yeah, okay. Would you state
Yes,
that,
thank you. Okay, I heard you say with regard to pre-collision brain problems that the plaintiff had: stroke, microvascular disease, hydrocephalus. Any others?
not that showed up on the MRI of his brain in 09.
He had a history of migraines. Is that something you'd put under that list or not?
Yeah. Yes. So
Sustained?
Okay.
Pardon me?
I didn't even
strike. I couldn't hear. Just
move
okay.
to strike the answer.
Motion granted.
I didn't even know what his answer was going to be, by the way. I'm just trying to get this list together. But
must disregard it.
thank you. So if you think of another one we ought to talk about, please tell me, okay? You said you want to talk about hydrocephalus. What is that word?
hydrocephalus is where the ventricles have too much pressure, or a condition called normal pressure hydrocephalus, which is equally kind of devastating.
Dumb it down for me. Does hydro mean water?
Yes.
What does cephalus mean?
Brain.
Okay,
Yeah.
so
water on the brain.
and then this is very confusing. Normal pressure hydrocephalus is not a normal condition. Is that true?
Not at all.
Overruled?
I mean, when I see the word normal in a diagnosis, I think, oh, that's normal. But in this case, normal pressure hydrocephalus is or is not a good condition.
So it is a well-recognized medical condition that is degenerative in nature, meaning it gets worse with time. About only 1 in 500 people between the age 60 and 70 have this, and it gets worse with time.
You said hydrocephalus means water brain. What does that mean? There's too much fluid in the head, or what?
So it specifically means that there is too much fluid in the ventricles of the brain.
And what's a ventricle again?
Fluid filled cavities that feed the spinal column and eventually get resorbed by the body.
And you said it's progressive. Just comment on that. So let's say there were no ski accident. Comment on its progressiveness in Mr. Sanderson.
So it's been 14 years since that initial MRI. That's quite a bit of time. I would expect symptoms to crop up like loss of a memory, like trouble with balance.
Okay. Let's move on to microvascular disease. By the way, I want to know if these things are related. If someone has the hydrocephalus like Mr. Sanderson, does he also have to have microvascular disease?
No.
All right. And do you believe the microvascular disease caused the stroke?
Yes.
Okay, so those two things are related.
So,
Go ahead.
so a stroke of the central retinal artery is a harbinger of future strokes and a indication that there is microvascular disease.
So microvascular. Micro means small. Is that right?
Yes.
Vascular means like blood flow?
Yes.
All right. So small blood flow. So in lay terms, does that mean the passages of blood flow are narrowed in his brain?
Yes.
Sustained?
I'm trying to get to the most like 8th grade level, which is what I understand.
Yeah.
So comment on Mr. Sanderson's pre-collision brain as it related to microvascular disease, please.
So 2 points. So some microvascular disease can cause very small stroke, which are not able to be detected by scans, MRI, CT. Also, number 2, microvascular disease is a great risk factor for a future stroke.
Do you believe this, is this your opinion? All symptoms the plaintiff claims is explained not by the collision, but by his pre-accident conditions? I'm trying to get his opinion out there, Your Honor.
You can ask what his opinion is.
Yeah, sustained.
Okay, comment on your opinion on that issue, on the issue of his current claims as it relates to his pre-accident conditions.
So in a more likely than not scenario, in this 76-year-old brain now, concussion symptoms should only last for 1 to 3 months. There is a wide berth of evidence that when the concussion symptoms last for longer than 3 months, it's highly correlated with monetary gains or litigation.
Explain that, please. Monetary gains or litigation. Go ahead. What's your point? And relate it, please, directly to Mr. Sanderson.
Your Honor, this goes beyond the scope of his expert report.
Could you approach, please?
I understand. This it's about the buy volumes on Max, by the way. I can't help it. I'm not going to be like, I think this is a great witness for them. I'm not sure what they're going to say now. It's impactful, mind, to see this guy who's had a stroke at that age and then still make all this in his life. Jesus, makes me think, bloody hell. So fair play, he's not used any excuse in his life, he's just gone for it. Yeah, they were just zooming in on it all the time. And they weren't supposed to do that. But it's hard because she's so thin. You have to bloody zoom in just to see her. I hope the plaintiffs are nice.
And the answer was stricken, and the jury is ordered to disregard it.
Comment, would you, on the patient's pre-existing anxiety and depression?
So he has been medicated for a number of years for depression and anxiety.
Do you believe those things play a role in his current condition?
Absolutely.
And just comment on that, would you?
So also, when symptoms of concussion last for 3 months or longer, anxiety and depression and other psychiatric conditions are the likely cause of that prolongation.
The last sentence?
Uh,
I missed the last word, I'm sorry.
Prolongation.
Prolongation.
Yes.
Thank you for explaining that. Can you just comment just a little further about that? What do you say it a different way for me, would you?
Yeah. So the symptoms of a concussion should last no more than 3 months. When the symptoms of concussion last longer than 3 months, you start looking for, and this is highly correlated with underlying depression, anxiety, and other psychiatric conditions.
One thing you noted in your report was plaintiff has a history of seeking medical attention at an abnormal rate, 72 times in 10 years. Is that your opinion?
Sustained.
Well, comment on how frequently Mr. Sanderson went to his doctors in the 10 years prior to the collision.
So I did note that he had an extensive history of seeking care.
And
Yes.
what does that tell you? Why is that important?
Two things. One, either he has many medical issues before the collision, or he is kind of hyper focused on his symptoms.
And that's pre-collision we're talking about?
Yes.
And then pre-collision, just as a part of aging, did he note a decline in his mental or physical activity, acuity level?
So what's interesting is within 1 month of the collision, he went to his own family doctor and said, I feel like I'm getting old.
This is within 1 month before, correct?
Yes.
And did he say, I'm having a hard time doing the things I've always done?
Yes.
Overruled.
And why was he feeling that way? Do we know?
So I
I'm just asking, do you have any thoughts on that issue?
Sustained?
Well, using your medical opinion, I'm just wondering, what does that tell you as a reviewing medical expert?
Foundation.
Overruled?
Go ahead. I'm getting old and I can't do what I used to do. Go ahead.
Overruled?
So I have had many patients of his age say the same thing. Yes. And I think it's important to clarify one thing. So the brain is an organ, just like any other organ. With time, it accrues conditions, problems, just like any other organ. The plaintiff had evidence, including objective evidence on MRI and things like that of these disease processes before the clinician.
Okay. And this was the stroke workup. Is that where he had the imaging?
Yeah.
Before? And do you know of any of their plaintiffs' experts who actually reviewed the stroke imaging before the collision?
Overruled?
I do.
Did they? Did any of the plaintiffs' experts review the imaging to your knowledge?
Not to my knowledge.
And if we're trying to figure out, hey, what's this guy's brain like before and what's this guy's brain like after, it would be nice to put those side to side, wouldn't it? And actually compare?
It would. And that's what the defense has done. Yes.
All right, let's just talk about aging have you seen, may I show him a document, Your Honor? Before I
Seen it?
Sure.
Have you seen Defense Exhibit 103 and 103B?
I have.
And does that appear to be a true and correct summary of Mr. Sanderson's health before the incident?
It does.
Okay, and Your Honor, I move to publish it.
Objection. We object, Your Honor. It's what we've talked about before. There's irrelevant medical information there.
I'm about to establish the relevance.
If he hasn't established it yet.
I'm going to admit 103 and 103B for demonstrative purposes only to allow this witness to illustrate their testimony.
Figure out how to show this too. There's an easel somewhere. Is this okay for a minute?
Sure.
This is the same thing. I just don't trust technology. So 103, and Doctor, do you have a binder right in front of you?
He's relatable.
Yeah.
May I approach? Oh, can you see it right here?
Yes.
Oh, the monitor threw us the first week, but the monitor wasn't working. Can we do the first third? All right. Can you see that okay, Doctor?
Yes.
And is this the note you were just talking about? Thinks he's gotten old all of a sudden, not doing things he used to do?
Yeah, it is. Yes.
And then let's say that big, then blind in right eye, were you familiar with that?
I was.
And severely impaired in the other, did you see that in his medical records?
I did.
Did you see evidence that he walked into walls before the incident?
Yes.
He would ask people standing on the right side of his field of vision to move so that he could see them. Did you see that in the evidence?
Yes.
One of the reasons he retired was because he had a stroke event that deprived his eye of oxygen, impacting his vision. Did you observe that in the evidence?
Yes.
We're going to go through all these. It's going to be leading, Your Honor, every time. Overruled.
He adjusted
What the fuck is he
his
supposed to do with any dick?
to one side of the slope to try to avoid hitting others in his blind spot. Did you observe that?
Yes.
He had to be picky about what days he skied to avoid days with lighting that would further limit his depth perception. Do you agree? Did you see that in the evidence?
Yes.
By the way, I mean, if I close one eye, do I have depth perception? Is it still three? Comment on that. Is it still three-dimensional or is it now two-dimensional?
You don't want to have.
Scope of his expert testimony, Your Honor.
It's talking about aging.
Overruled.
Okay, so I'm closing one eye. Does that hurt my depth perception or it doesn't?
That does.
Just comment very briefly.
Well, you have basically got a monocular situation, and so depth perception will be severely impaired.
Prostate cancer, were you aware he to this day still has metastatic prostate cancer?
Yes.
It's not like it was cured, true?
Yeah.
And he is severely hearing impaired. Did you see that in the record?
Yes.
He has difficulty hearing higher frequency sounds like a woman's voice. Did you see that?
Yes.
Hearing loss is severe. Did you see that?
Yes.
Heart palpitations. Did you see reference to that?
Yes.
And he was on two heart medicines, just prior to the ski collision, 2 blood pressure meds for his heart.
Yes.
Is that related to the palpitations, or are those high blood pressure issues separate from the palpitations?
So they can be related to the heart. They can be related to anxiety.
Okay. Do you have an opinion one way or the other?
So I cannot speculate.
Okay, Mr. Sanderson is 76 years old and experiencing the effects of aging. Do you believe that?
We all are.
Is that a yes?
Yes.
Microvascular disease, we talked about that. Moderate diffuse volume loss atrophy, brain volume decreasing. Did you note that he had that prior to the ski collision?
So I read it on the report. Yes.
Okay. And what does that mean? Do our brains all shrink as we age?
Yes. Some more than others. And
Talk about Mr. Sanderson, please.
Brain atrophy can be caused by a number of factors.
Okay. Comment on Mr. Sanderson, please. What do we know? Why did he have that before the ski collision?
We don't.
That's
I
what
don't
I'm
know why
asking.
he had it before.
I'm asking if he knows it.
Overruled.
Tell us if you know why he had it.
I don't. It's a vague symptom finding, and it could be caused by a number of things. commonly people who drink alcohol excessively commonly have brain atrophy, but there are a number of other causes.
Did you see any evidence in the VA record that he sometimes drinks more than 6 drinks a night?
I did.
And did you see the advice from his providers was, don't do that anymore?
I did.
We want you to abstain from alcohol. Yes? Overruled.
I did see that. Yes.
All right, we're gonna move faster here. By the way, it says moderate volume loss, so mild, moderate, severe, are those sort of the 3 categories?
Yes. And that's referring to the MRI in 2009.
Retinal artery occlusion, we talked about that, that's the eye thing. And clotting in arteries delivering blood to brain. Is there anything you want to comment that you haven't talked about on that issue, number 9?
No, I don't think so.
Depression, you've talked about that. Anything more you want to say about it?
Depression and anxiety.
If he says, since the ski collision, I've had more depression and anxiety than I did before, what do you attribute that to?
So any symptoms past 3 months, I would attribute it to this multiple factors, not at the accident.
Okay, migraine we've talked about. Let's go. We're going to march through these very fast. In addition to going now, starting on 103B12, did you know he had degenerative disc disease in his back prior to the ski collision?
I did.
Did you see reference to a foot drop that he, at least for a time, he actually was dragging his foot?
I did.
Weakness in his back and spine?
Yes.
Loss of sensation. Did you see that?
Yes.
And just general back pain?
Yes.
Did you see that? Knee injury? Yes.
Yes.
And that was actually from a ski collision? Do you recall this? Not a collision, a ski accident?
I did not know that. Yes.
Shoulder injury, shoulder problems. Do you recall him having those?
Yes.
And hamstring injury, right? Torn hamstring?
Yes.
Osteoarthritis. Did you see that?
Yes. And what may be more relevant to this case is the osteoarthritis in the neck region, which would make moving your head side to side kind of painful or difficult. That, along with the vision impairment, are, I think, relevant.
All right. My partners here are telling me I should wind up. Can you at least look at insomnia, respiratory problems, poor male sexual reproductive health, lower urinary tract issues, kidney problems, hypercholesterolemia, weight gain, and restless legs? Are those all conditions you saw in his pre-collision medical records?
Yeah.
Why are these things important when we're talking about aging?
It is a long list. Some of these conditions are more relevant than others, but the some um, indicates that he is 76, and with 76-year-olds, sometimes I have multiple medical conditions like this.
And these were all pre-collision events, right? Pre-collision conditions.
Yes.
And what does that tell you in terms of his aging? Like at 69.
Well,
that he was?
So like I said before, we all are.
Aging.
Yes. And so in terms of the brain as an organ, we talk about brain reserve. And we talk about cognitive reserve. Brain reserve tends to go down and down, starting at around age 25. It goes down faster with time and aging.
Okay.
Cognitive reserve indicates that the patient's ability to cope, adapt, be resilient, and find effective workarounds for that brain decline, which we all are undergoing at various stages.
Let me conclude here. They're about to stand up and criticize you for not personally meeting with the patient. Did you personally meet with Mr. Sanderson?
No.
And what did his actual treating providers at the University of Utah, or excuse me, the VA, Veterans Administration people, what did they show on all their neuropsych testing?
So I did not press to actually meet and examine the plaintiff because I think it would be a kind of a condescending to him and also to me to go over a totally normal physical exam as the medical doctors at the VA had well documented records.
And they documented high, average to superior in essentially all categories.
Sustained.
Can you comment on their findings in terms of some kind of graph?
So I think you're referring to the neuropsych test.
Correct. Just give us, and then I'm sitting down. Give us a couple, 2 sentences on that, would you?
So a neuropsych test is really like an MRI of the actual mind and its function.
And what was it as to Mr. Sanderson after the collision?
He had 3 neuropsych tests, and it was superior to above average.
Thank you.
And
those are all my questions. Thanks.
We'll take a short recess right now. Thank you.
It's tough. I do wonder how they're going to approach this now as a plaintiff.
You can step down. We'll take a 10-minute break. 10 minutes.
Sorry, break. They can't diminish his testimony because, I mean, how can he with his knowledge and experience? So, what are they going to attack? I mean, if they attack this guy, then I don't know what they're going to do. Yeah, so Big Mike, should be on my channel somewhere. I wrote to him. What did I write to him? Oh, I don't remember where it is now. Basically, I said, Big Mike, great commenter on live streams. We miss and love you, Mike. Come back. We do miss him. Oh, his profile picture's funny as well. Alrighty then. So we've got 10 minutes. Oh. I don't know. It's really hard to keep a beat with this trial because I think this trial's a slam dunk. Well, not slam dunk, but I don't know why we're still watching this trial. I mean, if the jury don't take more than the jury only need a couple of hours, have a cup of tea, have some free food again, unless it is shit. Ooh, do you reckon the food the jurors have is nice? Do they actually spend a bit of money on them and give them a nice spread every lunchtime and stuff? Do they go back now and get some cakes and stuff? Are they told to bring their own food or something? I'd be pissed if they told me to bring my own food, but hey, gotta pay for this. No, in what way? No. Do they pay? Do they buy the food, or do they have to bring in their own food, Stacey? What do you mean? Big might come back, and you're like, no. uh, really? Okay. So you literally have to bring your own food in. I've always wondered that because they all go back. They all go back to the same room. So you don't have to speak to anyone then. What do you do? I find that impossible. Or are you allowed to speak to somebody, but not about the case or something? I'm intrigued by this stuff, you see. Oh, Big Mike sees this now. Oh, okay. Well, did everyone else? Did you just do that because you wanted to do it, or were you encouraged to go somewhere where there was no jurors or something? I've been watching Twitter as well about this ice cream trial, and not everyone, but people are mortified that he's found guilty. Well, I didn't see it, but people are like, "What the did the jury see to make you guilty?" That's the thing when you put in jurors' hands, you just don't know. I think a lot of these cases, you're lucky. A lot of depend on which jury you get. A jury, sorry, you get. Oh, that's fine. No. If they said to me you can't speak to someone, I wouldn't sit there inside it. I'd probably go to the car as well. Do you know what I mean? Look at that. I was just sitting there doing nothing. Rather be in the car, jigging to the music. YMCA. I've not been out dancing for a long time. I forgot how to do YMCA. Quite hard with these ones in the mountain time because it's nearly 10 o'clock here now, and like, but I get up super early, so. And I've got one video to edit tonight, which I might download and then edit another time. Oh, it's tough work. But someone's got to do it. That'll be me. We've got 5 subscribers today somehow. I don't know how we got 5 subscribers, but we got 5 subscribers today, which is always nice. And they came early on before, I think 3 of them are before the stream started. So it might be from other videos, so. Is basically 5 to 10 in the evening. So, basically say like, say 10 o'clock then. So it's with you was 3 o'clock. So Joe Anthony, Joey, we skipped Jury. Joe, I bet you regret it though now. Now you're into all this crap. Bet you regret it. You'd love it, surely. Let's do the double again. I've never been asked to do jury duty, touch wood. Nearest one for me would be about an hour away, hour and a half, so I don't really want to do it. Because you have to go home every night. Oh, I'm driving every day. Oh. Is it state of Utah? Isn't that no one drinks? Is it, or is it you can't buy alcohol or something in shops or something like that? Are they anti-alcohol? I don't know. I just heard something because you got BYU there, haven't you? Mormon school. Utah State. What else we got there? Joe, you must be like a big Utah fan. Oh, is it BYU? Zach Wilson for the Jets there, but he was chuffed. Not quite turned out as you wanted him to, but it'd do good for him to sit behind Aaron Rodgers for a year or two. Oh, we've got 9 here. How many have we got? 10 here, 15 in Rumble. One Eve one. So I've got another chat here. So okay, you can't speak to each other. Okay, it's hard not to speak about the case though, Evie. Evie one. Oh, I find falling asleep here for this trial, let alone some of the others. Jesus. That's on Rumble. I got EV1, one EV1 over there. Loyal and follower now as well. So thank you, EV1. The trouble with when you fall asleep is when you start fighting it, woof, it's tough. I've gone a few times here. Sometimes you just can't stop it. Just got to let it go. You can't on jury, can you? Or streaming, really, but. Yeah, no. I said this right, everyone. I said this to Erin actually on YouTube. There's no way in hell, right? They don't talk to people about it, the trial. Like, even if it's not the jurors, you go home and you speak to someone about it. You know, with the Murdoch trial, 100% people are watching the Netflix documentary and, you know, stuff on social media and things like that. It's just human nature. You just can't do it, you know? But what? How do you combat that? You just like go, right, we're gonna lock you up for three weeks, no TV, no phones, nothing, and you're gonna be on a jury. You know, you just can't do it. So you just got to make sure it doesn't affect you as best you can, I suppose. But yeah, I don't think it'd affect me. I think I would be. I try my best not to look at stuff on Twitter and things, but I'd definitely speak to people about it. Well, I think I would anyway. I try not to preview the first couple of days, but then when you get to know people, you become besties, isn't it? They start talking to people. So, if you most people look at the person as guilty since they were arrested. Yes, it's so hard not to though. I bet that was hard. It's human nature though. That's what you see on Twitter all the time. These people, they're always like, oh, you know, innocent to prove guilty, but they always find the person guilty. That's that. Yes. Yes, 100%. 100%. I think I said that when it came out, it was ridiculous. He's the Sopranos guy. He's up here. Yeah, it's not about that though, Joe. It's about like making sure that everything's legit. We wouldn't have all these issues now if it was a fair jury, like, you know. I think that's the point, though. Do you know what I mean? The result's the result. It's a due process. A brother of a witness on the jury. Coming to conclusions in like, you know, less than 3 hours. It's like it's not right. In my opinion, anyway. But I respect your opinion, Joe. Whatever you think, man. We're all entitled to an opinion, guys. No, I believe that's not guilty as well. If the jury find him guilty, I've got no issues with that. If due process was followed, but it wasn't followed. It was a shit show. But I didn't think he was guilty either. I know the kennel video, but that's it. But there were so many other things that contradicted it. So if you're going to say the kennel video did it, what about the cleanup, the timings, the phones? So Carpenter out injured. Oh, sorry, you're here. That's how you're here then, Joe. Once you're back up and running, we won't see you as much then. Oh.
Judge, while the jury is not here, may I mention an issue?
Yeah, have them stop at the door. Go ahead, Mr. Owens.
So after this witness, there are 3 witnesses who haven't been able to testify, and so they're going to testify by deposition. Are they ready to go on Carrie Oaks? Because we withdrew that one, but we want to know, are they ready? to go.
Be ready.
And,
Yes.
and are you reading our parts too?
I don't know what your parts are, but.
We handed them.
Yeah, we got them about 15 minutes ago.
Right. It's just a matter of reading them though. I just need to know because otherwise.
We wanted to play video of ours.
But, you know, if the court wants us to read them, we'll read them.
Your Honor, we can't, Dr. Fong's video, as you know, took quite a while. We don't have that time if they want to call karaoke and rest. So.
Our video is 15 minutes.
No, but we're entitled to our talking too. So can we do it on paper, Your Honor?
What was the last question? I didn't
Can
hear
we
you.
just do it all on paper, the reading back and forth? We don't have time to review their
Mr.
video.
Sykes, are you fine with reading the deposition?
You know,
Actually, Kristen Van Orman is talking with James right now about it.
Right, but we're talking about like, we're going live here.
Right, and we've handed this to us, 15 minutes ago. We gave him our part a couple hours ago. We'd
Well,
like to.
James is right here. I don't know who.
Well, did you talk to Kristen?
I did not, but as I understand, Kristen is
We're-
amenable to reading it.
We're
Is
trying to
that
get
correct?
Dr. Bain. We'll go along with that if we can get Dr. Bain, but I'm not sure we can even get Dr. Bain except
Get
for
Kristen in here, would you?
2:00 for sure tomorrow afternoon.
All right, well, let's finish with this witness, and in the meantime, maybe it'll sort itself out. If not, I'll have to make a decision.
I'm trying to contact Dr. Bain right now.
Okay. Let's have the jury come in.
What a complete shit show this is. How can I don't get these? She does look gorgeous. She looks very, very nice. Gorgeous, she does. Make breed, Rosie. How can it's so mixed bag here? So the plaintiff's going to interview someone else? Oh, I don't. I give up with this trial. I don't know. I don't know.
Mr. Sorensen?
Whinging or enjoying it, so fuck it.
Dr. Edgley, thank you for being with us today and overcome a great deal to be able to be so accomplished, and we appreciate that. I'm going to go through a few questions pretty quickly, and I just ask if you wouldn't mind answering them yes or no, because they should be yes or no questions, and I think we can move this process along. Is it true, or is it the case that you're paid $500 an hour for records review and $700 an hour to be here?
I believe you have that information, and that is correct. That there is an opportunity cost by my not being at my regular practice. I'm not here for money. I get paid to offset the opportunity cost by my not being at my regular clinical practice.
Gotcha. So that is yes, though those numbers are correct.
Yes.
Okay, thank you. And is it true that, and as defense counsel pointed out, you did not ever meet with or see Terry Sanderson, correct?
Yes.
Okay. So you were paid to review records and do sort of a forensic records analysis, correct?
Yes.
We went over what you had reviewed in preparation to give and offer your opinions, and I didn't see that you ever reviewed the records of Dr. Boehm. Is that correct?
I don't think they were ever given that to me.
Okay, so that is correct. You did not review that.
I don't think so.
Okay. What about the records of Dr. Wendell Gibby?
Yes.
You did review them, or
Yes.
you did not?
I did review the deposition of Dr. Gibby.
Okay. That was not on the list of things that you said you relied on for your opinion. Are you aware of that?
No, I was not.
Okay. So is it your position that you did rely on some of Dr. Gibby's records to formulate the opinions you've offered so far?
So I did rely on the opinions of Dr. Gibby, yes.
Okay. And I did also not see that you ever reviewed the deposition of Whitney Smith, the EMT that we've heard from in this case. Is that correct?
I think that's correct.
Nor did I see that you reviewed the deposition of Carlene Davidson. Is that correct?
Who is she?
She's the plaintiff's former girlfriend that's offered testimony in this case.
So I did review her deposition.
Okay. And what about the man named Craig Ramone? Did you ever review his deposition?
Yes.
Okay. Neither of those last two were on the list of things that you say you rely on, so you were in fact partially relying on them for your opinions?
Yes.
Okay. I think we already covered it, but you did a forensic document review in this case. Is that correct?
Yeah, yes.
Okay. And in a nutshell, and I don't want to put words in your mouth, but you offered 5 main opinions in your expert report that you provided to us. Is that correct?
Right.
And really, because of court rulings, we're going to focus on 2 of those. Is that all right?
Yes.
Okay. Your first opinion that defense counsel went through with you is that compelling evidence indicates that plaintiff's concussion was mild and that he lost consciousness only momentarily, if at all. Is that your opinion?
Yes.
So you do believe that there's a chance he did lose consciousness?
And there is a chance, but more likely than not, no loss of consciousness. I have not seen any compelling evidence to formulate otherwise.
When you say compelling evidence, you're stepping into the place of the jury to weigh evidence. Isn't that correct? Is that a yes or a no? Sustained. When you weigh the number one opinion that you have that you've offered in this case, and you say that it wasn't compelling, is that because you weighed evidence?
I read, poured over many reports, many which were inconsistent. And I'm left to wonder, did he actually lose consciousness or not? I don't know. I would say more likely than not, the answer is no.
Okay. And for the reasons that you gave when defense attorneys were asking you questions, that's why you say that it was more likely than not that he did not lose consciousness.
Yes.
Okay. Do you need to have a loss of consciousness in order to sustain a concussion?
No.
And is there dispute among your peers and those of your specialty into the actual definition of what unconscious means?
I don't think so.
So all of those that are in your specialty would say that a loss of consciousness involves, I don't want to put words in your mouth, but lifeless and limp is the way you put it. Is that correct?
Yes.
So if we've heard testimony before this that you can be unconscious or have a loss of consciousness but still be somewhat awake, just disoriented or not alert, that's not correct.
That's disorientation, not loss of consciousness.
Okay. Is it possible that the amnesia that you talked about with defense counsel is or could account for Terry Sanderson's inconsistent testimony about how long he may or may not have lost consciousness?
Yes.
So that is a very real possibility in this case.
Yeah, actually, you cannot comment on your own unconsciousness.
So then we would be forced to rely on the testimony of those that were there or those that reported what they had seen?
Yes.
Okay. We've heard some testimony earlier about a triggering event. Are you aware of things that could be considered a triggering event?
The concept, yes.
Okay. Is Alzheimer's disease caused by a triggering event typically?
No.
Okay. Is dementia caused by a triggering event?
No.
Okay. Is NPH caused by a triggering event?
No.
Okay. Can the presence of NPH exacerbate a concussion or the symptoms of it?
It can in theory, but only for a brief period of a time. Brief meaning weeks to months.
Okay.
Not certainly not 7 years.
Okay. The jury's heard a lot of testimony about a condition called PCS or post-concussive symptoms. Are you aware of that condition?
Yes.
So is it your testimony that the presence of NPH could not be a risk factor in possibly leading to PCS?
Let me back up. So you should be aware if you're not already that the DSM-5, which is the list of psychiatric conditions, the fifth and most current edition says that if a concussion lasts more than 3 months, look for other causes, and I believe that they have totally eliminated PCS from their diagnostic menu.
So, and I don't want to misstate the answer you just gave me, but is it your opinion then that PCS and NPH are not related at all then?
You're asking me to state a categorical answer. Yes. No. I cannot say that there is no small, association.
Okay, so when Dr. Bang, for instance, testifies that it's rare, but PCS can occur after the occurrence of a concussion, is that accurate testimony?
I would like to, so I have an issue with the term PCS because I don't think it's, so whereas it was a valid condition, it's not, at least in the psychiatric world, it's not recognized as a condition now.
Okay, so, and maybe I inartfully asked the question, but essentially, if I hear what you're asking or what your response was, and again, I don't want to restate for you, but you're coming at this from a psychiatric perspective where PCS might be more of a clinical or medical diagnosis. Is that correct?
No.
Okay. Can anxiety and depression be risk factors for possibly having PCS?
Again, I take issue with the term PSCS, post-concussion syndrome.
Okay, what about, and I think we're talking about the same things, but I believe I'm talking about post-concussion symptoms. And I don't know that they refer to it as syndrome anymore. Is that correct?
Yes.
Okay.
So if you want to talk about post-concussion symptoms, we can have a dialogue. Yes.
Okay. And maybe that's my fault for misstating it before. I'll ask you the same question then. Can NPH be a risk factor for post-concussive symptoms?
So NPH is a chronic degenerative disease that is likely exacerbated by a number of things. The immediate aftermath of concussion being one of them. But more likely, much more likely than not, the concussion symptoms would have long, years ago gone away. And what we're left with is a brain that has NPH, microvascular disease, history of stroke, and is 76.
Okay. And you said history of stroke. I want to make sure the jury's clear. Mr. Sanderson had a stroke-like event in his eye. Is that what you're referring to when you say stroke?
Let me be clear to the jury. So the American Stroke and Heart Association considers a retinal artery occlusion as a stroke event. Yes, not a stroke-like event, a stroke.
Okay, but there's no scans, and you've poured over many in this case, that show any sort of brain bleed or any issues besides the MPH and other issues that we've talked about that would be related to that stroke event. Is that correct?
Yes.
And did you read anywhere in the medical records that you poured over that he had any sort of NPH symptomology before the ski crash in 2016?
NPH symptoms are insidious at onset.
Okay, and what are those? I think they're called the triads sometimes. What are the three main symptoms of NPH?
So this is a very layman's way of explaining it, but you have cognitive deficits, including memory loss. You have imbalance, and that can lead to falls. And you have urinary incontinence, loss of the function of holding urine in your bladder.
So just to recap, the triad is memory issues, ataxia, and then incontinence is typically how that's diagnosed, correct?
Yes.
Okay. And you did not see any of those symptoms in Mr. Sanderson before the ski crash in 2016, correct?
Before 2009.
And what were those symptoms that you read?
Well, no, before 2009, that's correct. But yet it was commented on the MRI of 2009. And given that those symptoms are insidious in their onset, happening over years, maybe decades. 14 years later, I'm not at all surprised to find the plaintiff experiencing memory and loss of balance issues.
Okay. Did you review any of the MRIs taken of his brain in 2017 after the collision?
Yes.
And did those MRIs that you reviewed, did those show any sort of a worsening of this NPH?
They commented on it. I don't know if the scan showed worsening.
Okay. So you don't know one way or another if it worsened or not, but they did mention that that condition was present.
Yes. And that NPH is a clinical diagnosis verified by radiology findings.
But nobody had diagnosed his NPH before as having the triad that we talked about before. Correct.
I did not see any mention. Yes.
Okay. And you were asked a lot about plaintiff's medical conditions. We had a board up here. We had a whole list here. Did you read anywhere in the depositions that you reviewed that any of the laundry list of medical issues that the plaintiff may or may not have had before the event kept him from being a world traveler or on the go or even skiing that day?
The fact that 3 weeks earlier, he said to his primary care physician, "I feel like I'm getting old." That is most likely based on, as you said it, that laundry list of conditions. They're taxing. They're no one condition is that problematic, but the complication of those various conditions do weigh on a person both physically and psychologically.
Sure. But then if that is the case, doctor, how do you reviewed some of the daughter's depositions, as you said, how do you account for their accounts of what happened with their dad directly after the ski crash in 2016?
I'm not going to make the claim that there was not a transient decrease of function up to 3 months. But beyond 3 months at time, what decline he had was more likely than not already the ball was already rolling.
Okay. You testified earlier that you've been an expert in many cases that have gone into litigation. Do you remember when you testified of that?
Yes.
Have any of those cases been ski crash cases?
No.
Okay. So this is your first ski crash related expert testimony?
Yes.
Do you know what confabulation is?
Yes.
And what is that? Will you explain it for the jury, please?
Confabulation means making information up.
And it's not just lying per se, right? It's not just you're grabbing it out of thin air. There's a little bit more of a clinical definition for it. Isn't that correct?
I don't know where you're going with this.
Well, it's not just confabulation is an actual medical condition. It's not just creating lies, correct?
It can be related to a medical condition, yes.
Is it often seen in situations where people have had a brain injury?
Yes.
Okay. So inconsistent testimony by the plaintiff may be attributable to confabulation if his story is to be believed that he has a TBI.
So to point that symptom, confabulation, to the brain, alleged brain injury, sure, it's possible, but plenty of other things could account for that symptom of a confabulation.
Sure, but it is possible, as you just said, correct?
Yes.
And from the 2009 to the last scan that you saw, and I don't know when that was, probably the 2017 scan, have you seen any of his symptoms, the symptomology that you reviewed earlier, getting progressively worse from an actual imaging standpoint?
No, but we're talking about clinical diagnoses backed up, only backed up by imaging. Yes.
Sure. But there's no physical, you can't point to any scans that say this is different than it was in those early scans in 2009.
Nor would I necessarily expect to.
Do you know what the medical term discordant means?
Yeah.
Okay.
We don't often use that.
Okay. And what does it mean?
Well, it means loosely that things don't make sense and don't add up.
Okay. You've been asked a lot about Mr. Sanderson's medical records and radiology reports that you reviewed. I'm going to show this first page of Plaintiff's Exhibit 6 to the jury. Do you see this radiology report right here?
Yes.
Okay. I'm going to zoom in here for all of us, and I've moved us to avoid the address on the bottom. Sorry about that.
I don't understand most of this. I do think it's interesting. So that's why I'm not giving any commentary.
That paragraph that starts with the word findings. Do you see that?
Yes.
Now, will you just read that first sentence for us right there?
Demonstration of a prominent ventricular system discordant with mild cerebral volume loss in sulcal prominence.
Now, you have the degrees and I don't. So does that mean that the prominent ventricular system, the issue with that ventricular system that you described earlier, is discordant or not related to or different from the mild cerebral volume loss with sulcal prominence? Is that what that means?
So I don't suppose to get into the brain of the neuroradiologist, but that is a valid conclusion. So
that's my layman's approach of reading a medical record, and I recognize you have that, and I respect your position. But the medical records that you reviewed, discordant is usually used before describing this ventricular issue that you described earlier. Isn't that correct?
I think we're talking about two separate things: the enlarged ventricles, and as a separate issue, the mild cerebral volume loss.
Okay. And short of going well beyond both of our expertise and sounding more like an idiot than I'm sure I already do, I think we'll leave that one there. But these aging conditions that you describe, is it also within the possibility of medical certainty that you've offered your opinions that Terry Sanderson's condition could be in fact related to post-concussive symptoms?
That is not what the medical literature shows, but so I would say much more likely than not.
It is possible, correct?
As far as anything is possible, yes.
Okay. Thank you. Let me just check with co-counsel, and I think that's everything I have for you.
The point he's scoring is for him to say things are possible. So it's not a win per se, but in their closing arguments, they could say, well, they said it's possible, so it could happen.
So if other witnesses reported massive changes directly after this ski crash in 2016, would you also attribute those massive immediate changes to the aging process?
Restate the question.
Sure. If other witnesses, ex-girlfriends and daughters, report massive changes in the plaintiff after the ski crash of 2016, would you also attribute their discussion of those massive changes to regular aging?
This is a complex question. He had distress over very real rib fractures. He had psychological and physical symptoms that do influence, a patient's global functioning. Rib fractures healed. Bumps and bruises heal. What we're left with long term. So I don't disagree with the fact that people around the plaintiffs said that there were big changes in his physical and psychological function immediately after the injury. But there was brain-related issues should have resolved within weeks to a few months. And what we're left with is a 69-year-old at the time brain with multiple problems.
Sure. But looking over the medical history that, like you did, you see that Terry Sanderson continued to try to seek treatment for something that was going on that he attributed to be fairly related to this accident, correct?
I would say that medical attention seeking behavior started before and evidence by his primary care physician visit the 3 weeks earlier, and that was likely a ball that was already rolling.
So he was interested in his health before the ski crash. You've testified to that, correct?
Yes.
So he would be very interested in anything that he viewed to be very acutely changed. Isn't that also correct?
Yes.
So it would be part of that pattern to continue going to the doctor a lot up until you think that you're going to get some sort of resolution of your symptoms. Isn't that correct?
I don't suppose to know what was going on in the plaintiff's mind.
What's going on here? That's a nightmare. Oh, crap, we're gonna have to go back to the old one. Record the other one.
Nod, yes.
And you were asked about a new word. Confabulation, like lying. You were asked about that, right?
Yes.
Did you review the deposition of Jenny Sanderson, the daughter?
Yes.
Did you observe she said that her dad would, in fact, be dishonest in order to get money?
Yes.
Objection.
Beyond the
That's
scope.
not an evidence.
No, that's not an evidence.
It is.
Jenny Sanders is not an evidence.
Yeah. Overruled.
And that he seeks attention, and that the notoriety of this case makes him feel powerful. Did you read that?
I did.
And on our little break, you said it's outrageous. You said something was outrageous, that they would assert something. What? Do you remember what it was? His current conditions are related to the ski collision.
What's
Am I throwing you?
now? I'm picking my words very wisely.
Thank you.
The neuropsych evidence and the psychiatric evidence have evidence to support that when a concussion like this alleged concussion lasts over months, there is a high concordance rate with the patient being involved in litigation and also media attention. Both
Beyond the scope of his proffer testimony.
Overruled. That's how he explained the post-accident.
Both of which are hyper real in this case.
Hyper real means what?
Very well, real. Very real.
What is hyper real? I missed it.
So it's just a colloquial
Term.
for extremely, so extremely real.
What is, again, extremely real?
The factors of this litigation and the factors of the media attention around his concussion case.
So what of those things is hyper real? What are they doing to him about his current symptomology?
Well, so
I'm trying to understand his response, Your Honor.
Overruled. It goes to the weight.
You got to dumb it down for me, please.
the fact that this is the first legal case that is ever televised in Utah makes it hyper real.
In what way to Mr. Sanderson? What is that doing to him, those facts?
Foundation, Your Honor.
I'm just trying to understand his comment.
Maybe you could go into a little bit more of the background behind this opinion.
Yeah, I'm trying to understand the point you're making. And then what it's based on. This very litigation and the media attention is impacting Mr. Sanderson. Is that your opinion?
Overruled as a preface to the question.
Absolutely.
Okay, and then how?
So the litigation, so a lot of money is in play here.
And how is that affecting Mr. Sanderson?
Your Honor. He can't
Sustained.
So I'm being told to sit down. Have a nice day.
Mr. Sorensen?
Just one question for you, Doctor. Is hyperreal a medical term?
No.
Okay, so that's has no basis in any sort of medical literature.
I would say extremely real, extremely relevant.
Okay, but again, you never conducted your own psychological evaluation of the plaintiff, correct?
No.
So that would be pure speculation about his motives or anything like that.
Based on a number of studies and meta-analysis of cases similar to this.
So case studies, but nothing directly attributable or applicable to Dr. Sanderson.
Case studies. So meta-analysis of actual things that are in the medical literature.
Thank you very much.
I would say he's more intelligent than everyone.
Okay, you may step down. Thank you.
Across the world.
You ready for your next witness, or should we take our last break?
Your Honor, definitely let's take our last.
Okay, we'll take a short recess.
So I found it hard because he's obviously clever, but he's too clever. That's why the lawyer was trying to get him to dumb it down. I think the jury would understand it and believe everything he said because he's just so clever. I think it's a good witness for them.
Short recess. Thank you.
Got a lot of respect for that guy.
I can see that.
We've come up with a plan for Carrie Oaks.
Good.
I guess I'm gonna be karaoke.
Okay.
We just have to figure out who on our side is going to read the questions. Because there's only one additional question that was added by Wayne Owens, we're just gonna have the same lawyer read all of the questions, and I'll respond as karaoke.
So Noreen could do it.
That's what I had asked.
You good?
Questions? Or
Sure.
Bob would-
I think it's nice to have both of one member from each
You
team.
guys decided that.
So I have the hard copy. Are there any objections?
I don't think there are on the mark.
Okay, I'll follow along if you'll
Yeah.
key me in on where you're at.
If there's some like objection calls for speculation, but I think we're good with everything.
Okay, thank you.
So, Aaron,
We're taking a short break before you begin.
Your Honor,
same mindset.
Yes.
one other thing on Dr. Richard Bain on rebuttal. We don't know this yet, but we would like to propose that to hit Dr. Bain, and if it's okay with the court, that we have him testify at 9 or even 8:30, 8:45 Thursday morning for a very short rebuttal.
Can we deal with this at 5?
Let's do it at 5. Thank you.
Well, it's hard for us to propose it if it's not approved.
You mean he's waiting for the word from you?
Well,
That's part of it, Your Honor. He's
yeah,
trying to
this week is
schedule
his wedding. He had an emergency medical procedure.
Is his wedding?
his daughter's
wedding.
Oh, okay.
His daughter's wedding. He had an emergency medical procedure. We notified the opposing counsel about 3 or 4 months ago that he couldn't do his attend trial. And so,
Well, I'm not sure when your rebuttal case is, but if that's when your rebuttal case is, that's fine. We can come a little early on Thursday. If that's not when you,
Deal with this at 5.
Yeah, we can do it.
I'm not in the zone.
getting back to Carrie Oakes, the witness, how are you going to allocate the time between the parties?
based on the time of the questions that they asked.
Well, the
So
thing is,
apparently there's one question for the defense and the rest of it's for the plaintiff. So whatever, however that works out to be.
Ours was about 15 minutes long. They proposed, I think, like a half an hour, 45 minutes of additional questions.
So we didn't call her, we didn't want.
You had designated her as a witness, and we only wanted 15 minutes. If you want to just let us do our 15 minutes.
Noreen has a comment on in response to that.
Yeah, so this is not going to take us 45 minutes to read the portion designated.
So let's go ahead and change questioners depending on which side has asked for that question, and then I'll be able to keep track of the time.
Oh, we didn't do that. We just marked jointly the time. It's literally, Your Honor, I would say their time is probably 5 minutes of the.
Total. Are you fine with 5 minutes? Okay. Then 5 minutes of the time will go to the defense and the rest will go to the plaintiffs.
Okay, I wasn't involved in the.
All right. Thank you.
Thank you.
So Erin, thanks for reading my mind. I thought exactly the same as you. Very impressive guy. Now I've got to talk about this. Love Recess. I love her as well. They are like children. So the problem is here, right? The defense have got until Friday, basically. What's that sound? Sorry, till Thursday morning to finish everything. They're not going to finish everything by Thursday morning, I don't think. So the rebuttal witness, I think that's why the defense was sort of 5 o'clock, because they're like, we ain't finishing by Thursday, mate. And also, it's interesting because both sides have got set times, so we just see how long each one have taken. There's a lot of fine margins in this one that I do find interesting. So I can't even guess what we're going to do next in this trial. But I trust the judge. I like the judge, so I trust him. Who else we got left here? Is Chrissy left? Is she? But right, Big Mike. Wait, I messaged him. Stacey messaged him as well off my one. Channel content, no, not that one. This one, no, that one. YouTube. I mean, it's not like Big Mike to be missing for this long. So this is what we of course. Sorry, why you say sorry? It's not your fault, it's all good. So you can see, and so if anybody else was to call, give a comment or whatever, or message him directly, let's get Big Mike back here. We need to get Big Mike back some way or another. So that's my comment. I don't know how you go get my comment, but you know, that's where it is. Come back, Big Mike. It's such a shame because he's a great contributor. It may be because he's busy. We're doing all this work, but he might be in chat now, laughing, going, "What these idiots?" I think it's save as well. Oh, he was here this morning. They just left abruptly, so we were joking about. I'm not sure if he did take it as a joke or not. So I think, I don't know. I don't know. Just have to take it as it is. Hopefully he comes back. Where is this one now? No, that one. What's the this one? Fine. Yeah, we all need a break. It's all good. Yeah, right. I mean, that's the thing that you've done, Stacey. It's all good, like, you know. So well, he could be actually just working all this time as well, because people have got work. Chrissy, we haven't seen much of Chrissy today. Oh, she popped in. She's probably popped out now. So the usual crowd, you know, Shannon, she's not really been in here today. So no, Stacey didn't scare him off at all. There was just a disagreement, shall we say, about Big Mike thinks that California is a shithole. So basically, that's where it came from. And obviously, Stacey comes from California. Wow. God. Yeah, you should be proud of it. I see everyone's reporting Mandy's tweets on Twitter. Yeah, it's just Big Mike is a character. Big Mike sometimes doesn't know where the line is. So Big Mike, when he's got an opinion, you're gonna know about his opinion. So he just thought his opinion is that California is just a shithole that has shit and homeless people all everywhere. And obviously, you know, everywhere has that. But White Castle Uber Eats. White Castle. Is that a restaurant? Joe, it's like a takeaway sim, a burger joint or something, isn't it? I've heard it's shit. But I don't know. I just heard it on TV once. Yeah, but Mandy, whatever her name is, has told everyone to report it to get it banned, Rosie.
Quick matter, Your Honor.
Let's wait for the other side.
Would you like me to go get them, Your Honor?
Yes.
Or is okay.
Yes, please. Thank you.
So gross.
You know, people blocking, reporting this Monday tweets thing now. They'll probably come out. People come down. Or they might be banned already, I don't know.
Are we on the record?
Yes, we are.
Okay, we're back on the record. Council are present and parties are present. Mr. Owens?
Yes, thanks. So we're thinking this karaoke is going to go about a half hour, and then we're trying to figure out how to best use that other half hour.
Sure.
One option is, well, here's the question. How strictly, we now have essentially one full day of evidence left. How strictly are you keeping us to like 4 hours each left?
Strict.
Strict.
So when you run out of time, you're done.
Okay, so.
And I'm trying to be mindful of the jury.
So depending how much time is left, then we'll call Terry Sanders back to the stage, back to the pulpit.
We talking tomorrow?
No, if we have time before
tonight.
5.
Okay.
Thanks.
All right. Ready for the jury.
We assume that you'll explain to the jury what we're doing.
I will.
Okay, thank you.
Do you want to go ahead and take your seat?
Yes,
Okay.
sure. Do you swear me in?
That you'll read? No, I think not. The lawyers will point out any errors in your reading.
It's better than swearing at you.
What page are we starting on?
So
We are starting.
the funny thing.
Okay.
Like, we're gonna try and say, if you jump to the next page, we'll let you know.
Okay. Right. Thank you. And who's doing the questioning, Ms. Abarama? Okay.
Use your deepest voice.
I can do without the commentary. Thank you.
Don't make objections.
gallery here. So, interestingly, it's all time-based, all this. Oops, muted myself as I was talking.
Thank you. You may be wondering why Ms. Van Orman is seated as a witness. We are now going to read a deposition, old school style. So the witness name is Terry Oakes.
Carrie. K-E-R-I.
Thank you for that correction. It's listed two ways in here. Carrie Oakes, and the person that will be reading Carrie Oakes' part is Miss Kristen Van Orman, and the questioner will be Miss Abarama. You may proceed, starting on page 6.
Judge, would you like me to state the page number and the line number?
I think if you, right now, just whenever you skip areas, tell me where you're going.
Okay.
And probably just the
otherwise
page. Don't need to do the lines.
Will
Yeah.
do. All right, starting on page 6. Good morning, Miss Oakes. Could you spell your name for the record?
Yes, it's K-E-R-I and Oakes is O-A-K-S.
And do you know about what year you started working at Deer Valley?
It's page 12, Your Honor. 1990. Actually, that was about that area, give or take a couple of years.
Page 16. Okay, when we talk about the incident or the ski collision or the ski crash or similar words, let's just agree right now that we're talking about the incident that occurred on February 26, 2016, involving Gwyneth Paltrow and my client, Terry Sanderson. Is that clear?
Yes.
Okay, now I would like to go through some of the parties to this case. Do you know my client, Terry Sanderson?
Not beyond seeing him on the hill that day.
Okay, have you had any other contact with him prior to that or subsequent?
Where I spoke with him or no?
Okay, what about Gwyneth Paltrow? How long have you, or before this incident, do you know Gwyneth Paltrow?
That may have been the first time that I skied with her family. I don't recall exactly how many days I skied with them.
Page 18. Okay, 1 or 2 ski trips you've skied with Gwyneth Paltrow, correct?
Correct.
Sorry, if you could speak up.
Correct.
Okay, what about Brad Falchuk? Do you know who he is?
Yes.
Did you ski with him on the ski trip that involved this ski crash?
In what capacity?
I mean, did you meet him?
Yes, we met him.
Okay, and I understand you were teaching primarily one of the children with some of the children. Is that correct?
Not his children.
Okay, whose children were you teaching?
Gwyneth's.
And who are they?
Apple is specifically who I was with.
Okay, and were all of the ski trips with Brad Falchuk and Miss Paltrow's children, they were all on the trips with Gwyneth Paltrow, correct?
Correct.
You didn't ski with Brad Falchuk or the children on the trips where Miss Paltrow was not there, correct?
Correct.
Did you know who Greg Ramon is?
No.
Do you know who Eric Christensen is?
Yes.
How do you know Eric?
Through Deer Valley, we worked together.
How long have you known Eric?
Since, I don't know the exact amount of years.
Page 31. What did you discuss on the day of the collision with Eric Christensen?
Particular?
Anything about the collision with Miss Paltrow and my client, Terry Sanderson?
A relief that everybody was safe.
And
It's too painful.
Everybody, meaning both people who collided.
Miss Paltrow and Mr. Sanderson?
Yes.
This is too painful.
Page 53. So just before the ski collision, please describe what was happening. Had you all met at the top of Flagstaff Mountain, for example?
Yes, we got off the chairlift, decided that we were going to go down to lunch, and...
Can I interrupt? When you say we got off the chairlift, who is we again? Just so we're clear.
The we would have been Gwyneth, Apple, and I were on the chairlift. I believe that Eric was with Moses. Then we met up with Brad, and I cannot remember exactly where his kids and their instructors were. They may have been down already, having the table for lunch. So we decided to go ski down Bandana to the Empire Lodge for lunch. Then as we started skiing down Bandana, it was not crowded at all. There was really nobody on the run. And Moses and Apple wanted their mom to watch them, wanted to do the side of the run, and she could see them ski. So we stopped to cross the run. The run was clear. There was nobody in front. It stands out in my mind because that's a rarity. Bandana was empty where we were, and so we had just crossed the run. And as I looked before we crossed the run uphill, there was really no one in sight, except farther up by a slow sign from where we were. And we crossed, made 2 turns, and then I heard the sound and looked over, and that's when I saw that they had collided, and we were both on the snow.
What was the sound you heard?
Just I heard her voice, and that's what caught my attention.
So I want to just go back over this slowly.
Yeah, just go to 56.
You inserted a word inadvertently.
I apologize. And that's when saw that they and were both in the snow. Go ahead and just read the rest of the page, that's fine.
And what was the sound you heard?
Just I heard her voice, and that's what caught my attention.
So I just want to just go back over this slowly. You started skiing down Bandana without Apple and Moses, correct?
Still on 55.
Okay.
You want to ask that one more time?
Sure. So I want to just go back over this slowly. You started skiing down Bandana without Apple and Moses, correct?
And Gwyneth and Eric, correct.
And you said you crossed the run. Was that near the top of the run?
Near the top of the run.
When you say you crossed the run, does that mean you went skiers left?
Yes, we were on skiers right, and then we had slowed down, or actually, I believe we might have even stopped enough that we were in a group. And then I looked uphill before we crossed, just to make sure it was safe. And then the kids and Eric and I crossed the run. Skiers left.
And were Eric and you above Apple and Moses when you did this?
He was behind. He was above hill, and I was more to the side and a little above hill.
And then what happened after you started crossing to the left?
We crossed to the left and started skiing down the side, and then we heard, after, as I said, 2, maybe 3 times, heard the sound of, it was more Gwyneth sounded surprised. It was like a surprise sound, and, we looked over, and they were both on the ground.
When you started to cross to the left, did Miss Paltrow then go straight down to the right? Is that what she did?
She stayed on the right, but she did not go straight.
Were you able to see her while you were watching Apple and Moses?
Yes, I was able to see her.
How was she skiing?
She skis small radius turns, consistent speed. At this point in time, it was slow because she wanted to be able to see the kids. They were not skiing fast because the kids are not fast.
Was she then going to stop and look up, or was she going to look to the left, She
was not going to stop because we were skiing.
Okay. Is it your understanding Miss Paltrow was going to look to the left while she was skiing to her children skiing?
No, I cannot say what she was going to do. They were in her sight, and the goal was to ski down to the lodge for lunch.
When did the topic of Miss Paltrow watching her children come up?
Watching her children ski.
Welcome for the first time.
When did the topic of Miss Paltrow watching her children ski come up?
It was, Mommy, watch me, and we want to go ski this, and so we took them to the side. It wasn't a detailed plan on how she was going to watch. It was just a plan to ski down to the lodge.
Okay, and when Eric, Moses, Apple, and you started skiing to the left, was Miss Paltrow skiing on the right?
Correct. She was skiing on the right.
Page 68.
I've had enough of this already.
Was Miss Paltrow agitated?
When she was first getting up, because she was very surprised and shocked, because that was her comment, was that he hit her.
What was her comment?
Her comment was that she was hit and was frustrated, but then as she got up and she checked on him. He checked on her. Everybody was quite calm. Nobody was agitated or yelling.
So the volume down a bit because she's
When
too
did she
fucking
ski
nutty.
off, Miss Paltrow?
I don't
This
recall
one is.
exactly. I believe she was there for most of the time, and
The other girl's
yeah,
fit as fuck.
she
but
was
this
there for
one
most
is
of the
sweating.
time. I think that when we had when it was verbalized that everybody was okay, Mr. Sanderson verbalized to us that he was okay, he was fine, and that was his response to her checking. We checked. Ski Patrol checked. And so then at that point in time, that's when we said, okay, let's start. We can start dispersing because everyone expressed and we were acting as if they were just fine. It was just a collision, no harm, no foul.
Chap,
Earlier
Harris,
you
brand
mentioned
new.
that Mr.
Give
Sanderson
the same
got up.
welcome
Do you recall anyone helping
as we
him get
usually
up?
do.
We were there, both Eric and I were there to help him. I don't recall that he didn't need us to lift him off the snow. I don't recall needing to give much assistance, but we were there for both parties to help them both and make sure they were both okay to our abilities and then assess him. From then, we would assess if there was the need for ski patrol to be called, but they happened to ski by and check themselves.
Page 71.
And subscribe
Why
as
do
well,
you write an
Copyara.
incident report back?
And like the video. Appreciate that.
Because nobody,
If you
to our
could.
knowledge, nobody was hurt.
And welcome.
Everybody left the scene on their own volition and everybody was able to leave. And it was, again, like just any other incident where people, got tangled up and everybody was okay and everybody left. And so.
Page 82. Did Gwyneth Paltrow say she didn't see Terry Sanderson before the collision?
She did not use that. I mean, he wasn't in front of her, so he was not in front of her, but she didn't use that phrase. She said, he hit me.
You're assuming she was in front of him, correct?
I saw that there was nobody in front of her when we were skiing, and so that's not an assumption. There was nobody on the hill with us in our immediate vicinity.
Page 106.
Let's get in. Forward. She's fit,
Miss
by the way.
Oakes, just before the collision, Gwyneth Paltrow's children, Moses and Apple,
Thank you,
wanted her to
Copyara.
watch them skiing, correct?
Yes, we were skiing together down the final run down to lunch.
Miss Paltrow was skiing down to the right, looking up at her children to see them skiing, correct?
She was skiing down on the right side. Her children were in her periphery.
Can you rewind one more time to what page we're on?
Sure, now we're on page 107, starting on line 14.
Oh, great.
So she was looking over at the kids to see them ski.
Are you on Twitter?
I can't say exactly where she was looking. They were in her periphery. She could see them while looking ahead to ski.
So Miss
Shoot, put it in
Paltrow
the
was
hand.
distracted,
Chat.
looking at her children while she was skiing just before the collision.
I would not say, well, I can't say that she was distracted.
Was Miss Paltrow looking at her kids while she was skiing down Bandana Run?
When I saw her, she was looking ahead at the run in front of her.
Was she also looking at her children skiing?
I did not see her looking at her children.
So Miss Paltrow was distracted when the collision occurred, looking at her children, correct?
She's not looking at her children when I saw her. She was looking ahead, skiing down.
So she wasn't watching her children. Is that what you're saying?
Oh, it's a nice piece all day.
Yeah, I didn't. They were in her periphery. I don't know what she was looking at directly. I don't know that she was looking at them directly. She was looking ahead where she was skiing when I saw her.
At the moment of the collision, though, you had not seen her for 3 to 5 seconds, correct?
Probably 3 to 5 seconds.
So you don't know where she was looking, other than she was supposed to be looking at her children, right?
I don't know exactly where that she was looking directly at them. I do know that when parents ski with their kids, it doesn't mean their eyes are glued on their kids. They can glance at them. They can see them in their periphery. And as long as the kids know the parents are there and they're in the visual, that's what the kids want. I don't know exactly what she was doing. The children were satisfied.
Moses and Apple wanted their mother, Gwyneth Paltrow, to watch them ski down Bandana, correct?
That's what they had said. Watch us ski this, Mom. Okay, that
No,
was the
it's not.
conversation.
Page 111. Okay, and then maybe you already answered this, but in that, when you last saw Miss Paltrow, the 3 to 5 seconds before the scream, did you observe whether there was anyone below her on the ski hill?
I observed that the area in the front of her was empty.
I think that's it. 111.
And that's it.
Okay. Thank you.
May I be excused, Your Honor?
You may.
Oh, fuck it. Fuck off.
Right.
Are you on Kapihara? Are you on Twitter? What's your handle if you are?
Mr. Owens, you may call your next witness.
Could we have a quick bench conference here?
You know, I've only done it for 3 weeks, so I've just started out Kapihara. I'm literally just starting. So I'm started here and also on Rumble, Discord maybe, but I got to concentrate on like one side. So I need to get subscribers right up, which I've got a quarter what I need. Once I get that, maybe I'd look at Discord or something. For now, it's just like also getting people to go on Discord is really hard because I don't know, people tend to have YouTube but not Discord, not Twitch or anything. Oh, sec. Well, if you do have a Twitter, it doesn't matter if you do. They don't have to tell us what it is, but if you do, then chuck it down. Also, have a look at all the videos. We're brand new, so you're starting on the ground up with us. If you come here and watch our videos, we've got low numbers, but we are a mighty army, small army, but a mighty one. We will be once Big Mike comes back. Right there and there. Okay, we'll just have to see then with that one. Ba 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 da ba da. Right, there's that. Oh, look here. I'm learning as ready I am. Chip champ or something it's called. That's what I'm on. Small but enthusiastic, yes. You just described yourself, Erin, and also the whole chat. No worries, Joe. Grab your white whatever castle. Absolutely. Oh, yeah. I do need to do one. I've been meaning to do it. If you want, message me on Twitter. I do need a better overlay. If you could do an overlay for YouTube. And a logo as well, I need. Big Mike. White Castle, that's what he's having. Bon appetit. T. Thank you. Yeah, I don't know what that is. Kapihara. I don't know what any of that means yet. My handle, hang on. Where's my handle? I'll put it up here now so you got it. There you go. That's my Twitter handle. Well, As I say, we're brand new here, so I'm not like everything that you see is basically what I created, which just doesn't say much, but I've invested enough money on equipment and shit so far, so that's why I need this to pick up, pay for everything. Oh, come on. What are they talking about now? Come on, guys, Jesus. This judge loves to stop at 5 o'clock as well. Like, he doesn't mess about. No idea what's going on. Just want them to. Let's get ready to rumble. Yes. Yes, Evie. She does. Very nice, though.
Okay, the parties have stipulated a fact, and it looks like it will save us some time. Mr. Brad Falchuk, who may or may not testify later, depending on how much time there is left in the case, the parties have stipulated that he would testify were he to be called as a witness, that he did not see the accident. Is that correct from the plaintiffs?
Yes.
From the defense? Did the court correctly?
I believe so.
Okay.
He may or may not be called if there is time. Thank you.
All right, thank you. And so we'll now move to the defendants have a deposition to read.
Yes, we're going to try to get to the two kids' depositions. First,
Are we reading the entire deposition or
No, the marked version, Moses. So we're calling Peter as a fake Moses to the stand.
Okay. So
Steve,
Peter will read
have a
Moses.
marked copy?
Let's look at it
I
all.
have a marked copy.
She looks hot. Get back to her. This is going to be painful again.
I'd like the lawyers to each read their side of the questioning so that we can capture the minutes used by each side.
I just need to get my copies back that I gave to them.
What if we, because we don't have two more copies because we're doing this on the fly, what if we, we'll read out Moses all the marked part, and you read Apple all the marked part.
That's fine.
Let's do this.
Yes.
You don't want to fucking do this.
That's right. They're not. You know what? You better keep it. Yeah. Just in case.
Okay. Kind of weird, but I'm the questioner and you're Moses.
Correct.
Do you recall how old you were at the time? Thank you. Page 7. Just make sure that's it. You were time.
9.
Okay, I'm turning the page.
I need to clarify that.
Oh my God.
We're going to back up because there's some gray. Could you just spell your name for the record?
Protected identity.
Okay, so we all stipulate this is Moses Martin. I'm on page 7. As you know, we're talking about this ski collision that occurred about 4.5 years ago. Are you familiar with that?
Yes.
And I'm going to pick up where I was. Do you recall how old you were at the time?
9.
Okay, and you recall this ski trip in February of 2016, correct?
Yes.
About 4.5 years ago, correct?
Yes.
Okay, you recall skiing that morning that your mother was involved in this ski collision, correct?
Yes.
I'm now turning the page to page 9 at the bottom. Okay. When this ski collision occurred, do you recall where you were at the moment the ski collision occurred?
I do not recall where I was at the moment it occurred.
Did you see the ski collision?
I did not see the actual collision.
Okay, so let's just start maybe at the beginning of the run.
Don't have this, but cool.
Yes.
The run is called with the bandana run.
Yes.
Okay, at the time of the collision, did you, or just before the collision occurred, you were skiing from the top, is that correct?
Yes.
And who were you skiing with?
From what I recall, my instructor, Eric. Page 11.
Page 11, line 22. And you were skiing with Eric as your ski instructor just before the collision, correct?
Yes.
And do you recall who else was skiing with you at that time?
No.
Was your sister AM, meaning Apple, nearby?
Yes.
Do you know where she was in relation to you on the hill?
No.
Could she have been below you?
Yes.
You don't recall seeing your sister?
Not exactly. No.
Tell us what happened on the bandana run just before the collision. What do you recall?
I recall skiing with my instructor and briefly seeing the collision. And then he skied over and I followed him. And I saw my mother and a person behind her that he had crashed. Who had crashed?
Okay. Did you hear a noise before the collision?
No.
And the person behind her, was that a man? Was this person from your mother?
Yes.
How close were they, your mother and this other man?
As I recall, decently close.
Let's just say, this close, see my hands, they're about a foot, about 14 inches apart, or were they further apart?
I think something like that, but I'm not 100% sure.
Were they touching each other?
I do not remember.
Was her head above her skis So her head was uphill and her skis were downhill?
Yes.
And the man
That's
that
true,
was
Anna.
nearby her, where where was his head in relation to hers or to his body? Was his head uphill or downhill?
Uphill.
So I'm just going to go back a little bit. So when did you first realize your mom was involved in a collision? How did you realize that?
I realized the equipment that she was wearing. I know that she wears what she wears when she skis, and then I realized that it was my mom. So I was standing around. I realized that it was my mother.
And did you hear a noise that told you there was something going on, a commotion or anything?
When I skied over, I heard my mom yelling at the guy.
What was she saying?
She was saying something along the lines of, "What the F word? You just ran into me."
And anything else that you recall at that moment?
No.
Was she standing up when she said that?
I do not fully remember, but I believe she was on the ground lying down.
Okay, did she get up by herself?
I do not remember.
I'm just going to go back in slow motion to, let's say, 3 seconds before this collision occurred. You were skiing with Eric. If you're facing downward, skier's left is on the left side and skier's right is on the right side. Do you know which side you were on the hill just before this collision occurred?
I was on the left side.
Do you know how far on the left you were?
No.
Do you think that...
But farish.
Okay. Were you closer to the left edge of the ski hill?
I believe so, yes.
And do you recall anyone else on the hill at that moment?
I do not remember.
Were there other skiers on the hill?
Yes.
About how many?
I'm not sure.
And so what made you ski over to your mother? Did someone tell you?
I was following my instructor, but I did not know what was going on.
So you followed your instructor over to where your mother and this other man were lying down, correct?
Yes.
That scene, your mother and this man laying down, what else do you recall?
I recall skiing over, seeing a few people around them. I remember my instructor seeing what was happening. And then I remember my mom on the ground downhill of the man that was uphill from her. And I recall that they were both on the ground at the time that I skied over.
About how far away do you think they were?
I do not recall. About a foot, maybe.
I'm asking how far apart your mother and the man were when you skied over there.
I'd say a foot, maybe more.
Were they touching?
I do not remember.
And do you remember your mother getting up?
Yes, but not for a while.
Okay, how long was a while? 5 or 10 seconds?
I'd say 2 minutes, maybe.
And how did she get up?
I do not remember.
Did she get up by herself?
I do not remember.
Did someone help her?
I do not remember.
Do you recall a large man next to the ski collision location?
I do not remember.
You said there were some other people there. What do you remember?
I remember seeing a few people, not a lot, but maybe 3 people, not including my instructor.
So there was your mother, the man that was involved in the collision, and then there was your instructor. Were there any other people?
I believe so.
How many other people do you think?
I do not recall.
Was there 1 or 2 or 3 or 4 maybe?
I do not recall.
And then what did you do after you skied down to your mother?
I stood there wondering what was going on, and then I believe that afterwards we went to eat lunch.
I remember it. And who is we?
As I remember, it was being me and my instructor, and I'm not sure whether my mother came down afterwards or with us.
So you skied down with your instructor to the bottom?
Yes.
Of the hill?
To lunch.
So you skied down the hill with your instructor, Eric Christensen?
Yes.
Anyone else ski down with you?
I do not remember.
Just before the collision, your sister was somewhere in the area skiing with you?
I believe so.
Anyone else in the area?
I don't remember.
Do you recall Apple's ski instructor?
No,
Do you recall her being present, the ski instructor for Apple?
I don't remember.
Do you remember Apple's ski instructor's name being Carrie Oakes? Carrie?
I believe so.
So was anything said when you came down to the collision site where your mother and Ann were?
My mother said to the guy, "What the F word? You just ran into me."
And then anything else that you recall?
Not that I recall.
Were people talking?
I believe so.
Was the man talking?
I do not remember.
When I say the man, I mean the man that was involved on the ground or the snow next to your mother. I think it should be on the snow next to your mother, correct?
What do you...
When I say the man next to your mother, the person that was involved in the ski collision.
Yes.
So that's
I do not remember if he was talking or not.
the instructor, Eric Christensen, was talking.
I do. I don't have a closer memory on that. No.
Did anyone besides your mother say that they had seen the collision?
I do not remember. I do not remember.
Do you remember talking about the ski collision at the bottom of the hill?
Vaguely.
What do you recall?
My mother saying that she got hit or ran into.
You said you went to lunch afterwards, correct?
Yes.
Did you discuss the ski collision at lunch?
I believe so.
What do you recall?
Not much.
Who was at lunch with you after the ski collision?
Oh, the only people that I remember are my sister, my instructor, and my mother.
Since the day of the collision, have you talked about the ski collision with anyone? Anyone else you've talked to about the ski collision?
I don't remember.
Do you think you might have talked about it with some other people?
I don't remember.
I'm now on page 25.
This is unbearable. I don't mind this.
When you skied down to the collision
Soothing.
site before you left, did you notice any ski patrol or medical people come by?
I do not recall.
Do you recall any other people in green uniforms at the collision site besides your ski instructor?
I do not remember.
Before the ski collision, do you recall saying something to the effect of, "Hey, watch me ski"?
No.
Have you ever said something like that?
No.
After the collision, this is bottom of page 26. After the collision, when you walked
Not at all.
Why are you so sure? It seems like your memory's a little faded in some areas, which is okay and understandable, but I want to know why you're so sure about this.
Because I remember him addressing the situation very calmly.
How so? What stands out to you?
He tried to find out what was going on and try and see how he could help everyone. He tried to help everybody get out of the situation safely, and yes.
Do you remember anything specifically he said?
Not specifically.
I think plaintiff's counsel, Lawrence, asked you some questions about, they were sort of vague about what have you seen? Said, "Hey, watch me ski." Maybe a better way to put this question. Have you ever told your mom, "Hey, Mom, watch this," before you decide to do something on your skis if you'd like her to watch you ski?
I do not recall saying things along the lines of that.
Did Eric help your mother stand up?
I do not remember.
Do you remember Eric helping up the man that was involved in the collision?
I do not remember.
Do you remember skiing down with Eric after you left the ski site?
I don't know if it was exactly Eric, but I did ski down alone. I did not ski down alone.
Okay, how close were you to Eric as you skied down towards your mother when you realized there was some commotion or incident?
Close. I skied closely to him.
And then you stopped near your mother?
Yes.
And then how long after you stopped did you ski down? Was it like a minute or two?
I do not exactly remember. My best guess would be somewhere along the lines of 2 or 3 minutes.
So you were standing there about 2 or 3 minutes, you think?
I think so.
That completes the questioning, Your Honor.
Thank you.
Oh, soothing.
Call your next witness.
He's a child.
You want to play Apple and you ask the question?
You're going to read another deposition of Apple.
Is that okay with you guys if they just do it?
Just let us know the pages, because remember, I don't have a fully marked copy.
I can't do it, man, but this was a 50. She's nice. I don't mind her doing it. He's got a soothing voice. Childlike, I don't know.
Can you just spell your name for the record, please? Oh, sorry. Page 11, line 13.
Protected identity.
And your last name?
Protected identity.
Okay, you understand that this is a lawsuit involving a ski collision at Deer Valley on February 26, 2016. Are you aware?
Yes.
Microphone more toward the center of the two of you. Thank you.
Sure.
Okay, page 12, line 3. Okay, and do you recall this event back in February 26, 2016?
Yes.
Okay, how old were you back in 2016? Were you
11. No, 12.
about 11 or 12?
Yeah. Yes.
Okay, what was your skiing ability at the time?
Intermediate. Beginner.
Okay.
Somewhere in between.
About how many times have you skied approximately for this date in February of 2016?
4 times.
Page 15, line 10. Okay, and do you remember your ski instructors on that trip?
Yes, we had Carrie, Preston, and then my brother's instructor, who I can't remember the name of, and one more female instructor that I also cannot remember the name of.
Page 16, line 7. Okay, that morning, do you remember skiing with which instructor?
Carrie.
Okay, and your brother was skiing with another male instructor, I think you said, correct?
Yes.
I'll just represent to you that his name is probably Eric Christensen. Does that refresh your memory?
Yes.
17, first line. Okay, so do you recall that the morning of February 26, 2016, when you were skiing with Eric and Moses and
Yes.
Carrie, where had you been skiing that morning before the incident with my client?
We were on the mountain at the hotel. Type mainly on the greens and blues.
Do you know about how you had skied before the incident?
5 or 6, I'd say.
And were you skiing with Carrie that whole time?
Yes.
Was your mother skiing with you at the same time?
Yes.
Did your mother ever ski different runs when you were skiing with Carrie?
I don't remember.
Okay, your brother Moses, about what level is he as a skier?
Beginner.
Okay, now I'd like to go to the bottom before the ski collision that's subject of this case, okay?
Okay.
So you were at the top of the ski hill, and I believe the run is Bandana. Do you recall the name of the run?
Yes, it was Bandana.
And why do you know it was named Bandana?
It was our favorite run.
Page 19. And you remembered the ski run because it's your favorite run, correct?
It was, yes.
And it was also the run you go down to the hotel you were staying at.
Yes.
Okay, next I'm going to ask you what you recall happening on that run, but before, do you recall this ski collision?
I did not see it, but I recall the events following it.
Okay, well, what was going on during the time just before the ski collision?
We were on our way to lunch at the lodge.
And who were you with?
I was with my instructor, my brother, my stepfather, my mother, my step-siblings, and their instructors. But we were all a bit scattered on the run, so some of us were in front, others were trailing behind a bit more.
And who was with your group?
I was ahead of my instructor, my stepsister, and her instructor.
Was Brad Falchuk with you?
No.
Sorry, that's page 20. So just to clarify, at the time of the collision, there was you, Carrie Oakes, your ski instructor. There was IF, and then there was IF's instructor, who we don't know whose name yet. And then there was also your brother's instructor, Eric Christensen. And then there was your brother, Moses, correct?
Yes, but I was not with Moses and Eric. They were a little up the run. I was closer to the lodge at the time.
21. About how far away were you from your brother Moses, as you recall, just before the collision?
I would say I don't really know how to say it. I was further down the run.
Say?
They were in the middle of the run. I was towards the end with my stepsister. I was not with Moses or my mother.
And did you know when the collision occurred?
Not the exact time, no.
Did you hear something before the collision?
I don't remember.
Did you hear a scream?
I did hear some commotion, but I was further down, so I decided to continue to go down to the lodge.
Okay, so when you heard the commotion, is that what you think is the collision?
Yes.
And when you heard that commotion, did you look anywhere?
I don't remember.
Did you see your mother after you heard the commotion?
Again, I don't remember.
So I'd like to know just the couple seconds before the collision, and then the couple of seconds after the collision. So only about 5 seconds of time. So you heard something, a commotion, right?
Yes.
And then did you see anything?
I don't recall if I had seen anything or not. I think that I did, but I don't remember.
Okay. And when you heard that commotion, you're with Carrie Oakes, your ski instructor, right?
Yes.
And where was she in relation to you? Was she above you or below you?
I believe she would have been in front of me. That is usually how we skied. She would lead me.
We're on 23 now. Okay, so the 5 seconds around the commotion that you believe was the collision, you were with Carrie Oakes and IF, and then the 3 seconds afterwards, what did you do at that point?
Continued to ski down to lunch.
And did you know at that time that there was a ski collision?
No.
When did you first learn that there was a ski collision?
When we had gotten there, about 5 minutes after.
And how did you learn about the ski collision?
My mom told me. She told us what happened.
What did she say?
She said she came in and I noticed that she looked a bit shocked, and I asked what had happened, and she said, "This a-hole ran into me. He ran right into my back." And I remember she did this motion saying that he ran into her back, and they both went down. But I remembered that's what she said.
24. So let's go back to the moment of the collision or the commotion. You heard the commotion. You didn't see the collision, but you continued to ski down.
Yes.
Did Carrie Oakes ski with you?
I believe so, yes.
And she skied with you down to the bottom.
Down to where we were eating, yes.
Okay, and when I say the bottom, I mean the bottom of Bandana Run, which is where the lodges and the
Yes.
eating places are. Is that clear?
Yes.
And so right after the commotion, Carrie Oakes, IF, and you skied down to the bottom of the Bandana Run, correct?
Yes.
And who is at the bottom of the run when you got there?
I don't remember. I just know that we were meeting everybody to eat.
Okay. I'm sorry to keep going back to the commotion. Did you see anyone else on the ski run at the time of the commotion?
Well, there were other people skiing, but again, I didn't really pay attention to what had happened. I just heard some sort of screaming going on above me, but I continued to ski down, and I don't remember if I turned around or not.
Okay. Did you recognize the screaming? Whose voice was it?
It sounded like a woman, but we were so far down, I couldn't really put anything to it. It wasn't very clear.
Okay. How soon after you got to the bottom did your mother arrive?
I would say 5 to 10 minutes.
So you were waiting for her at the bottom?
Yes.
And what about Brad Falchuk? Was he with your mother when he arrived at the bottom?
I believe so.
Did he arrive sooner than she did?
I don't remember.
Well, I'd like to go back to the commotion and just let you continue and tell us, to the best of your memory, what happened. So you heard the commotion, and then what happened?
And then we continued to ski down, and we got to where we were eating lunch. We started to take off our gear and then sat down. And then shortly after, my mother, Brad Falchuk, my brother, I can't remember if my stepbrother was there or not, but everybody else followed in after I had arrived.
And who is everybody else?
To the best of my ability, I'm pretty sure it would have been my mother, my little brother Moses, Brad Falchuk. I would say one or two more instructors and my stepbrother BF.
Okay, do you recall which ski instructors were there?
Again, I remember Carrie, my instructor, Preston, who skied with BF and IF, Eric, and I believe that there was one more female instructor, but I can't fully recall.
Okay, do you recall anyone else besides the people you've mentioned at the site of the commotion?
No.
We're on 27. So when you're at the having lunch, was the ski collision discussed at lunch?
Yes.
And what do you recall about that discussion?
My mom was explaining what had happened, saying that a man ran into her back and they both went down. And she was in a state of shock. And she decided after that she was not going to ski for the rest of the day, which she never does. She always stays on. But she decided to get off because she was in shock and she was in a bit of pain.
Did Carrie Oak say anything?
I believe there was a conversation between them. I don't recall what it was about, but it was probably about my mom getting off the mountain.
Okay, do you recall anything else?
I recall getting back onto the mountain for a couple more runs, and then I got off the mountain, and I think that my mom was getting a massage.
Okay, when you got back on the mountain after lunch, who were you skiing with?
I was skiing with Carrie.
Anyone else?
I don't remember. Maybe my stepsister?
Do you recall skiing with
I
Moses?
I don't remember.
Okay, were you concerned about your mother at the time?
Yes.
What was your concern?
Well, I never see her really like shaken up like that. And she was very clearly, visibly upset, and she had some sort of pain. I can't remember what, but she was in a little bit of pain. And I remember that's why she went to the spa to get a massage.
Did you discuss the ski collision with anyone after you left lunch?
I think that my step siblings and my brother and we talked about it because my brother was closer to the collision. And he had also said that he skied into her back. And they both went down together.
This is Moses. Can you tell us more specifically what Moses said?
Well, Moses was kind of telling us what had happened. I don't know if he for sure saw it, but I know that he was with people that saw it. And so they had told him what had happened and that it was what he said.
He said that my mom got hit in the back. Oh, what did he say again?
He said that my mom got hit in the back and their leg, they both went down together after somebody had skied into her back.
We are on 30. Okay, when you finished skiing, did you discuss the ski collision?
Yes.
With whom?
I believe we talked about it at dinner and after. I was checking in with my mom to make sure that she was okay.
And what did you discuss?
I asked her how she was doing, how she was feeling. She said she was in pain. Again, I don't remember where exactly, but she did say that she was in pain. She had gotten a massage, I believe. So this was around dinner time, and we had just kind of gone over what had happened.
Did she say anything about my client, Terry Sanderson?
She had earlier in the day, not immediately after, but after 5 minutes after we all met at lunch, she said that he had skied into her back, and she called him an a-hole who had skied into her back.
Anything else you can recall?
I remember she was very frantic about it, so she probably said something along the lines of that, but that would be all that I remember to the best of my ability.
31. Okay, when you discussed it with your mother and you said she was frantic, what do you mean by that?
She was in a state of shock. She was very upset and she was in pain.
Since that collision, have you seen your mother in that state of shock like that since that?
No, not like that.
So you discussed the ski collision that night at dinner, and do you recall you were staying at a hotel suite or something?
Yes, we were in a hotel.
The next day, do you recall what you did?
I believe we skied in the morning. I can't remember if we had left that day or not. The next day, I don't really remember much.
33. And do you recall how many ski instructors were with you at the time of the collision when you started skiing again?
I believe either 3 or 4.
And one was Carrie?
Yes.
And one was Eric Christensen?
Yes.
Was another one Preston?
Yes.
Was there anyone else that you recall?
I believe that there was one more person, but I can't be too sure about that.
Okay. Did anyone tell you they had seen the collision?
I don't think so, no.
Other than your mother?
No.
35. Okay, earlier I think that you said Moses and said other people had definitely seen the collision. Do you recall saying something like that?
I don't think that I said that.
What do you recall Moses saying?
I remember him sort of telling what happened. I don't know if he saw it or not, like saw the actual collision, but I know that he saw my mom on the floor.
I believe I said that he saw my. Let's see. Oh, that's you.
I believe I said that he saw my mom on the floor, but I don't think that he saw the actual collision.
Okay, so after the commotion or collision, you skied down to the bottom of Bandana Run, correct?
Yes, but again, I personally didn't see the collision.
Okay, but you heard this commotion.
Yes.
Did someone say to you ski down to the bottom of the hill after the commotion?
No, we did not think anything of it. We continued to ski down. I don't even know if we stopped.
The we includes Carrie Oaks?
Yes.
Did anyone ask you to wait by the side of the hill after the commotion?
No, I don't remember that I don't know.
That you recall? Do you recall seeing anyone going to help your mother after the commotion?
I, again, did not see the aftermath. I had continued to ski down, but I believe that people did help her.
And what makes you believe that?
Because I assume that she would have needed help up, and she was close to her boyfriend, Brad, who is now her husband at the time, and both my brother's ski instructors and I believe BF's ski instructor. So I'm assuming that they would have helped her.
But Carrie Oaks stayed with you down to the bottom of stayed with you down the bottom of the hill?
Yes.
What about Eric Christensen? Do you recall what he was doing after the...
I believe that he was with my brother, who was near my mom. So he was near the collision.
Okay, and do you recall which side of the hill you were on? Let's talk about skiers left and right. That means that if you were skiing downhill, the left would be the skier facing downhill to their left, and the same on the right. Do you know which side of the hill you were on ski?
I don't remember.
Okay, do you think you might have been in the middle of the hill, or the side, or near the edge of the run, Bandana?
I don't remember.
39. Can you be sure exactly that Carrie Oaks didn't stop and help your mom after the collision, or do you remember that at all?
I don't remember. I think that we were further down because I know that we got to lunch first, so I don't remember.
Okay.
I don't think so.
Do you recall before the commotion on Bandana Run saying something to the effect of, "Hey, watch us ski down the hill"?
No.
Do you recall if Moses said something like that?
No.
Do you recall if any of your other people in your group, like IF or BF, say something like that?
I don't know.
Okay, I'm just going to show you something here real quick. Do you recognize the person on the left there?
That's Carrie.
That's Carrie Oaks?
Yes.
42. So Carrie Oaks was recently deposed, Apple, and she actually has specific memories of being on the scene of the collision. Would you defer to her testimony of specific memories rather than sort of your vague memory that she has with you?
Yes, I could have easily been with another instructor. I believe IF had an instructor.
Lawrence, I think we have a picture of Eric Kenhe, which has a picture of him on the cover of it. He looks a little older than he did.
Oh, isn't he the one? Oh my God, I remember him so well. He was the best. Oh my God, he was the best. He would give us candies and he would tell us, yes, that's Eric.
Would you say he was under 50 years old?
I don't remember. I never really skied with him, so I never really saw his face. That's the end of it, Judge.
Thank you.
Yeah.
So, Your Honor, both Moses and Apple were ready, willing, and able to testify in person on Monday morning. But
Objection. Why don't we address that after I excuse the jury? Okay. I'm going to excuse you now until tomorrow morning at 9 o'clock. I will recess. Please do not discuss this case with anyone, including other jurors. Please do not attempt to learn anything about the case outside of the courtroom, including from other jurors. Please avoid radio, TV, internet, and newspaper reports on this case. Please keep an open mind throughout the presentation of the evidence. And finally, please do not form or express an opinion on the case until such time as it is finally submitted to you for deliberations. Have a good evening.
So the defense have to get that in front of the jury just to say, they were ready on Monday, just so you guys know. He's a sly dog. Sly dog. But fair play to him. Oh, there she is. Hello, Gwyneth. Bye-bye, my love. See you tomorrow.
Okay, Mr. Owens, what was it that you wanted to put on the record?
I would always prefer live testimony to reading transcripts, but the kids were not available. And mostly I just want to put that on the record. I was expecting to take over the case on Monday morning, given multiple assurances that I could do so, and I was not able to do so.
The multiple assurances were, if we're done, and we intend to be done. It sounds like some kind of a statement that we didn't do something we're supposed to do. And they took almost as much time cross-examining more on some of these witnesses, and that's why we didn't finish. In my humble opinion.
You could have called them live. You still can call them live. But I understand that you wanted to put that on the record, so
they
thank
became
you.
Unavailable.
All right. So we're going to take a short recess, maybe 5 minutes, and come back and work on jury instructions. Is that right? Okay. Just take a quick bathroom break and we'll be right back, and hopefully we'll wrap it up by 1:30.
So maybe we get to hear some stuff, learn some stuff. I don't know. Friggin' Nora.
What time would you like everybody here?
8:45, be ready to go, because once all the jurors are assembled, we can start.
Perfect. There you go.
So they're taking a quick piss break. So should be done in about 20 minutes. That's right. 12:10. I was up at like, what, 7:30 this morning? I'm too old for this shit. Oh, they've got a shop there now. It's a bit different. Oh, I thought she was really good. There she is, Defense Wednesday. I thought she was very, very good. Very, very good. Anyway, whoop, here we are. I'll rest my eyes. Take my glasses off. I can't read, but you know. Let's see what's happening over there. So Rumble thinks that she looks like Alanis Morissette. Yeah, possibly. Here, Joanna, I wasn't sure if you thought that was actually Gwyneth's children or not. I was like, I hope she knows that it's not their children, Gwyneth's children. But yes. If you haven't done so, please like the video and subscribe. Or it's 5 people here. How many is it? Or in Rumble and Rumble 10 in Rumble. Rumble, I've had good numbers in Rumble, much better than YouTube. For this, like over 20 most of the day, which is, you know, my first ever video there. Or second, sorry. Oh, that was paused. Just make it live again. I think the next bit's going to be boring, so I wouldn't stick around if I were you, but I'm going to stick around just in case there is something. It's jury instructions. So I can imagine it's going to kick off at one point or another with these 2 lawyers. So yeah, and also I've learned today that this case is time-based. They both get an equal amount of time to question, as in, I'm not sure what it is, we say 40 hours each. And once they reach that, that's it, done. So I thought that was interesting when they do that kind of stuff. But maybe it's not interesting for anyone else. But this is my first civil trial, so Rosie's probably in bed, gone to bed because it's literally 12:15, 12:15 here in the UK. But then, Erin, you're like 4:15 for you. You're probably on the beach now, loving the sun. Big Mike, don't know where Big Mike is. Big Mike, we might have lost a good one there. I don't know. Oh, Rosie, you still here? I thought you might go to bed because obviously it's like 12:15, like. Erin rotting in the office. But you haven't got long left, surely. You finish at 5, did you, Erin? And also, how do you work in an office in that sun? Uh, Giovanna, I fall asleep in the afternoon. That's why I went quiet. Rosie, I'm here. And it is late. It is late. Yeah, 5-ish. Jeez, those are the days. Yeah, I'm gonna watch this at 12:30, then got some stuff to do today. I want to edit a video, but worst thing is I'll be up again at 7 o'clock. You know, when your routine and it's just like get up at 7, 7:30 every morning. So I don't sleep much these days. Let's get the violins out for me, like, you know, the smallest violin in the world. Oh, Rosie, work from home. Yeah, I used to, till I took voluntary redundancy. I used to as well. Loved it. Loved it. But I moved home to West Wales, but I was working up in North Wales at the time. And it was a 3-hour journey. And we agreed that I would go up there once or twice a week. But I was like, I can't be asked. So in the end, I took voluntary redundancy, and then I was like, now I'm at work. What am I going to do? So I started this. So now I earn nothing. Just fucking put a lot of money into it. Yeah, I do need that. Do you know what? A couple of times I've nodded off of this stream with a boring testimony. I just go, oh, I get up again. Jesus. But this stream keeps me going. But sometimes, at this time of night, I do get a little bit quiet because I get tired, you know? Old age and everything, you know? We're all like that, Giovanna. I'm like that. Then I catch myself yawning. But I wouldn't change it. I love this. I love doing this. I don't think I'd go back into an office now. I was lucky enough that my job was inside and outside, but still, I couldn't go back to an office, I don't think now. I couldn't work with certain people anymore. I've got no tolerance for twats, and I work with a lot of twats. I get tired. Yeah, I do. Yeah, mid-afternoon, I normally get tired. I'm going to be 62 May. Oh, we'll have to remind us then, Joanna. See you happy birthday. Charles, oh yeah. Why do you think I go after people? Not after people, but I literally am like, I control myself a lot these days. I just love to put some sarcastic tweets out there now. But also, YouTube's taking over my life at the minute and videos and stuff. I hate it. I do as well. I couldn't do it. The only thing that was nice about working for me anyway was it was normally like it was long hours because I'd always be on call in case it was an accident or something. But most of the time, like get in for about 8, get out about 6, 7 o'clock. But I always have the weekends to myself. Now I don't even have the weekends. And also you have a paycheck every month, sorry. This one, there's no paycheck. So you grind harder, but it's your own work, if that makes sense. So you don't mind it. But we'll see. Yeah. I always get confused. 2 and 2. I never would ask anybody what they do for work or anything or where they're from, exactly because it's personal. And the same way, someone asked me if I put my because tomorrow Wednesday I have my niece. I pick her up at 11:30, and then I have her for a few hours, then hand her off to my mother. And so somebody asked to put her on the stream. I was like, no, I couldn't because so many weirdos out there. I'm not to talk about you guys here, but you just don't know who people are. Nice, Giovanna. Nice. Nice little bit of a pension there. Yeah, that's the other thing about me. I don't have a paying for a pension anymore. Jesus. Oops. You see, in about once we grow up to like having 1 million subscribers, we'll have a meetup or something. You know, we'll Rosie and me'll fly out to America to see you guys. Spend a few weeks there, go through some trials. If only, innit? If only. Oh. On Rumble, I got everyone. It's only 7:15 there. That's nice. 8, 9, 10, 11, 12. Yeah, also you go Eastern time then. Jeez. Yeah, Giovanna, you have to come over and cross the border just for a few days, like, you know? Who else would be here now for like five people in the stream? I would. I'd still be here if there's one person left on stream. I'd go down with the boat, I do. Do you know what I mean? The captain goes down on the boat. I appreciate all of you here. So, as I've said many times, but I don't know anymore who's listening, who's not. What we're doing the Sarah Boone trial, starting on the 10th, and then next week at some point, I will do like a live reaction. But you don't have to be there to watch it. You can watch it afterwards, wherever. So that'll be something people can do. So there's a week there. You know, don't get into other trials for fuck's sakes, because I need you for Sarah Boone. So yeah, I'm gonna do live reaction for her interviews because I don't know anything about this case. So Rosie, Giovanna, and all that. Do you guys know anything about this Sarah Boone case? I know Erin doesn't, so she's looking forward to it. So not sure if you guys know anything. EV1 on Rumble. Do you know anything about it as well? Not 10, 11 a.m. Probably won't go to sleep. Jesus, are you mad? What? EV1, are you mad? Jesus. Don't get to sleep till about 10, 11 o'clock in the morning. Oh, I'm finished here. I've got a quick edit to do. I'll be in bed by about 2, 3 o'clock now, and then I'll be up at 7. So if you know anything about EV1, if you know anything about it, yeah, Rosie, it's the suitcase one. Giovanna, yeah. So that's my next one on the 10th. Put that in your diary. That's the next big one I'm doing. So yeah. So it's a little bit of like a week off now, and then recharge the batteries. I hope you don't find other streams to watch in my absence, but you know, I'll try and drag you back somehow. Remember, Giovanna, I know Rosie does it, but remember to hit the notification button to see wherever I go live and stuff, just in case. So you'll know. But put in your calendar, the 10th. I'm not sure what time we're going live because I don't know, probably 9 o'clock Eastern, I imagine, but I don't know. Yeah, I'm not doing the Letitia's Storm's trial because it's a webinar thing. But Crime Spies, she's doing it though. So, you know, if you want to look at that, and even if you stick to her with her to do it, that's fine. And after that, maybe join us after that. But I'm not doing it. I need a week. Well, it's not a week break, but I still do stuff, but it's Easter holidays here in the UK next week for 2 weeks, so I want to do something with my nieces for a couple of days, and I got dentist on another day, so it's like I'll do a live stream on another day. So it's like my week's gone. Then 10th, then let's go. Let's go. So yeah, I expect to see you on the 10th, Giovanna. Yeah, the best thing for anybody to do is hit the notification button because then it's just shows you whenever we go live. Big Mike did it, but RIP Big Mike maybe. So hopefully, with it being like a murder trial, I'm hoping that we get good numbers increase and like more interest. Ah, Giovanna, thank you very much. I know you'll be here. So yeah, I hope we get more numbers. I think there'll be more people interested in it. Because you do need a few cases that no one's interested in this Paltrow one. It's shit. I thought might be a little bit interesting, but like she's not guilty, is she? So it's a bit shit. Yeah, so hopefully we get a few people there for Sarah Boone, and we can get some traction then. Hopefully there's another good trial after that, and then that's how you do it, really. If in a year's time still only got 5 people watching, then maybe that's a sign. Do you know what I mean? So we have to see. Giovanna, you have to drag people here. Make sure you got people here to watch it. Oh, I've got to take this before bed as well for my sinuses. Right, they're back. Oh no, they're not. Judge, oh yes, they are. Right, let's see what they're going to say. Hopefully, Giovanna. Hopefully, yes. Right, glasses on. Cool, 7 people in now. Rumble, we got 7 as well. Oh, EV1, sorry about you broke your back. Sorry about that. Oh no. Oh, I'm so sorry. Right. Come on, Judge. Oh, it's not going to be silence now, is it? No, it's not. It can't be.
Defendant, oh wait. No. The nature of the case we already resolved on page 4.
Just give us a minute, we're trying to find our.
Okay, sure.
Extra copies, please. We've had so many different versions. Is there?
I'm working off the one that was filed.
Okay.
Your filing, which is your objection.
Do you have the filing date, Your Honor?
It is, I can give you the docket number.
Yeah, that would be good. The docket number is even better.
plaintiff's objections is docket number 973. Are you with me on the defense side?
Yeah, are we looking at our document or their document?
Looking at their document because it contains their written objection.
Got it.
So starting on, I'm on page 6, defendant's instruction number 9. Mr. Bueller, are you with me?
Not yet, I'm waiting
Okay.
for it to load. $973, Your Honor. Yep.
Are you with it? Or are you there?
I'm there. Let's see, what page?
It's 7. Page number 6, fault defined. So this is the fault definition. Is there any reason why we don't just use the fault jury instruction from the model Utah jury instructions? I see that, I guess both of you started with that, but why not stick with it? Mr. Egan?
Believe it or not, we're still trying to pull this document out.
Okay. All right.
Sorry,
I'm looking at CV 201 on the model Utah jury instruction, 2nd edition.
Your Honor, we have it, and your question was, why not use the model instruction?
Why not stick with CV 201?
I think, if I'm recalling this correctly, and it's been a bit, we were thinking that the model instruction doesn't incorporate the counterclaim, so we wanted to just make sure that it was clear that there needed to be a decision about fault for both parties.
Okay.
That's what I recall off the top of my head, Your Honor. So if I'm remembering correctly, it was kind of that second sentence where we say you must also decide whether Gwyneth Paltrow is harmed, and if so, whether anyone is at fault for that harm.
Okay. And there's also an objection to adding the word skiing in the second paragraph, just negligence rather than negligent skiing, because I think their claim is a little broader than just negligent skiing.
I see, because of the post-collision claim.
Right. I mean, I suppose loosely it's skiing because it's part of the skier code of conduct.
Right.
what
Yeah.
to do after an accident, but
Right. Yeah. To me, I guess I don't know that makes a huge difference to the jury. If they see skiing, I think they'll understand that it's the whole part of negligence.
can you still argue your case if it just reads what the jury instruction does? And wrongful act or failure to act alleged in this case is negligence.
Your Honor,
Sure.
we think just the generic negligence is used in all sorts of things, from skiing to autos.
Yeah, you've got that in your brief, in your objection.
Sure. I mean, I don't.
So
Can you still argue what you need to argue?
Yes, I could. Well, this goes to a little bit of trial strategy. Is plaintiff resting? This will help me argue this very issue.
They haven't rested yet because you haven't finished your cross of their client.
So, sorry if I don't know this, but if I say I'm done with my cross, I'm going to call Terry in my case. I can still use leading questions, may I?
Sure, he's an adverse party.
Yes.
So yes.
So if I agree to give up my cross of Terry, they are agreeing to rest first thing in the morning.
This is not what we're
This is
arguing
not-
about
we're not
right
arguing.
here. We're talking about jury instruction.
I actually, this affects my, first of all, I'm entitled to know if they're resting. The judge ruled, Your Honor ruled, that we would know each day's lineup the following day. I think they benefit from just having this open case because it's just this one other witness. And then now it's 2, now it's 3. And I want them to rest.
Well, if you'll decide whether you're done questioning Mr. Sanderson.
I hereby decide.
Pardon?
I hereby decide that I am done.
So do you have any more evidence to put on?
Well, we weren't prepared to talk about that. 2 of our team are obviously not here with us right now. If we can get on the phone with them, we could discuss that and come up with whether we are definitely going to put anything else on or not. But I mean, we're here.
I mean, as I understood it, that was the only.
That's what I understand too, but.
Okay.
We've got 2.
Can one of you step out and verify that while we continue?
Yeah.
Okay, thank you.
So
would you like to come back to this one then after you get that answer?
Yes, I intend to file a motion for directed verdict on the issue of post-collision negligence.
On what? I didn't hear that, Steve.
On post-collision negligence.
Are you going to file something on it?
Well,
or are you just going to make it?
Depends how much work we have tonight.
Okay, all right. Well, as to so then, well, it would be my inclination just to use the word negligence anyway, and if it ends up that it's only the before and to the collision that's at issue, then you can certainly argue that to the jury.
Okay, if our motion's granted, I would want that tweaked because I don't want them to be confused that there's a post-collision issue. It's only the scheme.
Sure, if there's a directed verdict on the post-collision issue, I think there should be some clarification to the jury.
Yeah, we agree if our directed verdict went one.
Sure.
2.
Okay, so in the meantime, then, that's the instruction as it will stand. And if the landscape changes, you can certainly ask for an additional instruction or a modification.
Okay.
Turning then to defendant's instruction 12 on allocation of fault. Is this also, Mr. Egan, in order to, well, you've already come to an agreement, it says here, so that one's okayed, right?
Yeah, it looks like that's
Number
correct.
12. Number 13, inherent risk of skiing. I think you've already, well, you would like an inherent risk of skiing instruction, and the plaintiffs don't want an inherent risk of skiing instruction. Is that right, Mr. Bueller?
Correct.
For the reasons stated. Could you just tell me again why it is that you believe you should have one? And have you evaluated wasn't there a case that had 3 factors in it somewhere on whether was it Dutton, that whether a statute creates, whether a statute should be used? In other words, it talks about the protected class that's designed to protect
Yeah, I do recall looking at that, Your Honor. I also am struggling to remember the particular name.
That might have been, I think it was in the
Donovan.
motions in limine, if I'm not mistaken.
That may be correct. And Donovan, I believe, is it didn't go into a significant analysis of that because it decided not to. The court decided it didn't need to rule on that point, if I'm remembering correctly, and so it just cited, I think, these other cases that you mentioned. And I can look and see if I can find.
And I have Donovan. Can I read one sentence from it, Your Honor?
Sure.
To be clear, we do not establish a categorical rule that an inadvertent fall by itself can never establish negligence. And we overturn RICI, R-I-C-C-I, to the extent that it established such a rule. I don't know if that's helpful, but the way my mind works is that means falls can occur despite appropriate care, and that's obvious.
Okay, I know where that's coming from. I actually marked that here, so. Anything else you want to add to your counter to the objection?
Yes, it is the law. I mean, it doesn't say, when it says you are assuming the risk of collision with other skiers, that is a legislative finding. That's not unique to ski resorts. I think it's just a statement of law. And skiing has inherent risks.
Okay. Anything else on that one? I'm gonna take that under advisement.
I'm gonna look for one other thing.
Okay.
Should we give them an update?
Yeah, an update, Your Honor, and I understand that as I stepped out to make the phone call, the defense said they would not be calling Terry Sanderson again.
Correct.
Is that correct? We don't have any objection to resting right now.
Okay. So the plaintiff at this point is resting, and we can certainly do it officially in front of the jury so that they can see that you're resting. But does that resolve your issues, Mr. Owens, going forward?
Yeah, it does.
Okay.
Your Honor, in case it's helpful, and you may have already beat me to this, but it looks like Colosimo was the case
that they were citing.
Yes. So, yeah, sounds like you beat me to it.
Yeah. And I read what they were citing as well, and I'll continue to consider that.
Okay, thank you.
Sure.
I do have one thought here.
Even though my name's on this Donovan case, it was Judge Pettit that made that ruling.
Oh, yeah.
I think I had
didn't even notice that your name was on
I think
it.
I had the case in case it came back. Yeah.
All right, I found the inherent risks of skiing statute 78B 402(1). It does say inherent risks of skiing, meaning the dangers or conditions that are an integral part of the sport of recreational, competitive, or professional skiing include, and then it lists a number of things, and one of them under subsection F, collisions with other skiers. That is a legislative
Can you give us a study?
finding. 78B 402 sub F. Now, I didn't read it word for word, Your Honor, but changing weather conditions are not part of our case. Variations in terrain are not part of our case. So I went straight to F.
And then how would you respond to that same statute that says that definition of inherent risk of skiing is as used in this part?
Yes.
How do you look at that? it seems as though they're defining the term for this statute.
They're just going through the finer details of what closing arguments is going to be about, in case anyone's wondering what's going on. And also, the plaintiff has now rested as well. But
The main thrust of the section is to protect ski resorts, but it doesn't say anywhere like this does not provide any defenses for skiers. And so the wording works with skiers and skiers.
Well, if I don't approve this requested instruction, it doesn't mean that you can't argue that. It just means that there will not be a legal instruction, and I haven't decided yet. But you certainly can argue that there are inherent risks of skiing, and you can talk about what those are, and you can, as they're tethered to the facts of this case. That's fair game. It's fair game.
I appreciate it. They just won't know it's the law. It is true, and it should come. The law should come from the court.
Correct. And if and that's my decision. Does the statutory definition of inherent risk of skiing contained in 78B4402, does that apply to a skier on skier collision liability? Mr. Bueller?
Oh, just if the court changes its mind or
I haven't
considers
made a mind.
yeah, we would like another opportunity to discuss it, but it doesn't have to be done tonight.
Well, I need to know now what your arguments are so I can fully evaluate this.
We would say, Your Honor, it does not apply to skier on skier. That the main thrust of this, as defense concedes, is to indemnify ski resorts for accidents that take place upon their mountains, and not for skier on skier liability. That's always going to be available.
Okay. Thank you. So I'll take that one under advisement, number 13. Next, number 14. This is the one I was talking about earlier. Why not use the
safety rule?
Yeah, the violation of safety law, CV 212. Do you have that handy? The standard Utah jury instruction whenever there's an allegation of an ordinance or a law, a legislative enactment that creates a duty or is a safety law.
We're fine with that, Your Honor.
Okay.
I'm sorry, Your Honor. I had it and then I lost it. Can you give me the number one more time?
CV 212.
212.
Yeah.
It's under the negligence. So
Yeah, we have it now.
Quite interested to listen to this because you get to know what they're
And
going
then
to
you
argue
take
about.
the actual quote from the ordinance and put it in there, the language from the ordinance itself. Do I have a copy of the ordinance?
you should have. I think we might have it as an exhibit. We can provide that.
Could you email that to my clerk?
Well, they've rested, so we shouldn't be doing new things that haven't come into evidence.
There was a witness that referenced the ordinance.
Right. I'm not sure.
And this is law.
Judicial notice.
But the document is a safety law. I don't know that any witness so testified.
Yeah. Lee Blocker did, and I believe it came up with least one other witness that I recall. I don't recall which one specifically right now.
I don't believe
So it's,
Bogger did.
It's in Plaintiff's Exhibit 38.
What's plaintiff's exhibit?
It's the reckless skiing ordinance.
Where have you been here?
Okay, so plaintiff's exhibit
I haven't
38.
seen you in ages.
Was not admitted,
How are you?
correct?
Hope you're
Is that
well.
admitted?
Right, that's your question.
The one they objected to, but we would, we don't, we would want it admitted.
So no.
Notes.
It's worth watching replay. I hope you watch the replay on this bloody stream.
And it wouldn't be appropriate, I don't think, to give the whole ordinance hand it to the jury, or maybe it is, but this is the place where that law should.
Hold on, let me pause this for a second. Pause for a second. So basically, if you're watching on this stream, right, go back to the start. The first hour is basically a nothing burger in terms of we watched the ice cream trial because the results came back on that. So it's probably about 45 minutes, 50 minutes. So once the results come out, we can skip it or skip 50 minutes. Then I think there's a doctor that's very interesting. He was very, very good. Then there was another doctor, which I think people found boring, but he had a stroke when he was younger, and he's highly intelligent. So I didn't stand half the things he said, but I would suggest you look at you listen to him because he was very good, but it's a bit long. And then finally this afternoon, Apple and Moses, they've not been in, so they have to do read their depositions in. So lawyers did that. The first one was rubbish. The two female lawyers. Then the next ones were alright actually, but it's been quite interesting. But for me, nothing burger, nothing changes. I still think Gwyneth's innocent. So yeah, there's that. But Leah, I've not seen you for ages. Oh, it seems like that anyway. So thank you for coming. I've just lost someone else off now. I'll start this back up.
And there was a witness that referenced the.
I hope you don't expect me to type all that. We'll see about this because I don't know who's here, whether you've gone or not. It's all good. I wasn't taking the piss out of you. It was more like, thank you for your support. I've just missed you. I've not seen you around for ages. I was talking the other day about you, going, I'll see you. Always grateful for your support. And also, before I forget, are you into Sarah Boone? Do you know anything about Sarah Boone? Because that's the next one I'm covering. So next week I'm doing a live take on the interviews that she made because I've never seen them. And then on the 10th, then I'm starting the Sarah Boone trial. So taking a week off, basically. Not a week off, but do you know what I mean? So if you're interested in Sarah Boone, I think it's a good gang. Also, hopefully going to be up for that as well. So, and it's like a split. Half of people know about it, half people don't.
The to prove breach of a negligence duty, they have to also show that it caused harm.
Sorry, Joanna, I muted it.
Well,
I think
you
it's
should
you,
say
here,
by
Joanna.
Ramon's account, he notified them of the person who they say injured him, and Mr. Sanderson that evening texted, "I'm famous." He said that because he knew who he had collided with. So I believe that whole post-collision negligence claim, there's insufficient evidence both on breach of that duty and on causation of damages.
Let me address it when you make your motion.
Okay.
Defendant's instruction 24 on spoliation. What's the defendant's response to their objection?
Thanks, Your Honor. And as I understand your order, and this is important for the plaintiffs on closing, the court has precluded either party from commenting on it, on how this arose. So, for instance, I don't believe it would be fair for plaintiffs to say, hey, Mr. Owens, an opening said that link is really important, and here it is. I want the jury to be advised that it came through my office. The member of the public identified it, was able to open it, and the court declined that, which is fine, but I don't want to be beat over the head with it. Now to the spoliation issue. The GoPro is separate from the link. The GoPro came from a telephone call Mr. Sanderson made to his wife, his daughter, Shay, who testified. She got off the phone with him, believing there was a GoPro video, and she typed it to her dad. I can't believe this is all on GoPro. The plaintiffs have denied there was ever a GoPro. I think everyone agrees that if there were a GoPro video of the incident, that would be the very best evidence.
Yes.
I
So
believe
I'm going
the
to,
defense has made sufficient showing that there's a possibility that there was a GoPro video and it was deleted, and that we are entitled to the adverse inference, if the jury were to find that the GoPro was deleted.
Why not use the spoliation instruction that's in Moody's?
It's a suitcase case, yes. So I'll do
It says if I find, which means
a live take, which I'll record. Obviously, don't watch it live.
Works.
And then
what do you mean?
10th.
Isn't the wording of the Muji spoliation one?
We can move for it. Sarah Boone.
You guys used, yeah.
I have found.
I have determined.
Thank you. I don't have it in front of me, so it doesn't seem to work.
Right. So, Mr. Bueller, or I'm not sure who's arguing this, Mr. Sorensen, I think that there is sufficient evidence in front of the jury from which they could decide that there was a GoPro video. And so I think, and that it was in your, that your client had access to it. So I am inclined to consider a spoliation instruction, but not as it's currently written. I think it would have to be a permissive instruction. In other words, if you find that there was a GoPro, and if you find that it was destroyed, then you may decide that it contained information that was adverse to the plaintiff's case. In other words, it's not prescriptive. It's not requiring them to make that finding. They just can make that finding. Because there's different levels of spoliation instructions, and I think that's probably the least stringent.
And as we understand it, Your Honor, I think spoliation is a legal issue that you are supposed to determine. And so I don't know that it's a factual determination for a jury to find whether or not there was spoliation.
You don't want this in.
I think there is in this. I mean, I think in this case, a legal instruction could be crafted that would allow them to make factual findings and apply it.
Is that, as we understand it, the factual findings are just Shay's written email. Those are the facts that would support
so far
a finding,
right?
Okay, but there's no intent. There's not been any evidence to this point of any intentional destruction of that evidence, or
there's a Utah case that says that you don't that a party doesn't have to show that it was intentionally destroyed, just that it.
Well, the language.
The language in the Muji says that, but there's a Utah case. Let me see if I can find it.
That's huge for the defense to be able to say that, because I'm first there was a GoPro video. That's a big win, in my opinion, for defense. So yeah, I'm not sure if I said it. Yeah, it's a suitcase one, which I'm intrigued about. I don't know anything about it.
Defendants, I'm looking for a different. I mean, I can't approve the instruction as it's written. So it's denied as it's written.
Do you have the case that you're?
I'm looking right now. Yeah, hold on.
I mean, Muji lists 3 cases, I think, on the instruction.
Wow, we've
Because I
still
don't-
got
my
12
normal
people at
computer
Rumble
just doesn't
watching.
have all the software that mine does.
So if anybody new comes in, oh, brilliant, come in. It's boring as fuck, this is, but we're trying to spice it up a bit.
Oh, I don't have it
See you tomorrow.
here.
Sorry, nice to see you again. Thanks for popping in. Thanks for watching my videos.
It's highly prejudicial to, without,
Position.
shred. I mean, I guess the daughters, I can't believe there's a GoPro that she, that's,
I understand.
Lorraine, have you heard what the judges just decided about the
So
GoPro?
that one's denied as written.
So as written, he's denied it, but they're going to put
Burden
another
on
thing in.
us to now
If you want the
revise it.
instruction, I need one that's consistent with the law and the facts of this case, along the lines that I just outlined.
Okay.
That it be a permissive instruction.
So James, or Peter, can I delegate this to you? So a jury instruction that's consistent with the law and the facts of this case.
Right.
And the specific wording you don't like. So
This wording, no, because it doesn't require, well.
Right, but
The
what do you
jury
want?
the jury has to
If-
determine three things. One, that it existed. Two, that it was available to the plaintiffs and not the defendants, which I guess the evidence, that is available to the plaintiffs. And then thirdly, that,
Plaintiff destroyed it.
that the plaintiff destroyed it.
can we argue?
And then the last part of that is if they make those findings, and I'd like to see the authority, if you could take a look, Peter, for the authority that I'm referring to. If they make those findings, then they may, but they're not required to assume that it would have been negative for the plaintiff's case. I'm not using probably the best terminology, but you get the idea.
Can we then argue against that?
Sure, absolutely you can.
And bring up evidence.
Absolutely.
That the spoliation could have been the ski patrol or Deer Valley, because Deer Valley, I know our client thought that, he asked me before we even took this case, he asked, well, don't they have surveillance cameras there? And I said, no, a lot of resorts don't, and Deer Valley didn't at the time.
Well,
Now they
there's
do.
that evidence isn't before the jury. Your argument has to have some thread to the evidence.
Are we, okay.
But whatever this instruction ends up being, you can certainly argue the facts as to the different elements that are in this instruction.
Okay. We'll wait for that instruction then, Your Honor.
Okay. I will
They're
wait
not
for it as
happy.
well. So instruction 28, introduction of tort damages. The objection is that should be changed because they're not asking for economic damage. Is that right?
Yes, and I think we gave a counter instruction down below, Your Honor, on that, on page 16. That.
Are you okay with the counter instruction?
Okay, page 16, may I read it for 1
Sure.
second?
Yeah, sure.
So see more people joining. They're just going through closing arguments, what they can and can't say,
So
and what
I
the
would
instructions are
prefer,
going to be.
If something's simpler and more accurate, I would prefer just say, rather than you must decide how much will fairly compensate her, we just, I hope I'm following your brain track here. That Ms. Paltrow's has agreed that it's just $1. Is that the issue we're addressing, whether to do this big generic conversation about Gwyneth's damages?
Yeah, it's just following the Muji and with some changes.
I think we should change Muji just because it's simpler and to the facts, just to say $1 rather than you must find. I guess they could decide they only want to give her 25 cents, but I think it's confusing to the jury. It's sort of like, if we stipulated that they have $300,000 in medical bills, we should just say we have stipulated that there are $3,000 in $300,000 in medical bills. We wouldn't say, we think you should decide.
So I understand that you want to simplify it. Is it an incorrect statement of the law? I guess is my question.
Is it word for word Muji?
Mr. Scornson?
I don't have the reference below. Sorry, it's been a number of weeks since we crafted this.
All right, well, I understand both parties' position on that. Moving on to 29. Is there anything you want to respond to on their objections there? They object to the use of the $1 amount as previously stated. And they're asking for a compromise there.
I'm reading it.
See, Rosie? So I didn't know you. I thought you'd gone.
Okay,
See
I'm
you
at
tomorrow.
the
Sleep
top of
tight.
17.
Thanks for being here
and that's
today.
their-
Appreciate it.
their
No,
com-
that's yours, the bottom of 17.
Thanks for the
That's what
profile
they're
pic.
proposing.
Thank you for orienting me.
Excuse me, can I just borrow the Wi-Fi? We're trying to get another.
Giovanna's still here. It's interesting now that the defense can argue that the GoPro link
So,
had been
same
deleted.
issue. $1. Why are we making them think about Ms. Paltrow's number of economic damages? They brought in the fact that there's potential lawyer fees involved, and we don't want them speculating about that. So
I think we're
Ms.
moving to
Paltrow is
$1.
seeking economic
I
damages.
mean, on the verdict form, do you want to just put $1 in her blank so that if they get to a yes, I mean, how do you want to deal with the $1 claim, or do you want to leave it open so they might award more?
That's the person defending that is Kristen Van Orman,
Oh, that's true. That's true.
and I don't feel comfortable.
Okay.
So what if
We
they
did
came
submit
back,
our
we want to
proposed
give
verdict
Gwyneth,
form there, Your Honor, we did submit our proposed verdict form. So I think that we defer to what we already submitted there for the special verdict
Okay.
form.
All right.
so the confusion, I think, Your Honor, what if they came back and said, we want to give Gwyneth $1 million? All right, we've sort of set them up that they have the power when they don't to order more than $1, and then it just sets us all up for potential problems.
Right. All right, I understand. I will take
Fine.
that under advisement. Number 33, pre-existing conditions. There is a Muji on this, and the court would just follow the Muji.
I think it's an issue for us, Your Honor, of the 2018 Muji or the current Muji. We prefer the 2018 Muji, but
Is that the second? Muji second, the most recent?
I think ours falls more along with the lines of the 18, so not the current, but the previous Muji.
Okay, so it looks like the only thing that they object to, Mr. Owens, is the if any. That's bolded and highlighted on page 18. Is that right?
I don't have the old set. I mean, I would go with the new Muji as the current state of the law, which law I don't like, but it is the state of the law.
Well, would you object to if any on there?
Yeah, there's no if any in Muji 2018, CD 2018. So I'll just follow the Muji on that.
What's my view?
34? I mean, you can certainly make that argument.
I think we've stipulated to 34, Your Honor.
Okay, 34 stipulated. 45, hit and run. I think I've already addressed that.
When we say stipulated, was it a modification?
No.
As modified?
Well, I don't know if it was a modification or not.
The problem was we had agreed to some of these before they actually were filed with James, and we had gone back and forth. And so this was one that was listed as sort of being in disagreement, but we had actually previously stipulated.
So at the top of page 20, that's the defendant's proposed instruction on mitigation, and the plaintiff agrees to it. Okay.
Is that right?
Yes.
Yeah, that's what we
Top of and I should put on the record, Mr. Egan had to leave because we have 4 experts staying at a hotel right now.
Okay.
To prepare for tomorrow.
Okay. Defendant's instruction 45, hit and run. I think I've already covered that. It's been requested and denied for the reasons stated earlier. 46, I've already given the demonstrative.
No, Giovanna, no.
Instruction.
No.
I did give the instruction again, and I verbally inserted the word animation. I suppose I could take and modify the jury instruction that was already given and substitute it for the one that they received at the beginning of the case that contains the word animation.
I think that's fine.
Mr. Owens?
I think I heard you correctly.
Basically take the jury instruction that I gave the jury orally and take the one that was read in the opening on demonstrative exhibits and change and add animations to it so that we can substitute it in their package.
And animations?
Yeah.
Yes, we have other demonstratives that are not animations. but
Right.
I think you covered
And
that.
it won't exclude those. It'll still contain the language in the MUJI of charts and summaries. Chart summaries, including
Geo,
animations.
hopefully.
I think I already covered 47. I think there was an instruction on, there is, in the opening instructions, there's already an instruction on Deer Valley Resort's dismissal.
May I comment on the animations briefly?
Sure.
Your Honor, we had 7 20-second animations. Not all have come in. I wanted them all in. Your Honor ruled that that was duplicative, or I thought maybe that was the word you used, but while we had Eric Christensen on the stand, and then our expert, Dr. Bogger, was not permitted to talk about the animations. So, and I think our witnesses tomorrow, we're not going to be able to probably get the animations in through them. So I think we were prejudiced by this kind of being cut off, having to formally go through every step because the plaintiffs wouldn't agree to anything. And then, so I do feel like the defense was prejudiced in not being able to introduce all of their animations through the expert, or excuse me, through Eric Christensen and our Mr. Bogger today. So I'm just putting that objection on the record. If there's a way for me to mitigate that, I'm happy. I'm all ears to get the animations
See tomorrow.
all in.
Well, I've talked today. It's 1:15 in the morning here. Thanks for being here.
Job.
I would like you to.
They were duplicative. They were becoming, I mean, the 3 were fine, but additional ones were duplicative as to that witness's testimony. And at the pretrial order on all of these animations, I thought laid out what needed to happen in order to get them in.
Okay, I'm just putting that on the record.
Okay.
I think they each added a little bit different viewpoint. They were done by different views, but we can proceed.
Okay. Instruction 48. This is tied in with your your directed verdict motion, so I'm going to leave that in abeyance right now on the post-accident negligence claim.
Thank you, Your Honor.
So I think that covers all of those.
I think it does. Okay. Oh,
That's, yeah.
We inform the court and the parties that we intend to call Dr. Bain via Zoom for his trial testimony. We'd like to get that pre-approved before we go through the great expense and preparation of having him at 9 a.m. on Thursday, the 30th.
As rebuttal.
As rebuttal, 1 hour.
Do you have a sense when you're going to rest your case?
No, but let's look to the time frame.
He has to put all the
I'm going to tell you my latest thoughts, and I can tell you that they change hourly.
No, we've mentioned this many times before, Your Honor.
Let me think for a minute here.
We mentioned it earlier.
Yeah, I know you did.
Hours ago is not.
And my response is the same as it has been for the defendants. When they rest your case, you can put on your rebuttal. So, and I realize that that puts you in a difficult position with an expert that may not be available, and we certainly want to make any accommodation that we can. But as the plaintiffs were entitled to put on their case uninterrupted, except by whatever exceptions you guys agreed on, I think the defense has the same right.
Yes. Good judging.
All right. So as I understand,
That's fair, Your Honor. Thank you.
I'm reading this document and I'm trying to interpret it. This is the court's timekeeping.
Yeah.
Thanks. Because I'm thinking aloud, but I am trying to be responsive to your question. When do you think I'm going to rest? All right. So as I read this, both sides have had roughly the same amount of time, 15 hours. Both sides have about 9 hours total. So 4.5 hours each.
Isn't it more like 8 hours remaining?
Let's see, I'm looking at
5 tomorrow and
40 hours total, and about 30.4 are done.
I think you have to look at it a little differently.
I should.
Yeah, just what's available tomorrow and what's available on Thursday.
Okay.
So it's hopefully we'll get 5.5 hours in front of the jury tomorrow and 2 3/4 hours in front of the jury on Thursday. So that is what you got left to split.
And that is not for closing arguments.
Yeah, it is.
Oh, that includes closing arguments.
Yep. Otherwise, we're giving closing arguments in the afternoon on Thursday.
Yeah, I could agree with that, Your Honor.
I mean, I'm fine. Yeah. Otherwise, that's what we're doing. I mean,
Does
maybe we bleed into the afternoon a little bit if we have unforeseen things pop up, but that would be my hope.
Your Honor, I want to help counsel understand that he may only have 3 hours and 85 or 95 minutes tomorrow or something, 3 hours and 50 minutes tomorrow. Is that how I interpret this? Because it's 7.75 hours left remaining.
Well, I don't know. That's just an estimate. But yes.
So his experts, his case has less than 4 hours.
5.3, 6, 7.5 hours, 7.5 hours, plus 45. That's 8 hours and 15 minutes if everything goes great. That's left to be in front of the jury.
I wonder if the distinction, so this last 45 minutes we agreed not to count toward anyone. Is that
Was that counted against
recognize
anyone?
the 8 versus?
You got that 26 minutes because you didn't say it. Van Norman said that. You
Okay.
didn't agree to it.
And which side was it added? Were they added to?
It was added to defense. It was 26 minutes.
Well, will you give me the new numbers, not including it? In other words, take that out of the defense. Can you give that to me?
Actually, a total of 33 minutes because they went to 507.
Can you give me new numbers and then I'll put them in the spreadsheet? Okay. So that changes that dynamic by 33 minutes.
Now,
Let's do that on
it's
Thursday,
good,
yeah.
by the way, you're keeping us on track. I heard you today say strictly held to this, and then I heard you say earlier, I think, like, in an ideal world. I may have misquoted you. So are we like to the minute on this?
I can just tell you what's happened in the past. In the past, one party has gotten to the end of their case and they haven't used up half the time, and they say, we're done. You know, the other side can use the rest of our time if they need it. I've had that scenario. And then, but I've also had a scenario when they've gotten to the end of their time and they're asking for more time, and it's not on the books where it would be available, and they had to sit down mid-question. I don't want to do that. I mean, and that was an unusual case where, well, I'm not going to go into the details, but I don't want to do that. So a natural stopping point close to the time that you're entitled. So in other words, when you get down to 5 minutes, I'll let you know, and you should wrap it up. And if you go over 30 seconds or a minute, or depending on the questioning that's going on with the witness, or in this case, you'll probably be in your closing arguments, right?
Yeah, under this plan,
I will be
this
giving you
includes
5-minute warning while you're in your closing arguments.
and this includes their rebuttal time.
Yes.
And if we go over, we don't get a closing argument.
Right.
Your Honor, one other question.
I mean, I'm not making a prejudgment here, but if I apply the rule strictly, yes, when half your time is gone, if you haven't given a closing argument or you're not done with your closing argument, theoretically, you'd be cut off at that point. I don't want to have to make that decision, or I don't want to have to cut you off. So I'm hoping that you'll figure it out.
It's nice that we're even talking about like how to do closing argument. That means our trial's coming to a close, which is lovely. One way James Egan and I have split the case up is I've focused on liability and he's focused on damages. Is there any objection if we choose to bifurcate those issues in our closing arguments?
In the past, when I've been asked that, I've allowed it, as long as they do truly bifurcate between damages and liability. And you guys can do that too.
And their rebuttal on closing is also included in their time.
It is.
As much as I whine about this, I actually kind of like it. Can the parties, let's say at the end of the day tomorrow, stipulate that each side can have 30 more minutes?
We'll take that under consideration.
I'm not offering it.
Yeah,
I'm not offering
I'll
it. I may
consider
choose-
it. I'll consider it.
I'm wondering if,
because I want to consider I need to consider the jury, you know, and when they'll start to deliberate. But I'll certainly consider it if you guys do that. I mean, if the evidence closes tomorrow, then you've got 2 hours and 2 3/4 hours to give your closing arguments. Well, maybe I would want to call the jury back at 8:30 so I could read them the closing instructions, and then you would start your closings at 9 o'clock, and you'd each have half of that time to allocate between the plaintiff's argument, the defendant's response, and then any rebuttal.
so I know I'm just telling everyone I want an hour for closing. So I'm just sort of building that in. I think plaintiffs said they wanted an hour for closing. So just kind of knowing that's the thing. And okay, can I give my lineup for tomorrow?
Yes.
So Dr. Black is a radiologist. Dr. Hesch, Hoesch, is a neurologist. Dr. Eastfold is a neuropsychologist. Dr. Ashkenazi is a neuropsychologist.
Potential remaining witnesses, if we get to them, would be Dr. Sanderson, Brad Falchuk, Jenny Sanderson, potentially Gwyneth Paltrow. I think we're going to run out of time. But
Are you going to rest tomorrow, do you think?
so I think it'll depend on the time.
Okay. We'll have to watch it then.
Can I ask
Okay.
hypothetically, Your Honor? If they rest, is it possible for it to go to the jury sooner, or we just?
No, because
it's
we
going
have,
to the jury Thursday.
we'll need to resolve the most directed verdict motions as well as the jury instructions themselves. And we'll need tomorrow evening to do that.
But the jury could be dismissed
Yes.
early tomorrow.
Yeah.
Thursday.
I mean, it could.
You can guarantee we are taking our full day tomorrow. I mean, but I guess I should say never, but in terms of our timings.
So in terms of the court personnel, I need to move on to get to the other instructions. I'm looking at Paltrow's objections to plaintiff's jury instructions, starting on page 4.
Do you have the docket number, Your Honor?
Jesus. So this is all based on time then. This is really tight.
Counsel, do you know your docket?
969.
So we're definitely going to.
And I think the special verdict form is going to be pretty straightforward. I think the plaintiff's special verdict form most closely follows the Muji special verdict form, and I think it's perfect for this case. So I will. I don't think we need to talk about it today, but that's essentially what will be put together. I don't think they don't differ that much. So
May I look at it when the courts printed it out? May I look at it one last time?
Of course.
This is what we're giving, and then
Yeah.
Okay, thank you.
Yeah, you'll have a copy. And I'll read it to the jury as well. So we'll go through it all together before the jury, before you start your closing argument. So 969, did you find that?
We did.
Okay. So page 4, nature of the case is already resolved, stipulated facts. That wasn't really, there hasn't been a stipulation other than the fact that we did today. If you want to put that in jury instruction, we can certainly do that. Otherwise, I've read it to the jury. Fault, we already covered fault.
Your Honor, what was that last one you said?
The stipulated stipulations between counsel, there's only been one stipulated fact, and that was the one done today. So if you want to submit a jury instruction on that one, that witness did not see the accident, I will certainly read that. Page 5, fault defined, we already addressed the fault instruction. Stay in control. I'm trying to remember which instruction that was.
That was the reckless.
Okay. Plaintiff's instructions. This is based on the Summit County ordinance. I'm assuming that if the ordinance is adopted into that other instruction, that covers this one?
This is their version, but I would
Okay.
assume that.
Okay.
Remember, so Christensen was asked about this, Bogger was asked about this, but no one laid the foundation that this is, quote, the law, end quote.
Isn't that what the court does, though?
So
In other words, facts were introduced that could be applied to the law. That's the Summit County ordinance. I don't think a witness has to testify what the law is. In fact, they couldn't.
Legal conclusion.
So mentioned county ordinance.
I thought there was, but I don't know that it's determinative for the reason I just stated.
I think
There's no witness that testifies that as to negligence either. They just testify as to the facts, and the jury decides if it fits negligence.
All right, well, my thought process is if it's not admitted, this is a civil claim, so it's not like a criminal matter where like the definition of homicide is the law. I guess I don't think then we just, why don't we give them the statute on inherent risks? I mean, it seems like someone sort of has to build in that this is the law.
Inherent risk is a immunity statute, not a safety statute.
I understand that's your position.
No, I'm talking, sorry, I was talking to counsel.
Okay. So I've got, I mean, there's extensive argument here by the defendants. I'll consider all of it on this stay in control instruction.
Maybe one more piece of information. So that last Supreme Court case, Donovan versus Sutton,
right?
They specifically did not decide, as I recall it, that
look to the summary at the end. It's where Justice Peterson repeats what the holding is.
Ms. Donovan has failed to persuade us that the facts here implicate Section 316 of the Second Restatement of Torts, even if we were to adopt it. So we leave that question for another day.
Are you looking at the appellate court decision or the Supreme Court?
Thank you for asking me that. Utah Supreme Court, Donovan, last sentence.
Okay.
Of the entire opinion. To the extent that that helps us like not admit into evidence the statutes, I would defer to it.
Okay. Thank you. Then there's an instruction, downhill skiers have the right of way. In response to the objection, Mr. Peterson, I have the objection here.
Your Honor, I think maybe two other witnesses referred to it, including in addition to Bogger, Graff, and Christensen.
Are you on
it meaning?
Are you on instruction on page 14? Downhill skiers have right of way. So the plaintiff is asking for an instruction on page 14 of their proposed instructions. Downhill skiers have right of way. The defendant on page 7 of their objections have listed their objection. So do you have any reply to their objection?
If I gather this correctly, they want to roll or wrap in the skiing safely or staying in control with the downhill skier right of way instruction, and I think we'd prefer that they be separate.
And we object to the Donovan inherent risk part of it.
Yeah.
Okay. Under advisement. Next one. Skier's duty in the event of a collision. I think that's kind of wrapped up in what the court decides on the ordinance.
I think you're right, Your Honor.
And again, this directed verdict tomorrow morning is going to be on that issue.
All right. Court damages we covered on page 9 at the top, and collateral source payments. What's the response to the defendant's objection on the collateral source instruction.
Oh
I
my God, why
realize-
did I have to stay
Is
up
that
and do
a
this?
Muji instruction?
It is
Do we have the Muji?
2024, and you basically follow it in your proposed instruction.
So we just want to stick with the Muji, Your Honor.
Okay, I'll take that under advisement.
I have one sentence on it if you want.
Is it more than you've already done?
That would require me to know what I've already done.
Okay,
But,
go ahead.
Good night, Giovanna. Thank you for staying so long. I hope this finishes quick because I'm
I
so
suspect in
tired.
closing, they're going to say, hey,
Have a good
he incurred
evening.
a lot of
Ta-ra.
economic damages. But we're, out of the kindness of our heart, because he was in the VA system, we're not claiming those. And I don't want them to do that in closing.
Are you going to argue that?
We've been over this a lot. No, we're not planning on arguing that.
It's a pure non-economic damage case.
You essentially made a judicial admission that you're not seeking
We have, Your Honor.
economic
We've
damages. So they
stipulated
could
to
not
it.
make that argument.
Thank you.
Gone over it many times.
Are you still requesting the collateral source instruction even though they're not claiming economic damage?
So we are objecting to collateral source payment objection. Is this correct? They want it and we don't. Yeah. Would we have it? The whole thing is discussing economic damages that aren't being claimed.
You still want to maintain the collateral source instruction, counsel? Plaintiffs?
We'll defer to what, we think the Muji is appropriate. If it is a concern that it's going to be raised, it's been an issue here. We've had VA records all through here, so I don't know.
Yeah, I think it's a useful instruction, Your Honor, in case the defense insinuates that we've got VA coverage and they did in their opening.
I don't recall doing that. I'm not going to do it in closing.
It's the insinuations that and also the assumptions by many people that, insurance or retired military people or VA coverage is out there. So we think it's a useful instruction.
Your Honor, this does remind me my opening. I said he is a vet. He has care through the VA. His VA treating providers assess him neurologically, neuropsychology wise, and they found he's average to above average in every category. None of that deals with like source dollar amounts. There's no reference to that.
And I think also he didn't pay anything.
It's never come up.
Okay, I've got the new totals on time. If you want to jot these onto that spreadsheet I gave you to correct at the end of day 6.
Thank you.
For the plaintiff, it's 15 hours, 19 minutes. For the defendant, it's 14 hours, 50 minutes.
The defense went down?
Yeah.
Yes.
Oh, that's right.
Took away the time for the reading.
Okay. Moving on, demonstrative exhibits. I think we already covered that.
I think you're right.
Special verdict form. I think I just discussed that. I think that covers it all.
I think so, Your Honor. Thank you.
Please. What was left in here? Thank you very much, Rumble. Thank you guys for being with us.
Spoliation.
Yes. Do you prefer that be filed by pleading or emailed to all the parties?
I guess at this point, I have no preference. I mean, whatever way you decide you want to do it.
Hey, Peter,
If you do file it in the court docket, also email it so that it gets to me faster.
yeah, if I may, there was a filing or an email that went out and it had the incorrect email for me, so I never got it. It was from the defense. So, Steve, and if you guys could make sure you have the right email, it's on our pleading, every pleading, because Jackie at Bob's office noticed and said, hey, Lawrence, you didn't get this because they sent it to the wrong email. Just misspelled the first part of my email address.
Do you know who that was? Who sent that?
I can find out.
It came through sometime earlier this morning. I don't know.
Yeah, I haven't done any emails this morning, but yes.
Well, it came through on the last weekend, like Friday or something, and I never knew about it because it didn't come to me.
That would be very irritating. And your correct email
It's on all
address.
the pleadings, every pleading we've ever filed.
Okay, thank you.
It's L. Bueller. Sometimes the small L looks like an I and it goes to my wife, Isabel. So that's why I always try to capitalize the L.
I promise you that was unintentional.
I know it was. I just want to, since we're getting down to the wire here, we need to make sure these things get through.
Mr. Owens, how much time are you requesting for your directed verdict motion in the morning?
Does that count against his time, Your Honor?
We'll come early.
Okay. So it won't. I just wondered if
It's not time in front of the jury, so I haven't been counting time not in front of the jury.
Okay. And
I envision
how we
less than 15 minutes.
Okay, so if we were to start at say 8:15 tomorrow, that would be sufficient for you to make your motion, you to make your counter motion, and hopefully me to rule? Or not
yeah.
counter motion, but your opposition arguments?
Right, but it's hard to make an opposition argument until we get it. So if we get it just before.
It may be oral.
And
what I'll be looking for is for you to marshal the evidence that's come into the case that would support me denying the motion. I'd be looking for you to put in front of me the facts of the case that would give me what I need to grant the motion. In other words, the absence, pointing out the absence of whatever critical evidence that there is. And making a record with those facts. Both of you make it by witness and what they said. That would be helpful.
Okay, this is the directed verdict. I'm sorry, I was missing. What's the directed verdict in a sentence?
You have rested now. Maybe you were gone for part of this meeting, but so I don't think I have to preview it, but because I haven't thought it all out, but I will preview it.
I thought you mentioned it to the judge today or just this evening.
I'm thinking of things every minute.
I know.
But one aspect of it at a minimum will be a directed verdict on post-collision allegation of negligence, which would include this idea of you got to leave your name, you got to fill out paperwork, and that there are no damages. It did not cause any damages, even if true. That's what I'm thinking at the latest moment.
Okay. All right. So, but be prepared for anything on the directed verdict motion. It can be made orally, and he can make whatever motion he wants to make. So be prepared to marshal the evidence to support all of the elements of your client's claim.
Okay.
Anything else for today? Okay. So we'll reconvene tomorrow morning at 8:15 for the motions.
Your Honor, we're just trying to figure out how to do this Zoom. I know you've already spoken about it, but I guess Friday is out because the case will be in closing argument or going to the jury.
Thursday.
Excuse me. It's Thursday. So tomorrow is basically the last time for any of the rebuttal witnesses we might present.
Or as I indicated earlier, I consider asking the jury to come early on Thursday.
something like 8:45 or earlier, because
Earlier.
Just to be fair to council, it would be Dr. Bain to rebut what Dr. Scher said today. And it might be, we think we could do it in 15 minutes, maybe a half an hour. They may want to have another half hour, so maybe 1 hour.
And then you need to figure out the technology to get him here.
Yeah, I think we can do that. We can plug into your media kit.
Okay.
So I'm all for, I don't think we ought to torture ourselves unnecessarily. If the jury's gonna get the case by noon, I don't think it's that important that they get it by 11.
Yeah, if each of you hold yourselves to 1 hour, make that commitment. Does your hour include any rebuttal?
Yeah, we would like a rebuttal, Your Honor.
But does that hour include your rebuttal time?
Well, if we have enough time, we might want a longer one. I'm not as succinct as Bob Sykes.
I guess what I hear Mr. Owen saying is why not just start at 9, let him do the Zoom call at 9.
Yeah, I'm not agreeing to anything, but I don't like this idea of let's get everyone here earlier than 9 if they're going to have plenty of time to deliberate. That is what I'm saying.
What's your witness say, Mr. Bueller? When is he available?
He's got some flexibility on Thursday.
Thursday morning?
Thursday morning hours.
For sure,
He's got a couple
tomorrow
hours.
at 2. That's what we had. But we talked to him about an hour ago, and we think we've got
About tomorrow at 4:30. At 6:30 his time.
I'm not going to be
we can
done.
Find out, but I think Thursday might work early what? We could do it first thing. He's 2 hours ahead, so we could do it at 8:30, 8:45.
Or even 9 o'clock.
Or even 9 o'clock.
We could.
Any other rebuttal witnesses expected?
Well, we had some, but given the new calculations, we might be cutting.
We're going to see how our time is shaking out on tomorrow.
All right.
We're in the mood to cut rather than add.
So it sounds like the defendant will likely rest tomorrow. And if they do, then it sounds like you will have time to do this short Zoom examination on Thursday morning at 9 o'clock. But that's all tentative and depending on what happens tomorrow. So
We'll end up resting tomorrow, Your Honor. I don't.
The other option, which I don't like, but it was raised by one of my co-counsel, we could do another trial deposition.
Right.
And but that we'd have to have a stipulation of defense counsel or an order from you to do that. And right now, I'd move that we get such an order if we're depending on because we know we can get them at 2 tomorrow.
Well, just alert your witness that it might be 9 o'clock or it might be later.
On Thursday, we already agreed to do it once. We're not going to do a second trial deposition on the last day of evidence. We're not agreeing to that.
All right. We'll see you tomorrow at 8:15. Thank you.
Thank you, Your Honor.
Jesus, that was long, but it was very interesting. At least we now know that it's going to be finished. This trial will be finished on Thursday morning. And it'll be in the jury's hand by midday or around midday. So at least we know that. The only interesting thing now is that the defense, well, both sides can argue this would be worthy put in by the judge as instructions that they basically can consider that someone deleted potentially or tampered with the GoPro link. So I imagine the defense are going to really go after that a little bit. And the plaintiff was not happy, but barring something happening again, that's what's happening. So the rest of tomorrow is going to be defense, but there's going to be one more rebuttal. One of the doctors is coming back. I forget which one's coming back. So that's what they were arguing right at the end, the timing of that, and then they got a rest. But they haven't got much time either side now. The judge said if you have to up all your time, you don't get closing arguments. And he said he's going to cut them off basically mid-question if he has to. This is wild, but it is what it is. Thank you, everyone, Rumble. You've been fantastic today, Rumble. Thanks to everyone in YouTube. I know there's only a few left here now, but it's now 10 to 2 in the morning in the UK, and I'm going to be up at 7. So with that, thank you guys for everything. Love you to bits, and see you soon. Take care. Ta-ra.